Open up.
When music meets nature, something unforgettable happens. Symphony by the Water, a world-class live music experience set against the breathtaking beauty of Midmar Dam, featuring the KZN Philharmonic Orchestra, Spogazi, the Black Lapels, Saturday, the 7th of March, 2026. Day tickets from $150, evening tickets from $350. Tickets available at WebTicket and Pick and Pay. Symphony by the Waters, where sound flows.
If you love live music in beautiful spaces, Symphony by the Water is one to diarize. It takes place at Midmar Dam on Saturday, the 7th of March 2026, featuring the KZN Philharmonic Orchestra with an incredible lineup of South African artists. Tickets are available now at Web Tickets, Pick and Pay. Exhibition and stall spaces are available at 600 Rand. And for more info, you can follow at Symphony Waters on Facebook, Instagram and TikTok.
Every day, Randwater's underground pipelines run through servitudes across the country, carrying millions of liters of water to our communities. But when people build too close, it's called encroachment, and it's very dangerous. If a pipeline bursts, it can flood homes, destroy property, and in many cases, people lose their lives. That's why Randwater marks its servitudes with blue and white beacons, a clear warning to stay clear and safe. When we protect Randwater's servitudes, we protect our communities too. Randwater, finding new ways.
This February, love the shows that keep you guessing. Every case tells a story. Every clue brings you closer to the truth. From shocking twists to unforgettable investigations, Homicide returns with seasons 3 and 4, where justice is hard-won and nothing is ever simple. Because loving what you watch sometimes means leaning into the darkness. Homicide seasons 3 and 4, weekdays at 12 p.m. only on S3. Open up. S3.
What's with the camouflage, Doof?
I'm going hunting. It is me, nature, and my most underrated off-roader, a rental car.
Hunting? You could fit that little car in your backpack, Doof.
I sit in the driver's seat, baggage at the back, chairs on the roof. The kudu is going to get in and strap its own seatbelt, Savvy.
Could do with more legroom, Doof. Go hunt for a new 4x4 at WeBuy Cars. They got great deals.
Oh, shot, Savvy.
Don't be doof, be savvy. We buy cars geared for that big trip, geared for you.
The Talking Point with Kathy Motlatlana. Weekdays, 9 a.m. till midday.
"75 years ago, a 40-year-old geologist from Canada called John Williamson stumbled across a very rich diamond mine in Africa, in my own country, as a matter of fact. He was not even properly exploring. He just found people using big diamonds to play a traditional board game. He made friends with the local chief, asked him if he could buy that piece of land where the mine was to stand until today. And the chief sold it to him for very little money and trinkets. Williamson then went to the colonial government and asked for and obtained an exclusive license for mining in that particular area, which was promptly given, but also a law passed to make possession of diamonds by locals a criminal offense. He sent people around the villages to buy that diamond, and they bought again for small money and trinkets. He had built the richest diamond mine in the world within 10 years of getting to that place. What did the people get? The local chief got a modern house, and the people in that area were allowed to use the water from the dams that he had put together for the mine workers, and they were allowed treatment in the clinic. Now fast forward to this day, and you see big headlines like 5 of the world's biggest oil and gas discoveries were made in Africa in 2012. That's very exciting. We are all very excited. My own country made its own very big discoveries. We didn't make them. It's the latter-day John Williamson made the discoveries. Do we know the value? We still don't know. Same like the old chief. At how much did we sell it? Little money and trinkets. Nothing changes in Africa, especially when it comes to the way we lead and the way we are led. I think that we cannot keep making the same mistakes and expecting different outcomes or better results. We need to get our act together. I think it's possible for Africa to rise, but it won't do so until we get organized and we work differently.
Ali Mufuruki, sure. Yeah, what a way to open up the show. He's a prominent Tanzanian entrepreneur, philanthropist, and intellectual there. And what a great challenge that is. The imagery of people playing board games with diamonds, and then later not being allowed to own those diamonds. I mean, just if you think about the full cycle of that, something that you own now becomes something that you're prohibited from inheriting, something that is your inheritance. And no truer words could be said by Ali Mafuruku there. And we have to think about it, especially now, in the context of the critical minerals that are being spoken about, and the role of Africa in the supply of those rare or critical minerals, as it were. Are we going to allow things to continue in the same chain? Or in the same vein, rather? Are we going to allow things to continue in the same vein and allow and watch these raw minerals go out of the country, come back sold to us at a much higher rate than what they were? It's just, so much has been triggered by that opening clip. You're listening to The Talking Point. A very good morning to you. My name is Kathy Mutlatlana, and as always, a pleasure to be in your company as we lead conversations that move us. We're with you right through until midday. Coming up on the show today at 9:30, the Madlanga Commission is back on, and we're expecting that the suspended Major General Richard Shibiri, who is the former head of the SAPS Organized Crime Unit. He's going to be giving evidence, or continuing rather, with the evidence that he started on Wednesday. So far, he has been addressing some of the claims and the allegations leveled against him, including that he had received 80,000 rand from Vusimuzi Cat Matala. But he says that, yes, he received the money, but it was a personal loan, which he used to repair his son's vehicle, right? And he says that that loan has since been repaid. Oh, it's just such a... Let me park it. Let's wait for the evidence to continue so that we can understand more of the picture that is emerging. But the web, the entanglements in that web, I think are absolutely concerning. So before then we get to 9:30, we will start off with the National Round Table. We will be taking your calls on 086 000 2032. That's 086 000 2032. On the WhatsApp voice note line 0614 104 107. And on X, it's SAfmRadio. The hashtag there, SAfm Talking Point. So yesterday we received a call from one of our listeners who complained about some testing stations, some licensing stations and departments in Johannesburg having run out of printing paper, the paper on which they print the license discs. And I think he really was at pains to explain just how far he went to try and get his license disc printed. I think he visited about 3 or 4 licensing centers where they all described the same situation, and having faced a shortage of the official face value paper that is used for the printing. We put it out to the rest of the SAFM community, and many of our listeners also got in touch with us throughout the show and spoke about having experienced the same challenge. Now, we reached out to the National Department of Transport, and they said, no, this is not their baby. We must go back to the province. We went back to the province to ask for an update on the matter. The officials, the provincial department spokesperson, declined to come on air and instead sent us this voice note. This is the voice note that we have been sent as a response to the allegations around the licensing departments running out of the official face value paper which is used to print the license discs. So I want us to play this voice note and then we can get into the rest of the open line.
The Department of Roads and Transport is the sole supplier when it comes to face value documents to municipalities. We supply in bulk and have consistently done so on a weekly basis in volumes. This includes the city of Joburg to ensure continuity of service. The city then has the entire internal responsibility to determine the distribution of the documents to its local DLTCs. Now, we can at this stage confirm that the Xavier DLTC, the one in Maponya, Protea, the DLTC by the Gauteng Management Agency, as well as the one in Sandton are fully functional, and we're encouraging motorists to actually explore those DLTCs for services.
Okay, so there you heard the list that he gave, in as far as where they know for sure you can go and you shouldn't have problems with getting your license disc printed. Unfortunately, Mr. Mpia would not be drawn on some of the details in as far as why it is these other service or licensing departments are experiencing a shortage, and they encouraged us to reach out to the transport department in the city of Johannesburg, which is what we have been doing. Sometimes I've got to, the question I asked my producers when they told me this is, why must we be the one to do the work? Why must we find out for government, with multiple and different entities of government, why something is not functioning the way that it should be? Why does that responsibility fall back on us as members of the public? Because that's what we are. A member of the public has raised an issue. We have taken it to the relevant department, right? So when National says, no, it doesn't fall under us, go to province, we go to province. We get to province, they say, yeah, well, we've supplied, but we don't know what's happening. You go find out from the city of Johannesburg what the issue is. Why must it be that way? If you know what your supply chain systems are, why are you not calling the city of Johannesburg to say, why are you experiencing these issues? You can give us a list of where we can go, where we shouldn't experience problems, but you're not in any position to answer any questions about where we can't go and where there might be issues. It just, to me, is that can't be Batupele. It cannot be that this is a government that puts people first. So now, that must be the producers' jobs. They must go and try and wiggle their way and figure out who in the system is going to be capable of answering this question. So by the time you're done, you've spoken to how many officials? in how many different departments trying to get a simple question answered. Surely this is not the way that things should be. Surely this is not the way that things should be. I believe that we can really, really, really do better than what we are being offered right now. This is not the best of what we can be. So we'll take a quick break and then I'm back with your calls.
When it comes to world-class exhibitions and event solutions, one name leads the way: GL Events South Africa. From concept to completion, we transform ideas into exceptional experiences, delivering seamless events for conferences, exhibitions, business functions, and more. With global expertise and local insight, we provide innovative, sustainable, and turnkey event solutions you can trust. Partner with the industry leader. Partner with GL Events South Africa. Visit gl-events.co.za.
This Human Rights Month, we commemorate a significant milestone, the Bill of Rights at 30, making human dignity real. For 3 decades, South Africa's constitution has been a beacon of equality, freedom, and justice for all. Yet dignity is not just written in our constitution, it must be lived, protected, and upheld every single day. Join SAfm as we unpack the issues that matter, elevate voices driving change, and reflect on the progress we've made while confronting the work that still lies ahead. SAfm, leading the conversations that move us. Hashtag SAfm Talking Point.
I was requested by Mr. Gavin Watson to make a payment for Mr. Smith's daughter to study at Aberystwyth University.
I did not borrow any money from any company. The loan agreement was between me and Angelo Agrizzi. There is correspondence to that effect by way of an SMS. My loan agreement was with Angelo Agrizzi. And the reason why I had this agreement with Angelo Agrizzi in 2015, a few months, I don't know the time frame prior to that, Angelo had come to me to ask, for instance, to help him with an unemployed son. I do this all the time in my constituency. And he came to me and I indeed was able to do that. I in turn also went to him when my own son developed behavioral problems. And he referred me to a service provider who could help him with that. There was some sort of a cordial agreement with me and Angelo.
I'm guilty of loving you. Oh yeah, I'm guilty.
Hashtag SAfm Talking Point.
Yeah, that's certainly a story that should not go under the radar, right? Vincent Smith, former ANC member and also member of parliament, now going to be serving 7 years imprisonment on multiple charges, including charges of corruption. In that plea deal that he's entered into with the state, he admitted that he received kickbacks from Bosasa and the Gauteng High Court handing down that particular matter yesterday. Let me go to Ronald. Ronald, you're in Midrand. Good morning, Ronald.
Good morning, Casey, and
Yes.
the listeners. How are you?
Good.
Yes. No, Casey, I want to talk about this war between USA and Iran, which is also involving Israel. I think this war is now beginning to expose the big boys, the Russia, the China, particularly those who are aligned with the BRICS politics. We seem to have the BRICS committee team that is weak military and is also weak economically, because if you look at the economic scale of things, about the leverage and the benefits we have as a country for being part of BRICS, they are not that loud. It's not something that you can proudly show and say, this, we were here economically, we are here today because we have joined BRICS. Military now, it also shows. All they send is media statements that we denounce the war, we want America to stop the war. They don't do anything. But if a person is a friend to America, they get immediately protected. Now, America does as it wishes. I wish it was during the old days of the World War I. It wouldn't happen the way it is happening now. Now, countries have become selfish. They look at their domestic affairs. They look at what their people want than what the international world want. I think South Africa exposed itself by starting this subtle war with America, particularly with the case against Israel. Now, you can see, if they can take Maduro from a bedroom to America, just like that, and they kill Alatoya Karim, just like that, and you have a base in Lesotho next to South Africa, and you're still poking on America, I think we are playing dangerously there in terms of international relations politics.
Okay, all right, Ronald, I hear you. Yeah, I guess the biggest factor is the predictability factor. The range has just been blown out the box. We're now not dealing with predictability based on pattern or previous responses or historical patterns. But what we're dealing with now is unpredictability. You cannot assume that you know how somebody like Donald Trump is going to respond or react to any situation. And I think that is probably the greatest risk premium that the entire world is dealing with right now. Romeo, you're in KZN. Good morning.
Good morning, and how are you, my sister?
Romeo, I thought we agreed. Just good morning and you get into it. Colin yesterday, he's already raised this issue. I am fine. Everybody's fine. The twins are fine. So feel free. Good morning and straight into it.
It is in our blood in terms of African culture, regardless of whoever did ask you, whether at a platform of public speech or whatever it is, we always greet, regardless of anything that many people have been saying, good morning, good morning.
Yeah, now you've finished a whole minute. Now we're a minute down. So make your point quickly, Romeo.
I needed also to say my first approach on the first question you asked before I hammer on my point that I want to put across to the other listeners. I wanted to say on raw materials that we dash out of the country, of the continent, it is not going to happen soon to stop that up until we get people like Ibrahim Traore. Let me go into my reason why I call. I call because I needed to find out from experts and those who normally make some research in terms of the operations of the United Nations when it comes to 5 permanent members in terms of their veto powers. Does it mean to say when we see
Good morning, Ms. Hassim. Good morning, Mr. Premhead.
Morning, Chair.
Morning, Chair.
Thank you. We are all ears.
Chair, we, before today's witness takes the stand, we have an interlocutory application that has been brought by Mr. Suleiman Karim, and it's for his evidence to be provided in camera. And Mr. Premhead will address the Commission on that application. And I believe there's a preliminary issue that Mr. Premhead would also like to raise with the Commissioners, if we could begin there. Thank you.
I also have a preliminary issue I wish to raise with your preliminary issues, but perhaps let's hear your preliminary.
Thank you, Chair, and for the indulgence of going ahead of you. My learned friend is correct. This is an application that my client's main evidence be given in camera. My concern at the moment is that even though the directive says that it will be given in an open session at the college as we are here today. My concern is that if the in-camera application is argued in front of all and sundry, and I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in the way that we are physically here, but that it would still be determined in camera pending whatever outcome is to be made, as opposed to how we had asked for the reasons canvassed in the in-camera application that it be done virtually or at a different venue and so on. And so I just have to register my concern with all due respect that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or live television proceeding that goes out. And may I just say this, I can understand that if the commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in where the very request for that proceeding itself is to be in camera. Otherwise, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premhead. Mr. Premhead, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Karim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered nugatory. I just don't follow it.
I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the fact that my client, based on what he says in the affidavits, is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted and that he's still giving the evidence, with the effect that the threats are going to materialize again, with all due respect, because it effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Karim, wants the public to be under the impression that he will not be testifying, or what exactly is the point?
That's not the case.
What then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made, and if it was granted, then the public knows that Mr. Karim ought to have testified on the 9th and the 10th, that he might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the
Agreed.
difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these proceedings were in camera, on the 9th and 10th, if the commission is with me and grants the in-camera in substance, then whoever is threatening Mr. Karim and the public at large would be left to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be, insofar as Mr. Karim's appearance at the commission is concerned. That would not release Mr. Karim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected and offer him an interim modicum of protection where he says, I'm being surveilled and I'm being threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Karim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to or at least part of it, boils down to what I said, which is that he does not want the public to know that he will testify.
Yes, but that's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said says exactly what I say.
No,
of the various permutations you gave, part of it says exactly what I say.
I accept that, but we also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes which the public at large would not know about. So it's not as though Mr. Karim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Karim accepts he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me, Chair, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this the preliminary concern now,
no.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you,
yes,
Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Karim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising in the context of that submission.
I accept that, yes.
How will the Commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Karim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And I'm not suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. As you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to... The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah. Oh, sorry.
Sorry, Chair, what I was going to say to you is that we obviously have no difficulty with whatever accommodation has to be made to facilitate the fair trial rights of any other witness who may be impacted by my client. But what we know, and that's foreshadowed with all due respect in Rules 4.2 and 4.3 of the Commission's rules. But what we know in practice from cases like Bryden and Helen Suzman Foundation in particular, which in your previous capacity, Chair, you would be very well familiar with, There are particular circumstances where the disclosure of evidence in a particular context is subjected to a confidentiality regime that appropriately balances the interests in the evidence coming to the court, or in this case, the tribunal, the inquiry as the tribunal forum, so that it can apply its mind to all the evidence and do its job, but also that the court, and here I would say the Commission of Inquiry under those rules that I have quoted, has an equal power to impose a degree of, and I'm hesitant to use the word secrecy regime, I'd rather use confidentiality regime, that protects interests that are implicated if it was just conducted in the ordinary manner, which is the open justice default position. And with all due respect, Chair, in Helen Suzman Foundation, building off the commercial case of Bryden, you were at pains to explain that this is that the kind of regime that Mr. Karim is asking for, including the kind of regime that you would be entitled to impose in terms of the rules for what happens in future, is the appropriate balancing exercise where constitutional rights are implicated. And because my client has claimed that there's a threat to his life, there's a threat to his family, there's a threat to his businesses, there's a threat to his employees, this is the appropriate instance that the Commission, and through you, Chair, must consider its own rules which enable such a balancing exercise, and then your powers to give appropriate directives. Outcome, that's what we would say. Of course, my attorney tells me that there are other witnesses who have been heard in camera Karim's obligation to come here and to tell the Commission what the Commission wants to know and be subjected to questioning by the evidence leaders and the Commissioners. It's about the threat that has been identified and what the Commission does in recognition of that threat and to exercise its powers we would submit it should do to protect him in light of that threat. That's really where we are, Chair. Thank you. I apologize if that was a very long answer.
No, understood.
Thank you, Chair.
Can I? Thank you. Maybe on just that last point, to start there, that other witnesses, including Mr. X, have testified in camera and arrangements were made to protect their evidence. That's not applicable here because all the decisions about witnesses testifying in camera is based on the testimony that they are going to give. You bring a completely different application at this stage.
Yes.
You say the application itself to be heard in camera should be in camera. So yours is not, I mean, those other cases don't apply to you here, one. But you, in your engagement with the chair, you speak to, you want to be heard in camera. There's actually two legs to your application. You want this very application to be in camera because you don't want it to be known why the reasons that he's seeking to be heard in camera. Well, they are out there now.
It's too late now. Yes, absolutely.
And as an aside, I would have thought ordinarily a person would want it to be publicized, that the concerns that your client has, that there are people who are making threats against me, they would want it to, the light to be shown on those who are making the threats on them so that they know the world is watching. I would have thought that's what your client would want to happen. But more importantly for me, you have two parts to this. The second part is you want the papers, including this application. So we are not yet in the merits. This very application that you are before us about and that you are arguing about, you want the papers to be shared only amongst a defined number of people in the commission. You say the chairperson and commissioners, the evidence leader designated to lead Mr. Karim, the commission's appointed legal team, the secretary, Mr. Karim, Mr. Karim's appointed legal team, and the commission's official transcriber. You haven't said why you want to restrict you want the commission to restrict who has access to these papers. And I've tried to read your papers. I don't see a case made for it, including for this leg of the application. I mean, it seems like your client is wanting something that, certainly I've never encountered anything like this, and he doesn't lay a basis why only these 7 or people in these 7 categories should have access even to this, even before you get to his statement on the merits or the application to be heard in camera, just even this preliminary issue. Can you just explain what's going on? I really don't understand this application. And on what legal basis does your client think he's entitled to have to prescribe, as he's doing, about who should have access to his papers? 1. 2, the legal basis for him to seek to be heard in camera, his application to be heard in camera. I've never, ever encountered that, and I don't see a legal basis for it set out in your submissions, but also the factual allegations, if there are any factual allegations here. I don't understand this application, Mr. Kermit.
May I respond? Thank you, Chair. Commissioner Baloy, thank you. May I start with the first question about the prescribing of the access? That is rooted in the understanding of the applicant of Rules 4.2 and 4.3, read with Rule 11, which on our reading, 4.2 says, in an appropriate case, the chairperson may make an order that a hearing be held in camera or via electronic means. In such a case, the chairperson shall specify in the order those persons who shall be permitted to attend the hearing in camera or by some other means. Then with 4.3, at the request of the witness whose evidence is to be heard in camera or mero motu, the chairperson must order that nobody may, directly or indirectly, disclose the identity of the witness who is to give the evidence in camera, and then read with Rule 11, which is the so-called catch-all rule, which gives the chairperson the procedural right to determine issues not otherwise prescribed in the rules.
Yes, what I'm trying to understand is this defined list. I understand the rule. I know what the rule says and the powers that it gives the chairperson. What I want to understand is when your client says only the evidence leader dealing with the matter should have access to this application that we are concerned with right now, on what basis does he assert that kind of
yes.
of request?
Yes.
We have a whole team of evidence leaders.
Yes.
We have investigators.
Yes.
Right? You know that.
Yes.
There is no explanation.
Yes.
Why those should not
yes.
have access to this application.
Yes.
And I can put to you that, at least in my reading of your application, there's nothing confidential
yes.
about it. He's not, your client is not disclosing any confidential matter. The best he does is to suggest that the threats are confidential. That's because that's the only basis on which he's seeking for this first leg to be heard in camera. And all he speaks to is the threats. So he's asking for the threats to be kept confidential. Why can that not be shared with the rest of the staff of the commission? Why shouldn't the staff be aware that there are these threats that are that he's relying upon?
Yes. Let me immediately accept that on the strength of the affidavits as prepared and submitted in front of the commission, there is no direct engagement with why the list curtailed in Schedule A is presented in the way it is presented. I accept that, and I'm not going to dispute that, because that would be a hopeless cause. But I hope that, Commissioner Baloy, you can see that there is a relationship in the exercise that is being done in Schedule A with what is set out in the rules that I've just read to you, in the sense that where in an appropriate case there is an in-camera consideration, the chairperson can make an appropriate directive to limit access as to who can or cannot have access to those proceedings and the papers. So
yes, I'm not having that debate with you.
No,
I know that's what the rules say,
Exactly.
and we have used the rules.
Exactly.
What I'm struggling with, what I don't see,
Yes.
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
Yes.
set out in the
And
papers.
that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Karim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Karim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Karim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Karim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Karim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes? To my question.
It is a yes, but I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, you know, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the commission to the public?
Does it involve breaches of confidentiality?
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Pramit, or what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the commission, it does not include a complaint that the commission has disclosed what he asked to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified. That's not what you're complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
but Mr. Karim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Karim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
intervened twice, my colleague was still asking you. Yes, please go on.
May I respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says. I apologize for that. But Chair, it's very important because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the Commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the Commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the Secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the Commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the Commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me that it's not for Mr. Karim to determine, but we need some clarity from the Commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the Commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the Commission are unconscionable, and with all due respect I speak subject to the chair putting me back in order if I'm out of order, is that the Commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Karim acting of his own accord. It was Mr. Karim at every stage saying to the Commission, place this in front of the Commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came and went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats. But there's a factual context that's important to bear in mind as well, and that is that Mr. Karim sought the assistance of the Commission to let him know what to do by the 27th.
You say you hear what I say about what you referred to as threats, and yet you proceeded to say what the Commission did is unconscionable. I take strong exception to
I'll withdraw that statement,
that
Chair.
kind of language.
I'll withdraw that statement.
Thank you, thank you. What you've said raises two issues. What
Yes,
you
Chair,
have said, what you have submitted raises two issues. The first one is, you asked the Commission to keep all documents, affidavits and all relating to this matter confidential. The first issue is, I have no idea why Mr. Karim would not have wanted to file his statement if in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline, yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
Chair, I don't know if you want me to respond, or
yes,
those were
you're
your
free to.
concluding
yes.
remarks?
No. You're free to respond.
No, thank you, Chair. I appreciate that. Yes. On the first issue about not be kept confidential, I'm not going to rehearse what I said. All I'm going to point out, Chair, is the first time that that was given unequivocally, that the main statement would not be disclosed prior to the determination of the in-camera, was only finally clarified on the 3rd when the directive came out. That was on the facts after the statement fell due.
Just on that, why right from the beginning, instead of tying the filing of that statement to the hearing of the interlocutory application, why did the applicant in the first place not make the simple request that that statement should be kept confidential?
But with all due respect, we did, and that's addressed, that's in the founding affidavit and the notice of motion, and it's in the covering letter. And that's part of the difficulty we have here, is that we place all of this in front of the Commission, we ask for an expedited decision and an outcome, and instead of being told or being told by the Commission, yes, your concern about the main statement is taken care of, it will be held in confidentiality until such time that the in-camera is determined, we don't hear anything. The first time that the Commission puts up an answer is on the 24th, and incidentally, it doesn't deal with the request regarding the in-camera. If the Commission was able to give that undertaking by the 24th when it filed the answering affidavit, then we wouldn't be having this debate, because by the 27th, my client would have filed the statement.
All 15 pages of it, yes.
Yes, absolutely. Whether it's 15 pages, 3 pages,
I know,
100 pages.
I'm just, yeah.
Whatever the case might be, he would have been able to file because the undertaking would have been given. The only time that my client then was given the assurance is when the 3rd comes down, the 3rd directive comes down. And look at what happens. When the directive comes on the 3rd, and the directive says, you must file your statement by the 4th, and you must file it by 9 o'clock, and it will be kept confidential, the statement is filed, no difficulty. So with all due respect, it's a bit unfortunate that my client finds himself in this position in circumstances where he's not in control of these things, and a concern is raised for determination that affects the filing of the statement but is being dealt with in the way that I've just explained. So that's on the first issue regarding the main statement. The second issue, Chair, which I've now forgotten because I've written a note here that says deadline, but I have no idea what that means.
I think I've forgotten also, but probably...
As long as you forgot, Chair, that's fine. That's okay for me.
Probably it was that. But the bottom line is that the deadline was never changed.
Yes.
Whatever may have been going on in Mr. Karim's mind, the bottom line is that the deadline was never changed.
But that's it. But you see, that's, with all due respect, it's that catch-22 dilemma that my client is caught in.
Do you know what judges usually say? They say that when counsel says, with all due respect, deep down inside they're saying, what the hell?
Chair, I've never been accused of using such soft language in my entire life, so I'll take that. I'll take that.
Mr. Karim, you wanted me to reformulate my question, to re-put it to you. I thought you had answered my question, but then you went on to muddy it with the threats and the filing of the statement, and all of that was said about it. But I had the first part of your response was, you are not saying that there's been a disclosure of information submitted to the Commission by Mr. Karim, which he had marked to be confidential. You are not saying the Commission has landed that kind of material in the public domain.
Yes, we're not saying that.
Yeah, that's what I wanted to clarify with you. And then my next question, which I may well now ask, it's now out through you, right, in the engagement with the chair, why you want this application to be in camera. We've had many slip-ups like that from legal representatives, where they do seek something and then they are the ones that actually disclose that which they're asking for.
Yep.
Or that they're arguing. So it's now in the public domain, the reason that you want this application to be in camera. is there still any, hasn't the issue become moot? At least this first part. Hasn't the issue become moot and we should just go ahead and hear that part of the application?
Chair, my attorney is whispering something to me. Chair, through you, may I just take the instruction? Thank you. Thank you. Commissioner Baloy, before I forget your second question again, I'll still go back to the chair, but in response to you, Commissioner Baloy, yes. That's exactly why when I started, I said I have to place my concern on record that if we have this debate in the manner that it's happening, the very purpose of the in-camera would be rendered futile. And so when I started my remarks, that's why I needed to record that, because I was caught in a catch-22. Either I sit here silently and look at the three of you and the three of you look at me and I don't say anything, or I have to address what I need to address, but my claim for confidentiality and in camera is then materially prejudiced by that. And it's that very conduct, with due respect, that I'm saying has caused the prejudice that my client complains about in the affidavit itself. I mean, it's that famous Sutherland judgment, BDFM versus SAA, that once confidentiality is lost, it's difficult to get it back. And that's the exact position my client finds himself in. So I accept that it might have been through my own doing, but it was under the cover of recording the concern I had regarding the futility of us proceeding then in the way that we had.
I guess it may become necessary for us to, for completeness, to pronounce on your argument for confidentiality. It may well be, without changing anything, because as you seem to agree, the issue has become moot. We might as well go ahead with this application, but then the chair may have to pronounce on this claim for confidentiality, whether there was a case for it in the first place.
Yes, may I say, Commissioner Baloy, it's like one of those interlocutory disputes that arise in a main proceeding where the determination of the interlocutory then has the unforeseen consequences that it has. And given that as we walked in, we were then subject to live television cameras, that's the catch-22 that I was caught in, but also that my client was caught in. So even though the application is theoretically still in front of you, because as the chair reminds me, we're still only dealing with the preliminary point, I accept the consequences of the arguments that we've just had and we've just made. May I just go back, Chair? The second point that you had made, which we had both conveniently forgotten, but then unfortunately you remembered, about the deadline. I hear everything that the chair says. I would only ask that the chair bear in mind that there was a request for a ruling before that deadline came and went, so that my client would know what to do in circumstances where he says, I'm asserting a right of confidentiality. If I give my statement, that will render my asserted right of confidentiality nugatory. And on the other hand, if I don't give the Commission what they want, I am then liable to coercive force by the Commission in the enforcement of its rules. So yes, the deadline is what it was, but it's not without the prior context of, please tell me what to do before that deadline comes so I know what my position is. Thank you, Chair. May I just check if there's... Oh, I apologize, Commissioner Kumalo.
Mr. Permit, you could have just said, here is my statement, it's ready, please treat it confidentially. There was no need for all that drama. You wanted to consult with your attorney and then we will ask our questions after, so... Yeah.
Thank you very much, Commissioner Kumalo, for the indulgence.
I don't want us to debate the point I made, because I think the preliminary point has become I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Did I get the impression that, but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassan
Yeah,
gets an opportunity
that's where I want to
respond.
go to.
Absolutely.
That's where I want to go to.
Although
Are you accepting you abandoning 2 so that we don't need to debate?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay.
All right.
Thank you, Chair.
Ms. Hassan?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits because, as Commissioner Baloy says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or two of my learned friend's address, we strayed right into the merits. And so part of what's been debated in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say 1 or 2 other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission?
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premier will probably say neither he is instructing attorney nor Mr. Karim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the Commission before they appear before the Commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this Commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the Commission and the status of rulings that are given by the Commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the Commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the Commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the chair's reconsideration of the ruling. which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination. It wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the Commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Mr. Premhid, one last. Yes. Any response, Mr. Prem?
Yes, three very brief ones, if I may. In respect of the first point made by my learned friend about her understanding of the directive, with all due respect, it's not her understanding that matters. It's what the Commission makes of the application and the request for the ruling beforehand. And that's why the ruling was made beforehand. The request for the ruling was made beforehand, so my client wouldn't find himself in the exact position he finds himself in at the moment. On the second point, my learned friend, in fact, actually makes the case for us because her exact words were, it's the determination of this application that would thereafter determine the disclosure of the main statement. And that's exactly why, not only in the correspondence and in the notice of motion, but in the founding affidavit, before that statement was due, the direct application was made at paginated page 12 of the pleadings bundle, paragraph 27, I humbly request that the Commission determine this matter as one of urgency. This is because my witness statement is due on Friday, the 27th of February, 2026. If a determination is not made about my hearing evidence in camera, and with that regarding the witness statement by this date, then my witness statement will be made available to the general public, defeating the purpose of this application. If that was wrong, they filed the answering affidavit on the 24th of February. They could have made the undertaking or given the clarity on the 24th of February that the statement wouldn't be disclosed.
But why would he have thought, and I think that's a point that Ms. Hassim was making, that his statement would be made public before he testified? On what basis does he have that concern to a point where he doesn't abide or comply with a clear directive?
But that's because, as the chairperson foreshadowed, is that my client doesn't have knowledge of the inner workings of the Commission.
It's not about the inner workings. It's about what, you see, what he has done, and I have to deal with this by way of an example. He has made a claim. He's making a claim for confidentiality and for in-camera, based on the threats he has received, but matters that he says are reported in the public domain. He's made references and he's annexed stuff that is in the media. So he's relied on matter that is in the public domain. I'm asking a question like that there is nothing, he knows nothing about the processes of the Commission, as you rightly say. He doesn't know our internal workings, but again, he has nothing from the public space that is a basis for that concern about his statement being made available to the public. He makes it up. He makes it up, and on the basis of that fear that he's making up, he then says, I'm not going to file my statement until you give a ruling because it might go into the public, when there's absolutely no basis whatsoever, no factual basis for him to raise that kind of concern, and therefore not to abide a ruling that says you must file by a certain date. So it's not an answer to say, I guess what I'm doing is I'm saying, how reasonable is this fear about my statement will be disclosed to the public when there's absolutely no factual basis for it?
I accept that, and you've already heard me in my opening remarks that, to the extent that explanation is needed in the affidavit directly, it's not there, and I'm not going to push at that. Instead, what I will say, at the risk of repetition, is that that's the very reason why the ruling was asked for by the 25th, so that he wouldn't be in the position of potential non-compliance, because that clarity, and on the basis that Commissioner Baloy has accepted, he wouldn't know the internal working processes, would be given to him. And so when I was reading from the founding affidavit, and I mentioned the answering affidavit that came on the 24th, that was the day before the ruling was originally sought. And if the Commission in its answering affidavit simply said, we'll give you the confidentiality pending the determination of the in-camera, then that would have cleared the path to file on the 27th. And so those are the facts about what came before the Commission, and we can't, with all due respect in assessing reasonableness, determine the unreasonableness or the alleged unreasonableness of my client's conduct without those important factual features. Can I just say one more thing, Commissioner Baloy, and then I must make my third concluding remark in response to my learned friend, Ms. Hassan. On my client doesn't rely on threats in the public domain. My client relies, and that's what I understood Commissioner Baloy to have said about things in the public domain. If I misunderstood that.
Yeah, no, you misunderstood me.
Okay.
Yes, I wasn't saying he relies on threats in the public, made to him in the public domain.
Then,
I was saying there is nothing in the public domain that finds, that
breach.
Founds,
yes,
yeah, absolutely.
yes.
That's
No,
the point.
then we're ad idem. Then I don't have to say anything further. I understand what you were saying, Commissioner Baloy. Thank you. And then lastly, in respect of the issue of the threats, I think it's also just important to say it out loud and on the record that 2 witnesses that have come before this commission have been killed. One allegedly killed themselves by means of suicide, but did so after there was an attempt on their lives, and the other was apparently killed potentially or allegedly in relation to what they may not or may not have done here. And all I would say in conclusion, in reminding the Commission of that, is that your job and mandate is about serious issues that go to the heart of the criminal justice system and potential abuse of political connections, criminal connections, and political power, which threatens a huge many deal of interests of people. And where witnesses are dying after coming to the Commission and giving evidence, it's surely not unreasonable in those circumstances that my client uses whatever procedural remedies are available to him to try and get relief from this Commission to protect him in some way to make sure he's not subject to the same kind of treatment which is evidenced in his founding affidavit. Thank you, Chair.
Mr. Premier, I don't want to leave it uncorrected that the person who committed suicide testified before this commission. That person was never a witness before this commission.
I apologize.
So I don't want it to be left that way in the public.
I apologize.
Because factually,
I spoke then subject to being told the incorrect thing. I apologize then. And I withdraw that to the extent I need to.
That actually deals with part of my preliminary point.
Mr. Premier, you're going to go into the merits, and maybe just you'll deal with this in the merits. I don't want you to deal with it now, so I can either, in advance of you arguing it, just tell you what my concern is, and then you will deal with it when you argue, and then we can raise questions as you go along. If you look at prayer 3 and 4 of your notice of motion, read with your Schedule A, the effect of it is that the Commission's investigation team must not have access to these documents. The Commission's head of security must not hear this evidence, must not have access to these documents. Now, that is problematic because that is the work of the Commission. There is no way you can have a prayer. And our researchers, there's no way you can have a prayer that says the very evidence that's going to be led, your investigator must not hear or know about it. Because their job is to investigate everything that is presented and provide the Commission with facts. So the prayers are problematic, and I will just give you an example with prayer 3. We have, for example, a Mr. Brown Mokgotsi still coming to finish his evidence. If your client, either in his statement or in his evidence, says something that implicates Mr. Mokgotsi or that Mr. Mokgotsi would like to respond to. Mr. Mokgotsi and his representatives must have access to that in the same way that your client had access to the evidence of Mr. Mokgotsi. And you would have said it's prejudicial to your client if they were not given the evidence and the statement. So it has to work both ways. If your client mentions any person and gives evidence against them, they would be entitled to that. So you cannot have a situation where all papers exchanged in relation to your client's evidence are not disclosed. It cannot just be this open-ended. And then you've had me on the commission staff, especially, on matters of security, for example. The commission's head of security, and I won't go into detail because those are sensitive matters.
And internal processes which we're not aware of, absolutely.
To assess what security arrangements
Sure.
have to be made, he needs to have access to all of this. So you cannot say he must not have access, because how else does he do his job? Do you follow me?
Yeah, no, I do.
Yeah.
Chair,
I'm sorry. Commissioner Kumalo said that that's for when you address the merits, and that think about it and deal with it when you address the merits. I think we've reached do you were to...
That's why I was looking to you to give me direction whether it's now time to address the merits or not.
No. Let's adjourn for 5 or so minutes, give or take. We'll indicate when we are ready. So we are not strictly saying 5 minutes. It may be more. Let's adjourn.
Thank you.
This February, fall in love with food that tells a story. From bold new culinary stars to untamed destinations and unforgettable flavors. Gordon Ramsay brings passion, pressure, and purpose to your screen. Gordon Ramsay's Future Food Stars, Wednesdays 6 p.m. only on S3. Open up.
When music meets nature, something unforgettable happens. Symphony by the Water, a world-class live music experience set against the breathtaking beauty of Midmar Dam, featuring the KZN Philharmonic Orchestra, Spogazi, the Black Lapels, Saturday, the 7th of March, 2026. Day tickets from 150, evening tickets from 350. Tickets available at WebTicket and Pick and Pay. Symphony by the Waters, where sound flows.
Exciting news. Capitec to make paying your TV license simple, affordable, and accessible. If you're a Capitec client, sign into the app and click on Transact. Next, select Pay Bills, then click Pay At and enter your reference number to complete your payment. It's as easy as that. You'll receive instant SMS confirmation. Now you can keep your stories alive and your screens shining bright. TV licenses, pay yours, make a difference.
Osuthu are on a mission for a place in the semi-finals, while the believers are confident they'll secure their ticket to the last four. In another sizzling encounter, Babinanuku are ready to sing their song of victory, but the Stallions are courageous to cause a major upset. This is the doubleheader of the Nedbank Cup quarterfinals, where pride beats ambition. Catch Amazulu FC versus Casrick Stars this Saturday, 7 March at 2:30 p.m. live on SABC1. Then, Skuguna United face Milford FC at 5:30 p.m. Both matches are available on SABC Plus. Also, tune in to SABC radio stations at 3 p.m. and 6 p.m. Proudly brought to you by SABC Sport.
For the love of the
Clientele is here to safeguard you and your family with compassion because life happens. Be part of a family that truly cares. Our funeral dignity plans have helped South Africans bury their loved ones with dignity for more than 30 years. Let us help you create a meaningful tribute that honors your life and those of your loved ones. We pay out within 24 hours and you will get double accident cover with a clientele funeral plan. Our plans are affordable. Pick the option that suits your needs. Easy to apply, no medical examinations and no paperwork. SMS SAFM to 48031. That's 48031. Clientele Life is an authorized FSP and licensed life insurer. T's and C's online. Standard rates apply.
This February, fall in love with food that tells a story. From bold new culinary stars to untamed destinations and unforgettable flavors. Gordon Ramsay passion, pressure, and purpose to your screen. Gordon Ramsay Uncharted, Sundays 5 p.m. Only on S3. Open up.
This Human Rights Month, we commemorate a significant milestone, the Bill of Rights at 30, making human dignity real. For 3 decades, South Africa's constitution has been a beacon of equality, freedom, and justice for all. Yet dignity is not just written in our constitution, it must be lived, protected, and upheld every single day. Join SAFM as we unpack the issues that matter, elevate voices driving change, and reflect on the progress we've made while confronting the work that still lies ahead. SAFM, leading the conversations that move us.
As you sit in traffic reflecting on a good day, projects on track, clients happy, and they're a big one too. They trust you with all their sensitive data that's kept in your outdated work laptop, in your car, as you sit in traffic. Don't let bad tech choices get in the way. Switch to tailored secure cloud solutions because nothing should stop your business. Call 084 1234. Cell C.
Saturday afternoons in Mzansi, where loyalty is tested every single week. Manchester United fans still believing. Liverpool fans reminding you about history. Chelsea fans saying trust the process. City fans pretending this is all normal. Arsenal fans still shouting out, we are winning it this year. Every year, mate. But that's love. Through the wins, the heartbreak, the long rebuilds. The English Premier League, where we suffer together, celebrate together, and never stop believing. EPL, Saturdays at 4:30 p.m. on S3. Open up.
Neighbor to neighbor, show me this one is for you. If you didn't replace your SASSA Gold card before, your 10 is coming. From around April, you can replace it with the Postbank Black Card. It's simple. Bring your ID and visit a Postbank replacement site near you. For general questions, call Postbank Customer Care on 0800 53 54 55. To find active replacement sites, dial *120 *355#. Postbank will never ask for your PIN. Terms and conditions apply.
#SAFM Talking Point.
All right, you're listening to the Talking Point, 10 to 11 o'clock. Quite a dramatic start to the Madlanga Commission this morning. Quite a passionate session that we have heard so far, especially with the application being made by Advocate Camille Premid on behalf of his client, who is Suleiman Karim. He's applying for this matter to be heard in camera, and as you have heard, it has not gone as he anticipated. That's just one portion of the application that he has put before the commission. More is going to be heard this morning following this short adjournment that they are on. So what we'll do, we'll take a couple of the WhatsApp voice notes that you have been sending through, and then we'll be back live to the commission.
Good morning, Siskati. Mbongo Sondisa Mbuyisa. Hey, Siskati, I'm so disappointed in Vincent Smith. I really admired that guy. He was my role model, very intelligent in parliament. I give up. All politicians are the same.
Good morning, Siskati. Louis from the Western Cape.
So Mr. Matlala is a loan shark who happened to get tenders from the government so that he can give loans to the high-ranking officials, police officials. Kumnandi, ne? But here's another thing. There's only evidence of him giving them loans, but there's no evidence of them paying back the money. Yeah, ne?
Morning, Sis Kathy and the listeners. Just this morning, I was telling my colleague that 8 o'clock I went to the
My
testing
direction
center here in Cape
is
Town.
to refuse that application will be heard here in open session. Reasons will be given on Monday. Brief written reasons. Let us take the tea adjournment. We'll resume at 11:05. Let's adjourn.
Chair.
So there you have it then. The application effectively dismissed, right? If I heard that right, the commissioner has refused it. So that means that the application has been dismissed. So, yeah, an exciting morning of arguments and back and forth. How did Commissioner Kumalo put it? He described it as drama. He said, why so much drama? This is a simple matter. There's no need for this drama. So I guess that puts an end to the drama. The application for evidence to be heard in camera has seemingly been refused. And yeah, so the commission then will continue with its business at 11 o'clock. Okay, so let's hear from you in terms of some of the voice notes you've been sending through to the show.
Morning, Sis Kathy and the listeners. Just this morning, I was telling my colleague that 8 o'clock I went to the testing center here in Cape Town, and they opened at exactly 8 o'clock because that's the time to open. And by 8:30, 8:20 in fact, I was out of that office with my license disc. It's sad to hear that in Pretoria and Cape Gauteng, it's difficult to do the same. And I can tell you there was zero hassles from my experience. Got in, get out, nice service, polite service, and an appreciative service. How difficult can it be for Gauteng to follow suit? I thank you. This is Molefe Cape Town.
Morning, Sis Keith. Sis Keith, I think what will work best for our public servant is that they be based on a commission based, like they get remunerated based on the work and then the effort that they put towards their job, because these people are so arrogant. Sis Keith. You get there, they'll tell you no, the system is offline. Or even you get there, you queue there, they don't even attend to you. Then later when you find out, when you try to ask what's happening, no, the system is offline. No, we have run out of 1212. But they never initiate to tell the people, okay, listen, people, this is the problem that we are facing, and then maybe this is the measures we are trying to come up with to resolve the matter. So if these people can be based on commission based, that will work best. Thank you.
Good morning, Sis Kitty. John is here. Sis Kitty, I think Mr. Suleiman Karim's counsel is just wasting a lot of time, because you can't say the commission should not have an access to the transcripts, the record, the commission's investigation. That is not possible. I'm not familiar with law, but that one is not doable. It's just wasting your time. Thank you very much, Sis Kitty.
Transportation. Good morning, Kev. My concern is on this other bus service called the Great North and Limpopo. They once disappear. with pensions, with people's money. And then now they are back. We are not sure whether if the people got their money or not. And the worst part, they are back. They are not new. They are not road wealthy, and people are allowing it to operate. Can you make a follow-up on this company, but especially in Mopani?
How's Kathy? KKG go share with currents. I mean, arrest Vincent Smith. For now, I know it's a drop in an ocean, but for now, it just shows determination. Ramaphosa anang leona to keep Bohodu in our country. If you can check the monies that SIU have been recovering, even from the State Capture Commission, and they're still recovering even today. You can tell that this man is serious to stop crime. It's just that the than it looks. Thank you. Have a lovely day.
Hello, Ziggy Randberg pointing out that our ad hoc committee of parliament is adding insult to injury by vindictively harassing our private investigators who had to step in to protect South Africa from its crime intelligence corruptors all the way up to the Minister of Police. And now this crime investigator, private investigator, and his young woman helper are being harassed vindictively to tier level at a parliamentary ad hoc committee. Shame on them.
Hello, good morning, Kathy. Kathy, look, I would say I'm a bit not sharp that Vincent only got 7 years for this. And also, if the justice system is working for everybody in South Africa, Mandashi, Nomvula Mkonyana, Kize, all that were implicated in the Pusasa diary collection as such, they are supposed to be wearing orange overalls. And I would be pleased if they could also, the justice system could also follow on them in terms of this. It's 500 in the Israel.
Morning, Kathy. Morning, SAfm listeners. Kathy, I'm happy with the ruling of the judge now on the matter of Mr. Karim. I mean, Mr. Karim is alleging that there are threats against him towards his life, but he wants to do submit this evidence in camera. I mean, if already there are threats, irrespective of whether it's on camera or not, if those people want to kill him, they'll kill him. So what difference will it make? So it's as well as for him to talk and then he get protection, then we know who killed him. We know it's not a good thing, but at least he'll get protection. Z from the front.
Thank you. Hi, good morning. How's Kathy? I just want to concur with the previous caller. Look, I'm originally from Limpopo, but I can tell you that the services in Cape Town, it's something else. It's like you are in a different country. Sometimes you ask yourself, is this really South Africa? Because South Africa is not known for service delivery. Bob, Cape Town.
The Rockets are fired up and ready to blast their way into the semi-finals. But Spears are prepared to sweat every minute for a win to leave Giants in tears.
This is the Nedbank Cup quarterfinal. Kiona Yaruna.
Cax TS Galaxy versus Jackson Spears FC. This Sunday, 8 March at 2:30 p.m. Live on SABC Plus and SABC One. Then on SABC radio stations at 3 p.m. Proudly brought to you by SABC Sport.
Get Spar Super Savings at every store, in every aisle, every day. Like 3 kg Sunlight Hand Wash Powder for $79.99 plus 200 megs free data on Spa Mobile or 50ml Nivea Roll-On Deodorant. Buy any two for $44 plus 100 megs free data on Spa Mobile. Now that's super savings. Prices valid from the 23rd of February till 8th March while stocks last. Only at Spa. T's and C's apply.
There's a bold new rhythm on SABC2, and it starts Monday, 9 February, weekdays at 3:30 p.m. A new vodcast, Our Space, fires up conversation with young perspectives. At 4:30 p.m., a new talk show, Ain't Like Let's Connect, hosted by Penny Lebiane and Fran Rico. At 7:30 p.m., Deal or No Deal, now on a new time slot, Raising the Tension with Katlego Mabuwe. At 9 p.m., the new telenovela Pimville, starring Gilma Balane and Tapelo Mokoena, brings bold Soweto stories to life. From 23 February at 7 p.m., settle in for new drama Paradise, starring Losha Cooper, Ilse Klink, and Zayn Mias. This is the new era of SABC2. Live in every beat, the pulse of SA. SABC2.
You can become a victim of a legal problem, wrongful arrest, assault, uncontested divorce, rental disputes, maintenance matters, or labor problems. It can happen to you. Clientele Legal provides tough professional lawyers for an affordable monthly premium. Our legal team is standing by to assist you 24 hours a day. Join today. SMS SAFM to 32195. That's SAFM to 32195. Clientele General is an authorized FSP and licensed non-life insurer. T's and C's online. Standard rates apply.
This February, fall in love with food that tells a story. From bold new culinary stars to untamed destinations and unforgettable flavors. Gordon Ramsay brings passion, pressure, and purpose to your screen. Gordon Ramsay Uncharted, Sundays 5 p.m. Only on S3. Open up.
The safety and well-being of learners is a shared social responsibility. Parents and guardians play a critical role in ensuring safe, reliable, and lawful scholar transport. Parents are therefore urged to take responsibility for the following. Parents must actively educate and reinforce acceptable learner conduct while the scholar transport vehicle is stationary or in motion. This includes the proper use of seatbelts, remaining seated at all times, and never sitting on the floor, steps, or in the boot of the vehicle. By working together, parents, operators, and authorities can protect learners and build a culture of safety on our roads. Issued by the National Department of Transport.
Exciting news, South Africa. SABC TV Licenses has partnered with Capitec to make paying your TV license simple, affordable, and accessible. If you're a Capitec client, sign into the app and click on Transact. Next, select Pay Bills, then click Pay At and enter your reference number to complete your payment. It's as easy as that. You'll receive instant SMS confirmation. Now you can keep your stories alive and your screens shining bright. TV licenses, pay yours, make a difference.
Get Spar super savings at every store, in every aisle, every day. Like 80-gram Cadbury chocolate slabs, excluding bubbly. Buy any two for 34, save 14 Rand. Or 2-liter Coca-Cola regular only. Buy two for 45, save 11 Rand. Now that's super savings. Prices valid from the 23rd of February till 8 March, while stocks last. Only at Spar. T's and C's apply.
This February, fall in love with the shows that bring us together on Saturday nights. First, sparks, surprises, and second chances at romance. Farmer Wants a Wife US, where real love grows in the most unexpected places. Saturday at 8:30 p.m. And before the love story begins, the stage lights up with pure talent and big league dreams. America's Got Talent Fantasy League. The world's best acts battling for the ultimate bragging rights. Saturday at 7:30 p.m. 2 shows, one unforgettable Saturday. Only on S3. Open up.
When music meets nature, something unforgettable happens. Symphony by the Water, a world-class live music experience set against the breathtaking beauty of Midmar Dam, featuring the KZN Philharmonic Orchestra, Spogazi, the Black Lapels, Saturday, the 7th of March, 2026. Day tickets from 150, evening tickets from 350. Tickets available at WebTicket and Pick and Pay. Symphony by the Waters, where sound flows.
On the top stories, Karim wants his testimony heard in camera in the Madlanga Commission, and disaster management teams on high alert in KZN. For SAFM News, I am Ondelambana, and a very good morning. Northwest businessman Suleiman Karim's legal counsel has brought an application before the Madlanga Commission to have his testimony heard in camera. Advocate Kamil Premid has argued that Karim has been subjected to death threats. Karim, who has been implicated at the Madlanga Commission by alleged political middleman and Northwest businessman Bran Mokhodzi, was set to appear before the Commission next Monday and Tuesday. Advocate Premid has argued that Karim will be prejudiced if his testimony is heard in a public session.
If this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so, with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested.
The trial of 4 men accused of kidnapping and brutally killing a 6-year-old Buntle Mashiane in 2019 resumes in the High Court sitting in Bombela, Mpumalanga today. Buntle's mutilated body was found near her home in Mganjungweni near Hazy View after she went missing. 5 people were arrested, including a neighbor and a Sangoma. The neighbor Ndombinkai Sengwenya, her boyfriend Colleen Hlongwane, and their friend Tapelongomane were arrested, as well as a traditional healer Samuel Zela and his son Pilasande. In 2023, the lower court provisionally withdrew charges against Zela, and 4 months later he was allegedly killed by members of the community. Western Cape police are investigating a fire at the Nyanga taxi rank on the Cape Flats, in which 9 vehicles were destroyed in the early hours of this morning. Authorities say preliminary reports indicate that 5 Quantum and 4 Iveco Sprinters were destroyed in the blaze. Police spokesperson FC Van Veek says the cause of the fire is yet to be determined.
An inquiry was registered for investigation and no injuries was reported. All patrol vehicles were sensitized to patrol all taxi routes and ranks. Anyone with information about this incident is kindly requested to contact Crime Stop on 08600 10111.
Disaster management teams in KwaZulu-Natal have been placed on high alert today after the South African Weather Services issued a level 4 weather warning for severe thunderstorms. The storms are expected to impact large parts of the province. The warning indicates that a cold front and a ridge of high pressure will trigger widespread showers and thunderstorms. COCTA spokesperson Sanzelo Mzila says areas at high risk include eThekwini, Newcastle, Ladysmith, Port Shepstone and Pietermaritzburg.
Disaster management teams on high alert. This follows a level 4 weather warning issued by the Weather Service, which indicates that severe thunderstorms with rain could affect large parts of the province tomorrow, the 6th of March. These teams that have been dispatched by MEC Buthelezi will ensure that communities continue to be safeguarded. These teams will monitor areas that are low-lying and areas that are prone to weather-related incidents. The MEC has urged communities to be vigilant and to ensure that they do not cross low-lying bridges, as these pose a serious risk.
An Australian coroner court has ruled that a teenage backpacker whose body was found on a beach in January drowned as a result of an Indigo attack. A Canadian Piper James body was discovered on the island of Karim along the coast of Queensland. The BBC's Katie Watson.
19-year-old Piper James had been travelling around Australia with a friend when they decided to spend some time living and working on Karim, the world's largest sand island known for its beautiful beaches, freshwater lakes, as well as a local dingo population. Piper James had been working in a local campsite in January when she decided to go for an early morning swim. A while later, her body was found surrounded by 10 dingoes. 8 of the animals have since been euthanised. A spokesman for the Coroner's Court of Queensland said Piper James had died as a result of drowning and had multiple injuries from dingo bites.
Recapping the top story, Northwest Business.
Davids. We do have thick skins, but if we must call something to order, I think we should. Subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Karim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said, yes. Open quote, it would be concerning in the extreme if it were willing, that is the commission, to gamble with my life or my family's life to see whether the commission's, underline this, kill rate would result in a, again, underline, hat trick, close quote. I read this to mean that the commission has killed, underline the commission, has killed 2 people, and that Mr. Karim will be the 3rd person it kills if the commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Karim have that the commission has killed 2 people?
Chair, may I say that I hear what the commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the Commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the Commission's, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the Commission killed anybody, but that the Commission has experienced, in Mr. Karim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the Commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the Commission if that indeed caused the offences both being gratuitous and sensationalist.
Thank you for the withdrawal and also the apology. Right at the end, in my notes on engaging with you, I was actually going to call for an apology for this. But let me conclude the debate on this aspect, subject to whatever response you may have, by saying that, yes, earlier, as you indicate, there is reference to incidents. But commission's kill rate, that cannot mean anything other than that is the rate at which the commission is killing. The commission's kill rate. You cannot, I just do not see how one can seek to change that. And that kill rate, or the rate at which the commission is killing, is going to result in a hat trick. That is Mr. Karim being the third person the commission kills. That is my reading of this, and I found it quite offensive, but you've apologized. It is the commission's kill rate. It's nobody else's kill rate. It is the commission's kill rate.
Chair, without repeating myself on the apology and the withdrawal, I would just say that I respectfully disagree with you, because I think that's a very narrow reading of that phrase in isolation, not only from the rest of the sentence, but also the founding affidavit. So if the commission can look at paginated page 11 of that same bundle, please, in the founding affidavit at paragraph 18, at the top of the page, I'm reading...
Page 11.
Paginated page 11, yes please, Chair, 1-1. On my side, it's paragraph 18 at the top in the founding affidavit. I don't know if it's the same on the commission side. I'm getting indications it is. He explains what he talks about, where he says one of the witnesses that appeared before the commission was killed, and there was an attempted assassination on another witness who shortly took his own life. And he goes on to say, I am compelled to take these threats seriously. With all due respect, even if the commission and if the chair interprets that phrase to mean what the chair says it does, why I disagree is because at no stage has Mr. Karim ever used words to that effect to say it's the commission who's doing the killing. It's the commission's kill rate in the way in which the chair is putting it to me, as opposed to what we are saying, or what rather the witness is saying, regarding the experiences of what has happened. But I understand that the chair has a different interpretation.
I just don't see how paragraph 18 assists you, because it just refers to killings. Those may well be the killings of the commission, hence the commission's kill rate. But anyway, so I don't see how paragraph 18 assists you at all.
Well,
perhaps we should not waste any.
No, I was going to say, I think that's where we part company, Chair. Yes, but I must reiterate for the record both my apology and the withdrawal there.
Thank you.
On that interpretation that is put to me.
Thank you. Then let's go to the answering affidavit at page 45. Paragraph reply, I'm very sorry. Yes, the replying affidavit. Paragraph 66, it reads, instead, it is clear that the Commission or only Mr. Popkas has opposed the application for an ulterior purpose and out of vindictiveness. I assume that the reference to an ulterior purpose is what? Inferential reasoning, perhaps? I assume so.
Well, I'm in front of you, so I will bear responsibility for this replying affidavit, and I'll answer you.
Actually, before you apologize, one of the things I had noted down here with regard to what we've dealt with already was who settled this affidavit. Was it you, the attorneys? Obviously, it could not have been Mr. Premhead himself, but I think you basically want to suggest that you settled it or not.
No, I am, regardless of who settled it.
But we are past that. You've retracted, you've apologized.
No, it's more than that. It's more than that, and this is important for the public watching to understand, is regardless of who said what and who settled what, I am the advocate in front of you, I am the appointed leader, and I take full responsibility for anything that causes the Commission offense or upset. And as I've said, I apologized and withdrew in respect of the 9.1, I think it was. If that's what the Commission wants of me in respect of 6.6, I will do the same thing. All I would point out is in that paragraph, the second sentence tries to lay out a justification for that particular reason. It cites paragraph 5.1 of the Commission's answering affidavit. Now, I accept in 6.6, there's not an detailed exposition to justify the first sentence, but at the very least, the deponent is telling you what they are identifying as the basis for the first sentence. But as, again, I think with all due respect, I'm not going to defend the so-called indefensible. I will take responsibility for it, and I apologize to the Commission and the commissioners, and I withdraw as is needed.
All right, thank you. Perhaps let's leave it there. And why I introduced this by saying, is this reasoning by inference? I was then going to take you to what the test for inferential reasoning is, and then I would have also asked you, has that been satisfied for Mr. Karim to say that this is being done or averred for ulterior purposes?
Yes.
But perhaps let's leave it where. Yes.
May I just say, on the on that particular averment in the paragraph, insofar as the determination of the issues in front of you is concerned, that is actually not a central issue, to the extent that it's been called out and
I would have thought so
yes,
too.
Exactly.
So it's, that too, in a sense, is quite gratuitous.
No.
Thank you.
But that's why I'm accepting your logic, and I'm
yes.
saying to you, I fully accept what you say to me, and I give the tenders as needed.
Thank you. Let's go to your 30 minutes then.
Yes.
What's the time now?
I'm familiar with that 30-minute of grace before the barrage of questioning starts. So is Mr. Kumalo. He argued a few days before me when I was there for Pala Pala. But, Chair, may I say this? I think that...
I'll give you until 13 minutes to 12. You may start.
Chair, I was going to say that in light of what has occurred for most of the morning, we had prepared a note on argument, which I was going to have regard to, but I think that has largely been overtaken. Instead, I intended to structure my submissions to you in the following ways, if I may. I'm going to deal with 4 topics very briefly. Firstly, is I'm going to address why we're here. Secondly, I'm going to address the questions put to me by Commissioner Kumalo. Thirdly, I'm going to refer you to some cases on what I think are trite propositions in scenarios like this. Lastly, I'm just going to make some comments about prejudice. So, at the outset, and we've already debated 4.2 and 4.3 in the morning, the simple proposition is this: it's not the evidence itself, and Commissioner Baloy actually identified that there's a distinguishing feature about this application and how it was brought and when it was brought in respect of other applications, and I adopt that analysis because that's the very point that I want to start with. It's that it's not the actual evidence that my client gives which brings us here, but rather the fact that merely by appearing here on the 6th of February as a confirmed witness who was then granted a postponement and which gave rise to the 4 or 5 threats that we've attached to the 2 affidavits, which don't only threaten my client individually, but also threaten his family, that threaten the burning down of his businesses, that threaten them if they even leave where they were originally located, it wouldn't matter, because where they would potentially be moving to would also be known. And I'm trying to use language so as to not give away geolocations. Those are the serious threats that bring us here. So the reason for the in-camera then is, and I say this with all due respect, the reason for the in-camera is the threat to the life of the witness, his family, his businesses, and his economic interests. And that is not contingent on our reading of the rules of the actual evidence to be given in chief by that witness themselves, because nothing in the rules makes the application for an in-camera hearing contingent on that evidence in and of itself. I'm willing to accept for the sake of debate that it might be a factor that the Commission takes into consideration in deciding whether or not there should be an in-camera hearing or there shouldn't be an in-camera hearing. But what I will say in that regard is that that factor is but one factor in the basket of factors. And what else is in those basket of factors, in other words, in addition to the evidence that he's going to give, is the existence of those threats, the way in which he has treated it seriously, and reported it to the police because of the seriousness involved. And I must say this, the Commission, in response via the answering affidavit, starts out the answering affidavit with saying, I have some sympathy for Mr. Karim, but, and then goes on to say why the in-camera should be refused. And with all due respect, those reasons as to why it should be refused are reasons that we in fact rely upon in order to justify the in-camera. So those reasons that are relied upon by the Commission are inter alia the following. The first thing the Commission says is that the applicant has already been the subject of national media coverage, that his identity, appearance, and scheduled testimony are already in the public domain, and therefore the consequence of that public knowledge is that, well, an in-camera hearing is going to be pointless because everybody knows. But the truth of the matter is that if the in-camera relief is granted, then everybody will not know. Yes, they would have known what the arrangement was for Mr. Karim to give testimony in an open session was, but they won't know what actually occurred thereafter if he doesn't give testimony in the way, in an alternative way, if the in-camera application is granted. So, with all due respect, the Commission's position that this has already been in the public eye is the very reason that we come to the Commission, because you will know we say that these threats have started emerging even before he's given the evidence. So it means that the people who are threatening my client don't know what he's going to say, but they are so aggrieved potentially by whatever it is he's going to say, that they're already making the initiative to threaten him, his family, his businesses, and his employees, as well as his economic interests in the way that it does. The second thing that the Commission says is that, and it's a line of argument that is rooted in open justice principles, and indeed in the morning, I think it was potentially the Chair and Commissioner Baloy who put it to me when they said, I thought, or used words to the effect that I thought he would want to come and give this evidence in open so that that everybody knows what's going on. But with all due respect, that argument again makes the case that we are applying for, and that is that this publicity, without the threateners even knowing what it is he has to say, are already threatening him. If he comes here, it's almost like waving, and that is not made subject to an in-camera ruling, it would almost be like waving a red flag at a bull and waiting to see whether or not the bull charges and gores you, and effectively to take your life into your own hands. And the reason I say that, and mindful of what the Chair has already said regarding those particular paragraphs and the replying and the supplementary affidavit, is that the Commission itself does not say these are fictitious, these are non-credible, these are made up. They seem to accept, at least at the surface level, that these threats are real. And so the question then becomes for the Commission, bearing in mind, and the Commission and the Commissioners, bearing in mind that you have an applicant in front of you who says, I am scared, I am fearful. Does the Commission and the Commissioners turn a blind eye to that in circumstances where no one has suggested that those threats aren't real, aren't credible, aren't serious, and don't deserve to be taken as seriously? So that's point number one about why we're here. We're here because of the fact of the threat, and any opposition mounted on the content of the main witness statement, I would submit, is firstly misplaced, but secondly, to the extent it's not misplaced, it's but one factor in the basket of factors under your consideration. The second topic I want to talk to is the question put to me by Commissioner Khumalo. Commissioner Khumalo, you took me to the Schedule A, and you had indicated that the schedule was problematic because it excluded certain people and, was perhaps too restrictive in terms of the people that it did include. And you mentioned particular individuals like the head of the security, the investigation team, the researchers, and all these categories of people. I'm willing to accept that this might be too constrained, and the reason I can readily accept that is because we simply don't know who the relevant people are in the operation of the Commission behind the scenes. Likewise, for example, in trying to get the application in front of you, we don't know how long it took when the Commission's attorneys received it to put it in front of the commissioners, whether it was placed in front of you before the 25th of February, whether the correspondence bundle, like we asked to be placed in front of you, was placed in front of you. We don't know all of these things. And the reason I highlight that...
They're in the website, Mr. Freeman.
I beg your pardon?
They are in the Commission's website. Please continue, Mr. President.
Be that as it may, it can be on the Commission's website, it can be stapled outside the Commission's premises. The point of the matter that I'm making, Commissioner Khumalo, is that parties often ask courts for relief all the time based on what they understand the position to be. And sometimes a court will say to them, as you will well know, yes, you've made out a case, but this operative part of your relief is a bit too narrow or a bit too broad, and we need to include these people and we don't need to include those people, or whatever the case is. So, with all due respect, if it's a question of the schedule, we can amend the schedule. Or if it's a question of the Commission making a directive regarding who should be included and who shouldn't be included if the Commission is with me, then that satisfies the issue with all due respect. Because like I said in the debate in the morning, and I think it was with the chair, is that these requests have always been subject to the chair making the appropriate ruling, either accepting and granting the application, or dismissing the application, or granting it but subjecting it to different grounds on the relief, or anything of that kind. So I think with all due respect, it's a little bit difficult for me to answer the way in which the question was put at me in circumstances where it's being positioned potentially that Mr. Karim is dictating these things. It's Mr. Karim saying to the Commission, I'm asking you for these things based on what I know at the time that I know it, and I lay myself in the Commission's hands as to make the ultimate determination. So if the accuracy of the schedule is incorrect, we wear that. And we wear that not because we want to keep some people out or some people, we simply don't know. And that's why we come to the Commission and ask for the relief that we do. May I go on to my third topic? And I think, Chair, I'll be done with my protected time relatively soon. May I just take an instruction? Yes, and I'm just being pointed out that the particular paragraphs that Commissioner Khumalo had difficulty with was 3 and 4. I think what I've just addressed is the difficulty with paragraph 4. Regarding the difficulty with paragraph 3, I just would point out that it's not the main statement that was subject to the in-camera, it's the in connection therewith defined as being in the in-camera application. And I mean, even if the drafting is not clear enough to make that clear, let me make this clear now on the record. That must obviously be the case, because if the in-camera application that we're arguing now is unsuccessful, then the normal rules apply. But if the in-camera application that we are arguing now is successful, that would be subject to whatever the Commission and the Chair ultimately grants as the relief. And again, I understand that the concern against me might be what it is. I don't think that the idea has ever been that the main statement must be kept away from the relevant Commission staff. It must be kept away from it being an open publication, or as effective as an open publication. That's the contention in the in-camera. And in regard to the Brown-Mokhotsi example that Commissioner Khumalo raised, apart from saying that I don't know whether Mr. Mokhotsi applied for an in-camera hearing or an in-camera hearing and how that would impact fair trial rights, like I said in the morning, part of the Commission's imposition of an in-camera regime would make accommodations, as it must, for these kinds of issues to be ironed out. So that, like we know, for example, in high court proceedings and in all court proceedings, where there is a confidential affidavit filed, sometimes what the court says is it seals that part of the record, and the parties are given a full opportunity to engage each other on the contents of that confidential affidavit. It's just that those exchanges of affidavits are subject to a confidentiality regime. And we don't ask for anything more than that. And in fact, we ask the Commission, if such an in-camera regime is going to be upheld in these circumstances, that that's the kind of consideration that is applied. May I say then, on the third topic that I had, which was about the cases that I wanted to deal with, I think these are fairly trite propositions that I'm making from the cases that I've cited. I've given my learned friend notice of those cases and the paragraphs that I'm going to rely on. So I'm not going to ambush her very deliberately. But my learned friend raises her eyebrows at me. But these cases, we say, put forward two propositions. The one proposition is that the state has a positive duty towards citizens to protect them where there is a concern about their rights. That is derived from cases like Carmichael, Carmichael, I apologize, I always say Carmichael. Carmichael, at paragraphs 44 and 45, and the court will be familiar with Carmichael. And then the other case that we rely upon is the SCA case of Van Devenboden, which the commissioners will also be familiar with, and the paragraphs there are 20, 21, and 22. Now, why that's relevant, of course, is because we say that on the facts of this case, there is a threat to the right to life, security, integrity, family, commercial interests of the witness. This is a body that exercises public power in the name of the state, and so this commission is caught by the same obligations that the state has to make sure that where issues of safety are raised, that it properly applies its mind and discharges its power in accordance with that. The other two cases, sorry, I said 4 cases, there's 6 in total, and I'll come to the other 2 shortly. The other 2 cases that I want to refer to is the Constitutional Court matter of independent newspapers, otherwise I think commonly referred to as Masetla, at least that's how I know it. And the paragraphs there, the relevant paragraphs there are 42, 43, 44, 45, 58, 59, 60, and 61. And the other case that I would refer to whilst I'm talking about Masetla is the SABC versus NDPP case that came before the Con Court. And I think that was, I speak subject to correction, but I think that might have been in the context of Van Breda and whether or not his criminal trial could be subject to publication. And the paragraphs we rely on there are 28, 29, 30, and 31. And what those cases make abundantly clear is that courts in those contexts, we say courts, it applies as equally as against this inquiry as a tribunal, must engage in a balancing exercise where default positions of openness, which is what the default rules of this commission envisage, conflict with competing and contesting rights. And where those competing and contesting rights are put before the court, and this relates to what I was saying earlier about one factor in the basket of factors, the court will seriously apply its mind to circumstances where it treats openness by default not as an absolute principle, that there are justifiable circumstances where it will derogate from openness as the default principle, and that those require then the application of this balancing act. And we say that some of those factors that need to be included in the balancing act are those cases, are the instances where my client comes to the commission and under oath tells you about the threats that he's facing to life, limb, property, and family. The other two cases, if I may, whilst I'm machining through this list, is MIDI television. I apologize. I think MIDI television was Van Breda. I said SABC versus NDPP was about Van Breda. But MIDI television, which the tribunal will be familiar with at paragraphs 19, 20, and 21, and the other older constitutional court case of Mamabolo, which, if I'm not mistaken, was written by Justice Crickler, and the relevant paragraphs that we rely on there are 41, 42, and 43. And what we say those two cases give rise to, again in the context of discussing the openness by default principle, is that firstly, no single interest, this is from Mamabolo, no single interest overrides others. So yes, just because this commission might have an interest in an open justice style of argument, that justice must be seen to be done, does not mean that that is judged in isolation from competing interests where security of the person is concerned and so on. The second proposition that these cases give rise to, which is from the MIDI television case, is that the restrictions on publication are permissible where it's demonstrable that there is substantial risk to justice or to other constitutional interests. And we say that we fall into that category. We fall into the category that there is substantial risk to constitutional interests, and that's why the in-camera application in the way that it is brought before you is entirely justified. Chair, on the last topic, if I may, the topic of prejudice, I did address some of this prejudice in the morning at the so-called prejudice being at the hands of the commission, and I'm not going to repeat myself there. Instead, all I'm going to say, Chair, and you will recognize this not only from having deposed to the answering affidavit in the unsuccessful urgent application, but also when we were in front of you in the postponement application, that my client's complaint throughout his involvement in this commission's proceedings is one about consistency, fairness, and procedural and substantive rights. Rightfully or wrongfully, that's his view, that he is being treated in a way that is prejudicial by the commission, and in fact, what is happening is rather than the commission seeking to cooperate with him and his reasonable requests, like, for example, receiving the proper 10-6 notice, like, for example, receiving the bundle in good time, like, for example, receiving an undertaking regarding the confidentiality of the statement in good time, like, for example, that an expedited application which is sought to be determined before a deadline is approaching is placed before the commission, doesn't seem to happen. Those are the head notes, if I can use that phrase, of what my client claims as his ongoing prejudice in these proceedings. And I mention that prejudice because it's regrettable that we find ourselves in this position. Unfortunately, the way in which my client seems to be treated is in an adversarial manner rather than what we understand a role of a commission of inquiry to be, as being an inquisitorial manner. And unfortunately, the way in which things have unfolded in front of this commission have meant that, I apologize, someone is trying to phone me again. The difficulty that my client has is that rather than reasonably being accommodated so that he can come to the commission and give the evidence and do his inverted commas job and get out of the commission as soon as that job is done, instead we get tied up in these kinds of procedural skirmishes where at the end of the day, like for example on the issue of the bundle, which was the subject of the postponement application, the bundle eventually was given. A specific bundle was eventually given the night before we were expected to appear for the first time. And why I highlight that prejudice in the context of this ongoing dispute we have in front of you is that in the absence of any credible basis to say that these threats are not real and not serious, we would say, and I say this in a guarded manner, that it's heavy-handed of the Commission, with all due respect, to oppose the application on the basis that, it's already been publicized or whatever else it is they say. Because at the end of the day, if the in-camera application is granted, this commission will still be able to do its job. And it's important to say that because the in-camera application at various times is treated as though it's an act of gamesmanship, which it isn't. It's a legitimate request under the Commission's rules for protection from the Commission regarding the giving of that evidence so that my client can do what my client needs to do because this Commission has asked him to do it. All we would say is that when this Commission brings my client in front of it to give such evidence, that it does so in a manner that is suitably sensitive to the threats that he faces and gives appropriate relief to protect him in light of those threats. Might I take an instruction? Just whilst, before I yield the floor, so to speak, just one thing that we are aware of. Obviously, whilst we sit here, we expect the Commission's supplementary bundle, which we anticipate to be given today, because it's 2 business days later after the filing of the statement. We hope that that will be done, because that will again help my client come and do his job, rather than end up in another procedural skirmish about whether or not there's been adequate time or inadequate time. But Chair, those are my remarks in my protected time, and I yield. Thank you.
Thank you, Mr. Premhid. Just on the last point, Ms. Hassim, I assume that if that bundle is not ready, you will move mountains for it to be served today.
The bundle will be provided today.
Thank you. Thank you. Mr. Premhid, you, quite early on, you made maybe let me start right at the end. I'm not sure that I follow your submission on the relevance of what you referred to as head notes on prejudice to the determination of the in-camera application. I'm not sure what the relevance of those head notes is exactly. You did explain it, but I still remain in the dark as to what you suggest the relevance is.
May I respond? Thank you, Chair. No, I accept what you say to me. What I am using those particular examples of is, in each instance of those examples, my client has asked for a reasonable accommodation, which has been refused. The response to that has then been that my client has to, through its legal representatives, litigate quite aggressively, whether in court or in front of the Commission, with interlocutory applications, to have that reasonable request, firstly, reasonably considered and then decided. And I was linking that pattern of conduct to the opposition that is being put up here, and I explicitly detailed those grounds of opposition, the publicity, the fact that it's already known, but importantly, there's no counter-argument as to the credibility of the threats, that in those circumstances, the Commission insisting that my client be made to give the evidence in an open session where those threats are highlighted for determination is a further instance of the prejudice that my client finds himself in. That's the extent I was using it.
I trust, though, that the suggestion is not that the in-camera application will not be decided on its merits.
No, not at all. I know for a fact it will be decided on its merits.
I just wanted to be sure in my mind what exactly you mean by that.
In fact, Chair, if I may, I think the way you've put it to me crystallizes the exact point. It's that in each of those instances that I've spoken about, my client, to use your phrase, has had to move mountains to try and clarify his position and get certainty and outcome. And this in-camera application is yet another example of that, in circumstances where my client not only said on the 18th, a week before, he asked for an outcome by the 25th, bearing in mind that the 27th was the due date. He also said, just determine this on the papers expeditiously, so we don't have to take up the Commission's time and I know what I need to do. So I fully agree with you, Chair. It must be decided on the merits, but the fact that we've had to repeatedly move mountains to get that determination, and even in circumstances when we ask for an earlier ruling, is the exact prejudice that my client relies upon. Thank you, Chair. I'm indebted.
Thank you. Now, let me take you to something you said quite early on, which is, and I hope I will not mischaracterize what you said. You said that applications for in-camera hearings, or rather this application for an in-camera hearing does not hinge on the evidence Mr. Karim is going to give. Even though I cannot think of ready examples, I'm willing to accept that that may be so in some applications. But what exactly do you say is the basis for your submission in this particular application? I'm asking that in this context. Not every and any witness that has testified before us has received threats. And those that have either received threats or had a reasonable basis to believe that their lives were at risk, even if they had not received threats, gave us cogent reasons for us to understand why there would have been threats and why there would have been a reasonable belief that there was a risk of bodily harm or even a risk of them being killed. Something cogent was placed before us. Please bear in mind that here, I'm not talking about just the fact of threats. I'm talking about what underlies the threats that we are told about. That's where my focus is. Now, on what basis would Mr. Karim, I know the threats don't come from him, and he says in so many words in his affidavit that he does not know where the threats come from. But if he sits down and applies his mind in the light of the testimony that he's going to give, who does he think may possibly be threatening him? He is best placed to think about that and possibly to even come up with answers to that. Bear in mind that I say in all without exception, all the other cases where applications for in-camera hearings have been made, we were given something cogent, which had a factual foundation.
Thank you, Chair. May I respond? Chair, on the first point, where you said, you put to me the not hinge proposition, and you said it may be so, just to emphasize that our position is that based on the Commission's rules, that doesn't seem to be the case to us. But let's leave what the rules may say or not say to one side for the moment. The not hinge proposition comes from the fact, like I just read back to you in Mamabolo, it's a weighing up exercise. And so
I'm not there yet. I am not at Mama Bulo in that weighing up exercise, because you raised the weighing up exercise in the context of open justice. So I'm not there yet. I'm just at the level of possible facts, the possible basis for threats.
I'll come to that last.
That's where I am.
I'll come to that
don't
last.
quite see how the Mama Bulo balancing exercise, the open justice principle,
Yes.
I just don't see
May I
how,
develop the submission?
how the relevance of that is to what I'm raising.
May I develop the submission?
Yes,
And I will come to those very point about the facts that you put to me. I'm sorry if I'm taking the circuitous route. The reason that I start at Mama Bolo is because it speaks to the court's discretion in weighing up issues in front of it when there is a counter consideration to the default position of open justice. So insofar as where I anchor my submission, that it's not exclusively contingent on the content of the main witness statement, is derived from the Mama Bolo principle, buttressed by the MIDI television principle that talks about we derogate or we depart from open justice when there are credible threats and so on. So I'm willing to accept.
I'm exactly at the credible threats.
Yes, I'm coming.
I think that's where we should be before we get to the balancing exercise. Show me the. I'm just asking you a question, and I'm not suggesting that the threats are not credible.
No, and I'm not
All I'm
suggesting
saying
that either.
is, what is the possible grounding? And that will then help us determine the question of the credibility of the existence of the threats. That's where I am.
I accept that.
Yes,
I accept that. But I think what's important is where I started out, because that sets the ground rules with respect as to what discretion the court is being asked, or I apologize, I keep saying court. I look at you, ADCJ Madlanga, and I go back to a different time and different place. But Chair, it's about what discretion this inquiry tribunal is being asked to exercise. And that's why I start with both Mama Bolo and MIDI television, because it says that yes, you consider openness, but you consider all the things on the other side of the T account, if I can use that phrase. Then let's go to the examples that you gave me. This is now the facts and the credibility that you were talking about. Those examples, from my understanding of what you have said, Chair, is that they were all anticipatory explanations for why in-camera hearings should be justified, because if I get your words wrong, Chair, please correct me, but you said something to the effect that those witnesses who asked for in-camera hearings gave cogent reasons for us to understand who would have threatened them or where those threats could have come from, in anticipation of asking for in-camera.
Or even where they would come from. In regard to those witnesses who did not say that there had in fact been threats.
No, so you and I are ad idem on that. And I would say that my client is, with all due respect, in a stronger position than those people. Because what my client says, or does, is he doesn't come to the commission on the basis of reasonable speculation about what threats I might face or where those threats may come from or who may be giving those threats. My client, by contrast, comes to the commission with real threats annexed to the affidavits and says, look at what I'm being subjected to. Now, yes, it might be that my client is being criticized for not doing a further exercise in the way the other witnesses did, in answering the 5 W's and the H, where did it come from, when, who, and all those kinds of things. But look at what my client does. Apart from coming to this commission to ask for the in-camera relief, he goes to the police and says, investigate this, and he lays a criminal complaint on the basis that he has received these threats. So, again, going back to the Mama Bolo MIDI television framework I was talking about, it might be that the failure to address those questions weighs as a factor in the basket of factors against granting the in-camera application. But I would say, with all due respect, imposing that on my client, and doing so in an adverse way in the balancing exercise is contradicted by the factual position that he's in.
I'm still not at the balancing exercise. I'm still at the level of the facts and what would, where, put it this way, who would these threats possibly come from? And I repeat that I'm saying, Mr. Karim is best placed to scratch his head and come up with ideas as to who these threats might come from. And I'm raising this because this is going on the 9th and 10th. This is going to be his testimony and his alone. He knows what he is going to say, against whom, and who therefore might possibly want to threaten him not to say whatever it is he might be minded to say. It's on that basis that I'm raising this.
No,
let me just, I'm not saying I do not believe him. It's very difficult to say that I do not believe him when there is no affidavit that says, Mr. Karim, you are lying. But sitting here, looking at what he says, I want it to make sense to me. And I'm saying part of what would make it make sense to me is possibly who he thinks might threaten him. Do you understand where I'm coming from?
We are at Eden.
And this has nothing to do with the balancing exercise. I'm purely at the factual level.
I mean, I think it does come to the balancing exercise, which is why I started there. However, I understand what you're putting to me, Chair. What you're saying is the sufficiency of the explanation regarding the possible source of those threats is missing from the affidavit. And to the extent that that is missing from the affidavit, that may be something which, if you had, would have made your decision maybe easier, but now that you don't have it, makes it a complication for you in terms of how you apply your mind to the relief sought and the outcome. I understand us as being engaging on that sufficiency explanation, not whether the threats are credible or not credible. I see your microphone is on, Chair.
I know you are good at reading gestures. You would do that at the Constitutional Court all the time, and even address the gestures in your argument. I'm not sure that I want to get there. That is, get there to the extent of saying, I'm 100% saying there's no issue with the credibility. I'm not there yet. I'm actually testing the credibility in wanting to find out who could possibly have threatened Mr. I'm quite mindful that we are dealing with an application that's on affidavit. And, I don't even think we get to plus and evens here because there's nothing countering or seeking to counter. I realize all of that. But it does not mean that we cannot engage at the level of, is this something credible just on its face? That's where I am. And as part of that engagement, I want to know who Mr. Karim thinks may possibly be threatening him.
Well, I can't give evidence from the bar, and I'm not going to give a version on behalf of my client, whatever he might have told me in consultation. I don't know what you're showing me. In consultation. So I now, in front of you, I can't give you that explanation. What I can accept is that that explanation, in the way that the chair is putting it to me, is something that should have been there or might have been preferable if it was there, and I accept that it's not there. And what I am saying to you, Chair, is that even in the absence of those particular averments being made, that does not on its own undermine the credibility of the threats as they are evidenced on the papers. And as you yourself, Chair, have said to me, no one says in response to those threats, unexplained as they may be, Mr. Karim, you are a liar, Mr. Karim, these are invented, Mr. Karim, you're just wasting our time because this is a gimmick from you. So what I'm saying is I'm confronted with the position where the chair says to me, these questions might have been, or these issues, if they were addressed, might have been preferable. They're not addressed in the papers. And I'm saying in that circumstance, it is what it is, and that we can still seek the relief. But I don't know, and I'm speaking without an instruction, but I don't know if these are the inquiries that the Commission is interested in, which again, without rehearsing anything about prejudice, if we weren't treated adversarially, and if we were treated perhaps a bit more reasonably, we could have been advised about or told about. Because remember, we're also making the application on the strength of the Commission's rules, where these kinds of issues, yes, they might be raised by the chair, they might be relevant, but they're not specified in the rules. So my client is again caught between a rock and a hard place, where he looks at the rule, he does what he thinks the rule says.
On that point about if perhaps an indication had been given, would a supplementary affidavit assist?
I was just going to come to that, and I was going to say that's what I was going to say without an instruction.
Yes, Mr. Prem.
I was going to say, Chair, that that's what I was going to come to regarding a without instructions submission, was that given that position and where we are, a supplementary affidavit dealing with these issues pertinently may be relevant for the chair and the panel to consider. But of course, that might have consequences in terms of my learned friend, and obviously mindful of your judicial role, you will say to me, but now you're supplementing after you file the application and you're trying to remedy after the fact. I'm just tendering this as a practical or potential practical solution to the position we find ourselves in, which is if those are the kinds of questions that the commissioners are interested in, then my client should probably file a supplementary affidavit addressing those questions.
The fact that I raised it does not necessarily mean that that will be granted.
No,
it's
absolutely.
something that will be considered.
No.
Yeah.
Absolutely. But that's why I say you might punish me for not having that there at the beginning. So I'm expecting it on both grounds.
I don't think we would be that strict. There's a whole lot of things that apply in court that do not apply here. For example,
I agree, Chair.
The nature of the evidence that we may admit here.
Absolutely,
All
Chair.
right, let me go on. You see, my difficulty, and which is why I'm engaging you on this, is this. The threats from where I'm sitting appear to come out, like a bolt of lightning, as it were. No factual foundation whatsoever. They just proof. But there are threats,
yes,
and there's no explanation on their possible source.
Yes,
we've engaged on that.
Yes,
I'm just explaining why I'm engaging you to the extent I'm engaging.
Yes,
that's just to explain. And they seem to just come out of the air, as it were.
But Chair, that's the exact dilemma my client faces. That these threats do come out of the air. And that they're coming from numbers, and he says under oath.
And something I forgot on the last point I made. There are witnesses who before us were under circumstances that are not comparable at all to Mr. Karim's situation. Not comparable because they were in far more serious situations in terms of the testimony that they were to give and ultimately gave, could possibly expose them to the risk of bodily harm and even death, by far. So on the face of it, simply no comparison from where I'm sitting with Mr. Karim's situation, which makes it difficult from where I'm sitting to understand where on earth these threats could possibly have come from. About 2 weeks or so, we had an IPID investigator who testified openly here. I know that the facts of one case cannot necessarily be used to determine another, but I'm just showing you this to try to make you understand why I have difficulties with threats that appear to come from nowhere in the sense of a proper grounding. That's where I am. That witness testified here, and she told us in graphic terms the risk that she was and continues to be exposed to. And she was brave enough to sit there and testify openly before us. So, as I say, I know at the risk of repetition, I'm saying, for myself, I want to understand who could possibly be threatening Mr. Karim, who is, at least at face value, unless there's some explanation, does not appear to be in a risky situation at all. The risk that we see comes from the unexplained threats. Any response to that?
Yes, thank you, Chair. May I just say that had my client, and I need to speak very carefully because there are things that have been said to me which are not in front of the Commission, and so, but, you know, we're coming pretty close to discussing that, so I just need to give that caveat, if I may. Had my client known, or reasonably known or suspected, one would have imagined him to say these things. And he not only says to you about the unknown numbers and doesn't give an explanation who those potentially might be under oath to the Commission, he gives an equivalent statement to the criminal case where he's opened a criminal complaint and says, this is all the information I have, here's the threats, please investigate because it's threatening me. Now, I don't want to be impertinent, but the police are hopefully not going to turn around to my client and say, no, sorry. We're not going to investigate these threats despite the objective evidence of these threats because you didn't do your own forensic exercise as to who it may be or what.
I don't think the two are comparable. And, but please, yes, okay, let me not gag you.
The point I'm making is that even an imperfect complaint to the police can sustain a criminal investigation. Obviously, we are in a different scenario here, but the point that I'm making is that it's the fact of those threats in the criminal scenario that would trigger a criminal investigation. It's the same facts and of the existence of those threats that are placed before the Commission by the witness who gives the fullest explanation. And the Alice in Wonderland world we're potentially heading towards is that my client will be refused relief on an insufficiency ground potentially, but the same insufficient evidence when placed in front of the criminal case or the police might result in an actual criminal investigation. So the dilemma for my client is that through the engagement with the chair, it's that lack of forensic exercise that he was supposed to do that is now coming back to potentially prejudice any relief that he could seek. But surely the question should be, if he knew who these people were, he'd say it. Because like the Commissioner is putting to me, those would be weighty factors as to whether or not to grant the application. But then how do you expect the witness to engage the hypothetical counterfactual of who it could be in circumstances where on the facts in front of you, they tell you they don't know who it is? And I'm not saying that the Commission is expecting my client to go down the world of speculation, but what must my client speculate about where he says, I don't know these numbers, I don't know what their connection is, and must he invent a potential connection between, and I ask that rhetorically, of course, I'm not saying he must invent, I know that the Commission is not saying that, but I'm putting the proposition, must he invent that connection in order to get relief in front of the Commission? So that's the danger with where we're going down with respect regarding the sufficiency explanation. May I just make two points in response to what the chair has just put at me, and then I will yield again. So that's why, with all due respect, what other witnesses did or didn't do, and whether they were brave enough to sit in an open session or not brave enough to sit in an open position, is actually immaterial. And it's immaterial because I don't understand the position to be that you need to show a quantifiable level of harm to try and trigger this kind of relief from the Commission. It's rather whether if we use interdict language, for example, there's a reasonable apprehension of that kind of harm. And in these circumstances on the facts, what we can't run away from, even with the evidence being as insufficient as it might be, is that the existence of those threats are on the table in front of you, and that grounds the reasonable apprehension, given that those are real threats, to seek the relief in front of you. So I fully accept what the chair says to me, but that's really the difficulty that I'm in, and which is why I will gently mention the supplementary affidavit again, if it should help.
One last point from me. I hope I'm not articulating this out of context. You said something like, the people threatening Mr. Karim do not know what he is going to say. Wasn't that part of the submissions you made? I do not follow the basis of this submission. Is it not more likely that people that would threaten Mr. Karim would be people who have somewhat of an idea of what he may say, and therefore would threaten him exactly because of their belief as to what he may say? So I don't quite follow your submission.
Yes, what I was pointing out was just the factual timetable in which it arose. So it's obvious, well, let me not say it's obvious because stranger things have happened. We assume that Mr. Karim is not just going to be subjected to threats by anybody, right? We can assume for the sake of our engagement that Mr. Karim is going to be subjected to threats by people who potentially know what they think Mr. Karim is going to say or not say, and how that might implicate or impact them. All I was saying in respect of what you put to me, Chair, is that before he then even comes and says whatever he might say, he's the subject of the threat. So why I mention that is because it demonstrates, with all due respect, that whoever these people are, and whoever they may be, and whatever the connection they have to Mr. Karim, direct or indirect as it is, are taking this kind of hostile attitude towards him, this kind of threatening posture towards him, which is a generic threat that's not premised on what you're going to say. It's your participation in the Commission at all is going to result in us coming after you in the way that we're threatening you to do so. So all I'm saying is that let's imagine a world where Mr. Karim comes in front of you and there's someone out there who thinks that he's going to say something about him. But then he comes in front of you, doesn't say anything about them, right? That person then they don't know what he's going to say, but they might be the one who's threatening him even before he says it, before he comes here. So that's the dilemma that my client is faced in, and that's why, Chair, I can adopt what you say to me regarding who these people potentially are, but I'm just emphasizing that the way in which these threats come about in terms of the timing shows how serious they are, that they're making these threats even before he comes here and says anything. So I understand what you say, it's just that I have a slightly different view on that exact same proposition.
Thank you, Mr. Premier.
Thank you, Chair.
Thank you, Chair. Thank you. Mr. Premier, I think the first two things that your client relies on in the affidavit, need to be straightened out. You have withdrawn in your earlier engagement with the chair the references to the death by suicide of Mr. Pretorius. So there's no reliance on that anymore. Am I correct to understand
well, that's the consequence of being corrected and me accepting the correction.
Yes, that's not one of the facts he relies on. The second is the killing of Mr. van der Merwe, witness D, that he relies on in his affidavit. And he annexes, if you want me to refer you to remind you.
Yes, please, Commissioner Baloy.
If you look at the main affidavit, and you go to page 15 of that, it's yes, 15 in the main affidavit, but it is so it's obviously mentioned in the affidavit itself, and then he annexes this, and this is one of the factors that he raises with us as part of his concerns that he may be killed. Can we just perhaps clarify with you that there is nothing, there is no evidence or information in the public domain or before this commission that supports a statement that the witness was killed because he testified here? There's no such evidence. This is still very much a matter of police investigation. Okay, you're not stating it as a fact.
Yes, and I would do no more than look at the headline of page 15, where it says, in an apparent hit of the witness.
Yes.
So my client's position has been that these things are happening.
What things are happening?
Well, the apparent hit is happening, and that's, he relies on that article to say so. He's not attaching evidence that has come in front of you. Or
he's not saying he was killed because he testified.
Yes.
That's not what you're trying to say.
The position taken by my client is that, and I'll direct you, if I may, Commissioner Baloy, back to that paragraph 18, which didn't help me earlier, but I'm hoping is going to help me now, is where he's giving an explanation of what he understands to be happening regarding witnesses. And he's contextualizing that to say, I'm just not willing to take a risk.
Yes.
He's not being definitive. He can't be definitive.
Well, in paragraph 10, he says, it is well established that there has been assassinations and attempted assassinations of witnesses who have appeared before the commission or who are scheduled to appear before the commission to testify, right? And then he attaches those articles.
That we just spoke about,
what I'm putting to you is he makes that statement, but in fact, as a matter of fact, there is nothing that says the witness died because he testified.
Yes, I have no difficulty in accepting that. I have no difficulty in accepting that.
All right. Now, having done that, can we, and in light of your discussion with the chairperson, can we have a look at the documents that you've attached as threats?
Yes.
Because I would like to, firstly, maybe let me foreground it this way. Your client is a businessman, right? That's what he tells us in his affidavit.
Yes.
He's a businessman. Your client tells us in his affidavit, at least in the annexures that we have here, he's a member of the ANC.
Yes.
Okay, so
that's not in doubt.
We've got those facts, right? Now, I look and please assist me to the extent that I may be misreading these annexures. Now, my reading of these annexures, except the last one that we will get to, none of these annexures, the first is at page 14.
I'm there.
There is absolutely no reference to his appearance before the commission.
Yes.
Previous appearance and anticipated appearance, right? Nothing about it makes that connection. Do you accept that?
Subject to the caveat that factually, yes, I accept it, but my submission in respect of this annexure is that the timing of it is suspicious, alternatively convenient, given when it comes. So factually, does it mention the commission? No, it doesn't. But in context, the submission is that it's related, inextricably related, to his appearance here and the evidence here.
When he first appeared.
Yes, yes, that's right.
And this would have been, he would have received it, if he did, he would have received it after the court application.
No, because if you look at the page 14, it says Sunday.
Yes.
And I think the Sunday that's referring to is Sunday the 8th of February.
And the application was issued when?
The application was heard that Tuesday, I think that was the 3rd, and then we were in front of you and the order came out on the 5th, and then we were in front of you on the 6th.
Okay, so the application was in the preceding week before he appeared before us.
It was in the same week. It was heard and determined in the same week.
The chronology I'm trying to clarify is an application was issued.
Yes.
The agent application was issued.
Yes.
And you were heard.
Yes.
Before he came before us.
Yes, 3 days before.
Okay, and so this is issued only after he's appeared before us.
Yes.
And in the court application, he does mention that he's going to be appearing before us, but he doesn't get a threat. In the period between the court application and his appearance before us, there's no threat received.
No, there are none.
Okay. So we've cleared that page 14 doesn't make any reference to his appearance before us, right?
But may I say something in response to that? Isn't that ironic? Because when he is in the urgent application, and the possible outcome of the urgent application is maybe he doesn't have to testify, given what the skirmish was at that moment in time, there is no issue. There is no threat issued. But just thinking about what the commissioner has put to me in the timeline, after he comes here on the 6th, and one of the outcomes from the 6th is the chair's order directing, you will appear on 9th and 10th, not even 2 days later than on the Sunday, the threat is issued.
Yes.
And the threat is then about whatever is happening here, about your life and your house, and even though it doesn't mention the commission, I would just point to the timing, using the exact facts that you have put to me, Commissioner Baloy, is, as I said, either ironic or convenient.
Well, yeah, maybe it is convenient. I think the point that I'm making to you is, well, the first time anyone knows that your client is coming to the commission is not when he appears here. That's a point simple point I'm making, that the first time it is public knowledge that your client is going to appear before the commission is with a court application. That's the simple point I'm making.
Yes.
That's the simple point I'm making, as a matter of fact.
Yes.
Yes. That's all I wanted to accept.
I can give that fact because those are the facts. I can give the answer. What I'm trying to resist is the path we seem to be going down regarding the timing of the threat vis-a-vis the appearance here in front of the commission and the absence of a threat vis-a-vis the application and the inference to be drawn potentially.
No, I'm not at inference stage
well,
yet.
then I have no concern.
I'm not there yet.
Then I have no concern.
I'm at fact establishing stage.
Before we go there, potentially, yes.
Potentially. So we've established page 14 does not make any reference whatsoever. So this threat could, on this page alone, the reason for the threat could be anything. Could be his membership of the ANC, could be his business associations, in any of that, maybe even the commission.
Yes.
But we have no basis on page 14 to link it to the commission.
Yes, well, no explicit basis to do so. But
no basis at all. What I'm suggesting is there's no basis at all.
No, that's where I need to resist that conclusion with all due respect, because by the same token that you put up two other possible explanations, his membership of the ANC and or his business interest, why is the commission and the timing of the commission seemingly discarded, but
no,
two
I've
alternatives
included the commission. I've said to you, it may be the commission,
okay. Well, then,
but I have no basis to say it's one or the other. There are three possible bases from what I've put to you, I've proposed to you. There are three possible bases.
Or more, we don't know.
Absolutely.
Then we're ad idem, thank you.
And then A2 we've agreed it says nothing about, it doesn't help anything, right?
That was the
Because-
attempted assassination.
Yeah, no, this is the death, in fact, of witness D, him being shot.
The one at page 15.
15, yes.
Yes, the apparent hit. Sorry.
Okay, so this has nothing to do with being a reason, providing a reason for your client to fear appearing before us.
Well, you've heard me on that already, and I've tried to read that in context for you, having regard to the other paragraphs in the affidavit where he gives an explanation regarding how he sees these things happening, which animate his fears. So, factually, I accept your correction of the record like I did earlier with Commissioner Kumalo, but with all due respect, I don't think that detracts from the underlying point, which is that even if he's misunderstood the correct facts regarding what happened in respect of this witness, that is nonetheless something that animates the fear, which triggers the in-camera, and that takes us to a reasonableness assessment. But
yes.
So I think we're at idem.
It's up to us to look at these that he's referring to, finally, to determine whether that fear is reasonable or not.
Yes.
So it's not for him to simply say,
yes,
I'm animated, I'm concerned because of this, and that's it. Then we must make a decision that favors him.
No, of course.
We have to assess the reasonableness of his fear, and we can only assess it on the basis of what he's relying on. Right?
Yes,
For
I
the
accept that.
86. Okay.
May I just say that, and I speak subject to correction, but the answering affidavit doesn't make these points about what could have animated my client's fears and says, oh, well, you know, you talked about two witnesses, but actually this is the correct factual position. And so in as much as obviously the commission needs to correct the record where there are mistakes and apply its mind to the issues as they are, the point that I would make is that the commission fails to correct that animation regarding the fear. And
but what are you saying? Okay, now that you're saying this, what are you saying we should do with that? Just because the commission doesn't deal with it in the way that you say they haven't, are you saying it's not within our powers to determine on the basis of what he has placed before us? Because maybe let me suggest this to you. As I see it, is even if they had chosen, the evidence leaders had chosen not to answer, we still have to determine your application on the basis of the case you made.
Absolutely.
Yes.
But
so it's irrelevant. It must be relevant for purpose of my engagement with you. It's relevant for purpose of you replying to Ms. Hassim, but for purpose of my engagement with you, it's irrelevant that they didn't say what you're raising now. What's relevant is your answer to what I'm raising with you.
Yes, and may I just say that I have no difficulty regarding the proposition you put to me regarding what you need to do. Absolutely, I'm not disagreeing with that. All I'm highlighting is that even his mistaken approach regarding what animates his fear is not rebutted by the commission as a mistaken basis to animate the fear.
Okay.
So,
Mr. President, we have a few times said the evidence leaders are wrong in what they have said. So it doesn't take the matter any further for you to say, well, they are not saying it. As I say, you'll reply to her if she tries to make that point.
But I'm sorry, I think we're speaking slightly past each other, Commissioner, with all due respect. I'm not taking a pleading point in the sense that, oh, the answering affidavit doesn't put up a rebutting version, therefore on Plascon Evans. As the chair rightfully said, there are rules that apply in a court proceeding which do not apply in these proceedings.
Yes.
All I am saying, insofar as your assessment of reasonableness is concerned and what animates the fear, is that even if he was mistaken at the outset when the application was launched, the commission, who is in possession of the true facts and the full facts in a way that we are not necessarily in possession of, could have said under oath, here's some facts that you need to think about regarding animating your fear. And I'm not making the pleading point. What I'm saying is that may have reasonably or not reasonably adjusted my client's position regarding the in-camera. And so all I'm saying is that where the commission itself doesn't put up a version to disabuse
But
my client.
What version could they possibly put up, Mr. Prime Minister?
Exactly the version you put to me now, Commissioner
I'm not putting
Baloy.
no, what version have I put to you?
You put to me, sorry, maybe I shouldn't call it version, maybe I should say you put two facts to me. It's even stronger than a version. One was about the witness D or F or X.
Mr. Pretorius, that he died of suicide.
Yes,
he
and
was
then-
not a
and then
witness
there was-
before us.
And then there was the other.
And you're saying the commission should have said that in their answering affidavit?
Well, if they did say that in the answering affidavit, that would have given us basis for pause. And it would have invited my client to respond to that and maybe then explain why he's nonetheless afraid to come and give open evidence. Or evidence in an open session.
When your client or when a deponent makes allegation in an affidavit and they say these are factual allegations on which I rely, such as Mr. Pretorius, he died, he was a witness and he came to testify and subsequently he was killed. Where does he get it from? It's for him to justify that statement. It didn't have to take, there's no requirement that the opponent should have said, but that's not what happened, so that he can formulate his next response or next position. Your client asserts, the deponent asserts as a fact, and the chair sought to engage you.
Yes.
Where do these facts, the stuff that is alleging,
Yes.
where does he get it from?
Yes.
It's not open to you, at least from where I sit. It's not open to you to say, well, the evidence leaders should have told us that he was never a witness, when it is your client who says he was a witness and he was killed because he was a witness.
Yes, I think where there's a potential, where we're potentially speaking past each other, is that I accept what you say regarding the affidavit, the contents, the accuracy, and whatever the case may be. All I'm saying is that in response to that and putting the facts to me in the way that you have should nonetheless not result in my client not enjoying a consideration of all the other factors that he puts up.
Oh, and that's if that's what you're saying,
Yes,
you don't even need to say
yes,
it, of course.
Well,
his application will be considered on its merit.
Then we're ad idem.
Okay. All right, let me continue the exercise that I was doing with you. The next annexure is A3. A3 is a continuation of that witness D, Mr. van der Merwe's killing.
Are you at page 20?
Yeah.
Oh, sorry, 22. I see 22.
It's at 22. I just want confirmation. It's a continuation, right?
Yes, it's another article regarding
that same story that we have now discussed.
Yeah.
Okay. And then the next one is at page 24. Okay.
I apologize. Yes, Commissioner?
All right. It's at page 24.
I'm with you.
All right. It starts off with tell your every driver at. Okay. And then it says tell your every driver at that fight has started. And we will make sure that everywhere where there is that company, we take them out. So there's a reference to his business there, which you can correct me, which on the face of it seems to be threats related to his business or emanating in respect of his business. And then the next one says, before you appear, the commission will show you and your eyes. Boy, go to the commission, we will stay behind and take care of your staff. Now, for the first time, there is mention of the commission, but in context of the earlier messages, it seems to me that, in fact, the threat relates to his business affairs, because it mentions his business.
Yes, but I mean, with all due respect, we know what Ndumeni tells us about how we're supposed to interpret a document as a whole and all those kinds of things. And with all due respect, if we can't interpret this document in isolation from two critical messages that come after the business being mentioned, which what we say gives color and context to the entirety of the application. And may I just finish by saying this, is even if we assume if I assume in your construction of the message that the first two messages are aimed at businesses, what does it matter in circumstances where the subsequent two messages, which don't mention the business's shore, are saying, go to Madlanga and see what happens to you?
Yeah.
So I don't know whether, and
So they will go to Madlanga and we will show you and your ice boy. So the ice boy surely has nothing to do with coming to the commission, because we are not calling anyone that's referred to as ice boy.
well, that depends on, that depends whether someone you have called is or isn't an ice boy, depending on what your final report says. I mean, I don't know. I'm not going to speculate, but I think with all due respect, this is the difficulty I'm having with the interpretive exercise, is that we're picking out parts of the message.
No, I'm not. I'm actually saying in context.
Yes.
I do exactly what you say.
Then I apologize. It might be me who's
and I'm
picking
saying
apart.
in context, I'm unable to say in context where his business is mentioned, somebody else is mentioned, and it says go to the commission and we'll take care of you. Why we will stay behind and take care of you while you're at the commission. I'm saying in context of all those messages, it's not clear to me that in fact this is a threat that says to him, do not go to the commission. That's what I'm putting to you.
Well, no, I must respectfully disagree.
And that we will punish you for going to the commission.
I must respectfully disagree. The last message reads, and I quote, before you appear at the commission, which is this commission, we will show you and your ice boy. So they're saying, actually, we're not going to wait for you to donor and skit after you go to Madlanga. We're going to do it beforehand. And then in the next message, it goes on to say, go to Madlanga, we will stay behind and take care of your stuff. So we're threatening you before you go there, and then when you go there, we're going to do more to you.
All right.
So with all due respect, and that's the difficulty that I was having as to the construction of the context, I think it's, and I say this respectfully, a little bit artificial to identify those two messages, take them out and say they have nothing to do with the commission, but then ignore potentially the most direct threats which follow immediately thereafter, and I would say respectfully, give context to what those two other messages are about. The targeting of the business is that might be how the threat manifests, is that we might not necessarily going to come and shoot you, but we're going to go to your offices and shoot your employees or burn your offices down. That's the context that we're talking about, and that's how the deponent tells you under oath he understands the threats.
All right, I do need to move it along. Then let's go to the supplementary affidavit, page 60. And then why do you say that has to do with the commission? We've got a picture of three people who say, I think in the affidavit you say, I can't quite see, and it's really more my eyesight than anything, but I think the witness says the T-shirts say he must fall, Karim must fall. Why do you say that has to do with him appearing before the commission?
Sorry, I apologize,
Page
Commissioner
6.
Baloy, just would you give me a moment?
Yes.
Yeah,
Page
I got
60, supplementary. And then the allegation is at page 53, paragraph 5.
Yes, thank you, Commissioner.
And again, it's a message sent to his business manager. On your paragraph 5, it says, on 22, my operations manager received these pictures. So they were not sent to him, they were sent to his business manager, and but that's all he says. Individuals wearing T-shirts with slogans, Suleiman must fall and his business must close. My question is, why do you say this has to do with him appearing before the commission?
Well, I mean, you've heard me already about the timing of these threats and when they arise. And you've heard me already about the logic of the absence of the threat before the urgent application is what I would rely on to say about the presence of the threats after the first appearance on the 6th of February. And the particular slogan which we looked over is not just any slogan. It's a slogan that is said to say Suleiman must fall. And if you have page 60 in front of you, which is the picture of the three balaclavaed individuals.
Yes.
I don't know, I can make out the individual on the far left-hand side who's got his head bowed down. If you look at the square on his T-shirt and towards the bottom right-hand corner of the square, I can read that says Suleiman must fall.
Yes, no, I'm not quarreling with that.
No, I know. All I'm pointing out is that for the purposes of context as regards to timing, that's the basis upon which the link is made to the commission. The shirt doesn't obviously say go to the commission and then you will fall, or anything of that kind, but I'm answering your question in the context of what's this link, or how does he understand this link, and that's the version that he's putting, is that all of these things emanate after the 6th of February, and that's why he, reasonably in his view, understands that to be the basis of the threats. It's the appearance at the commission.
Yes. Yes, but can we also agree that, he says these individuals are making gestures of a threatening nature. What do you consider there in that picture as A1? Because that's where he's making reference. What do you see as gestures of a threatening nature there, whatever the threat is about?
I mean, I'm not going to give evidence.
I'm not being facetious.
I'm not suggesting that either.
You do accept that we have to make our decision based on the facts and evidence that have been placed before
absolutely.
us.
And
so I wouldn't want him to say the commission disregarded evidence that showed threatening gestures.
And I mean, but that's why I'm saying what he should have probably done is he should have said, like the sufficiency discussion I was having earlier with the chair about identifying potential sources of threats, is maybe he should have said, in picture 1, this person has got a fist raised and that means X, or in picture 2, and so on and so forth. That explanation is not there, and that is what it is on the papers. I'm not going to give an assessment of what is threatening or what is not threatening. That's not my role to play here in front of you. So I can accept that there's an absence perhaps, or a disconnect between what's stated in the affidavit and what you've got in the pictures and what the commissioner is reasonably putting to me.
Yes.
I can't take it further than that.
All right, I understand. And then lastly, the last annexure is at page 63.
I'm with you.
He says, you're taking chances, we're after you, we're gonna burn your place, you can run but can't hide, bro, we'll make sure we deal heavily by your family. On the face of it, again, on the face of it, there's no link to the commission, on the face of it.
You've heard me already, subject to that same caveat.
Yes, I know.
Then of course, I must accept that.
Okay, all right.
I noticed that Commissioner Baloyi did not read the middle text.
I'm a lady.
Exactly as it is.
I'm a lady.
I hope that's not an invitation from Commissioner Baloyi for me to read it out and not be a lady. But let's just say that the threats, such as they are, use rather colorful and robust language that we as members of the noble profession might not be used to saying in open court, but potentially about each other behind each other's backs. I'm not certain. But yes, but I would say the use of these words are indicative of a context. The use of the language and the threats as they are being made are indicative of a context. Admittedly, Commissioner Baloyi, your position is that absent the direct link to the Commission, you are in doubt about that context, and my response to you is to say, well, read it chronologically, what happens from the 6th, and that's how you understand the context. That's how I would put it.
Maybe lastly from me then, we've seen his statement on
the main statement.
Yes. To the commission. Is it irrelevant to our determination of this application that if we form the view, maybe let me formulate it differently as an if question. If our view of the statement is that it doesn't implicate anyone, if that is our view of that statement, and so we have no expectation that when he comes to testify, he will implicate anybody. We don't have that expectation. If we didn't have that expectation, because his statement, we form a particular view about it. Is that irrelevant to our consideration of this application?
No, it is relevant. Like I was debating with the chair earlier, it's relevant in the basket of factors. What weight you attribute to that might sway it one way or you might say it's insufficient weight and it sways it the other way. So it's not irrelevant. It is relevant, but it's not the sole determiner of the application for in-camera on the merits. So I accept that.
Thank you. Thank you, Mr.
Commissioner Baloyi.
Thank you. Mr. Premier, I'm going to be brief. I think you've accepted that prayer 3 and 4 have to be modified. In their current form, there's a problem.
Absolutely.
Yes. And in prayer 3, you accept that your client is coming to testify next week.
Yes, absolutely. Yes. Unless you decide otherwise, he's going to be here.
No, not here. We're not there yet. He's coming to testify, not here yet.
You know, in principle, then I fully accept that he's going to be giving evidence next week. No, I accept that. I accept that.
So whoever is threatening him then knows that he's coming to testify because your application says he's going to the commission.
No, sure. And I mean, they would have known that from the very least at the 6th of February when the order was read out on the record and the dates were specified. Yes. So, yes.
And all the WhatsApp texts that Commissioner Baloyi has taken you to relate to him, or at least some of them, to him coming to testify at the commission, correct?
Yes. I mean, Commissioner Baloyi and I disagree about seemingly disagree about whether the ones that don't are linked to the commission or not. But in my construction of those messages, in his version, that is exactly the point.
And his identity is already known. I mean, his face is all over the media.
Yes.
He was here the other day, I think it was the 6th, so everybody saw him.
Yes.
Now, here is my problem. Accepting that those are the facts, what then justifies his evidence being in camera?
Well, I mean, I think that's if you approach it from the perspective of the horse has bolted, then there's no answer to that.
No, because here's the threat. The threat is they don't want him to go to the commission.
Yes.
But he is coming to the commission.
Yes.
So that threat becomes irrelevant because he's coming anyway.
I'm not sure you can say that it becomes irrelevant because if they make good on the threat when he comes here to the commission, then that's indeed very relevant. What I'm trying to engage you on, Commissioner, with all due respect, is that that it might all be known and the date was already known might render the application from a strict legal sense moot if we were in front of the High Court. But we also know that the High Court has interests of justice jurisdiction to nonetheless grant relief, even potentially impractical relief, but nonetheless grant the relief where the interests of justice are satisfied. So it's not irrelevant with all due respect. It is still relevant for determination because even though on the facts it might be quote unquote moot, you're still, I would argue, you sitting as the commission, are still clothed with your interests of justice jurisdiction that might give you that might result in you giving some or other order that my client may or may not benefit from on the facts. But that's the difficulty we're in.
What does it achieve, him giving evidence in camera? I mean, you must look at this thing the other way. If people are threatening him because they are scared that when he comes to the commission, he's going to say things that may cause difficulties for them, it is even worse if he's giving evidence in camera because now it means they know he's going to the commission. They know he's going to give evidence. But because they don't hear that, then he might have said something which actually causes them difficulty.
But with all due respect, I think that's being a bit glib, and that's actually expecting my witness to take his life into his own hands, and to come and defy the people who are threatening him, to defy the commission by hurting him either before or after that evidence. I think it's a perhaps too strong a stance to take, to say to a witness who comes to you and says, I am concerned about my safety, I am concerned that I and my family and my businesses are going to be prejudiced and damaged and destroyed or killed in the way that these messages reference, and then for the response to be, well, come and say it all in the open light, in the, what is that famous phrase, that sunshine will disinfect all, malfeasance or whatever the case is, where his doing so is the very thing that may cause the harm to befall him. That's the point.
Mr. Permit, I said you must accept as a fact that the threats are there and take it from there. So let's accept as a fact that the threats are there. and accept as a fact that he is coming to testify anyway. It may or may not be here, but he will be testifying anyway. My simple point is, why does it have to be in camera if he's coming to testify anyway? I would understand if you said there are things that he is going to say that cannot be heard in public, because if they were heard in public, he would be in danger. But you're not saying that. So I'm still at a loss as regards why his evidence needs to be in camera.
Well,
I've accepted that there are threats, but because he's going to give evidence anyway, and he's not going to tailor his evidence depending on whether it's in camera or not in camera, you did not make that case. That's why I'm still at a loss as regards why the evidence must be in camera, because I've accepted that there are threats, nobody disputes that, nobody says they are not credible. But because he's coming to testify anyway, I don't understand why evidence must be in camera, and I don't see it in the papers.
I think, with all due respect, Commissioner Khumalo, I think I've given that response already, and I'm at risk of potentially repeating myself. But the top-level notes that I'm going to give to you, so as to not be accused of failing to answer your question, is, number one, it's the fact of the threats, which we say is a stronger factor that weighs more than what the Commissioner has put to me.
Just stop there. They don't go away whether or not he testifies in camera or in person. And that was my point. Because the threats are already there. Whether he testifies in camera or in person, they don't go away. So my simple question is, why then must the evidence be in camera?
But that leads me to the second point, which is what I was going to say, is that then takes the attitude from the Commission that he must come here and take his chances. And with all due respect, I think that's a pretty difficult position for my client to be in circumstances where he says to the Commission, I'm coming to you to prevent the possible threat from materializing. The threats are there, and the Commission's response then is to say, well, everybody knows as it is, come and give the evidence and see what happens. And that's really, actually it boils down to an equity and value judgment to be made by the Commission as to whether or not, in light of those threats that you yourself, Commissioner Khumalo, say to me you accept as factually existing, should be decreased in their purchase because of all these issues that we've been debating today. And our respectful submission is that that shouldn't be the case, because in exercising your discretion, that the factual existence of those threats is something that should weigh heavily on you in making your decision.
I'll accept that as your best answer.
It's the third time's the charm.
May Council please just give us a moment. Ms. Hasim, do you want to start now, or is it not best perhaps to start when we come back after lunch at 2 p.m.?
Chair, may I just consult with because there's another... Chair, that would be preferable because it's also time for Friday prayers.
All right.
Thank you.
Let's adjourn and resume at 2 p.m. Thank you.
When music meets nature, something unforgettable happens. Symphony by the Water, a world-class live music experience set against the breathtaking beauty of Midmar Dam, featuring the KZN Philharmonic Orchestra. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people?
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people.
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM.
Music never sleeps, and neither do we.
angikhathali eyonto phela isuke inzima hard work yena ngivuke ekuseni ngenza uhlelo umelela benza njalo I hold myself impumelela sesiseduze nayo Shilo ini makanana Shilo ini makanana Shilo ini makanana She got the shama chana mane Shilo ini makanana Shilo ini makanana Shilo ini makanana She got the shama chana mane Yes makanana Yes makanana Yes makanana She got the shama chana mane Shilo ini Shilohini makanana, Shilohini makanana, Shilohini makanana, Shilepisha majani, Ilesh makanana, Aye, Ilesh makanana, Aye, Ilesh makanana, Aye, Ilesh makanana, Shilepisha majani, Ilesh makanana, Aye, Ilesh makanana, Aye, Ilesh makanana, Aye, Ilesh makanana.
This is SAFM, leading the conversations that move us. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people.
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people.
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM.
Music never sleeps, and neither do we.
ngikhathali eyonto phela isuke inzima hard work I am Ngivuke ekuseni ngenza uhlelo melela benza njalo I hold myself impumelelo Sesiseduze nayo Shilo ini makanana Shilo ini makanana Shilo ini makanana Shigepisha machari mare Shilo ini makanana Shilo ini makanana Shilo ini makanana Shigepisha machari mare makanana Ilesh makanana Ilesh makanana Ilesh makanana Shigepisha machari mare Shilo ini makanana Shilo ini makanana Shilo ini makanana Shigepisha machari Ilesh makanana Ilesh makanana Ilesh makanana Ilesh makanana Shigepisha machari Ilesh makanana Ilesh makanana Ilesh makanana Ilesh makanana
This is SAFM, leading the conversations that move us. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people.
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM. This is SAFM.
Just tell me about how this concert series fits in with what you are trying to do with these young people.
The reality is that private funders do not just thoughtlessly throw their resources around.
It is one thing to get a backtrack like that for a finance guy, hey?
Somebody just WhatsApped me to say that she has a daughter who has hearing loss.
Corruption in South Africa has reached disgraceful levels.
First things first, let's get to my daily that's my point feature. So, did you see Cristiano Ronaldo cry yesterday?
This is SAFM.
Music never sleeps, and neither do we.
moment, in fact, I had a look at the weather forecast via Apple, and I noticed that we are going to be wet for the remainder of next week as well. And I'm very happy to hear that. But hopefully it doesn't put a damper on your weekend plans, whatever those might be. Wrapping up the week that was this Friday, and we're dipping in as the Madlanga Commission goes on their lunch break. They've been preoccupied for the better part of the morning with those arguments by Suleiman Karim's legal team, advocate Primhead, putting together an application for Karim to testify in camera. A lot of issues have been ventilated over the last couple of hours of the morning. Really, that's been the talking points there. So we'll find out from Spahle Mota what has transpired in case you've missed it, and some of the points that have come up from those arguments. And of course, the response from the commissioners, who are not easily swayed by what Advocate Primhead is putting forward to them. We'll then catch up with Tianis Ferreira, who is an independent TV critic and writer and journalist, and we'll look at Showmax, who are shutting down. That media release causing much discourse across social media platforms over the last 48 hours, with the announcement of the streaming platform being let go by Canal Plus. And so we'll find out what the implications of that, what informed that decision, considering also the amount of resource and infrastructure that was put into starting up and sustaining Showmax. It seems like quite the investment to just let go down the drain, but perhaps there are plans that we're not aware of. So we'll be having that conversation. And we'll be looking at scaling South Africa's creative economy with she's an institution in her own right. In fact, the living legend, Shedo Twala, is going to be in conversation with me a little bit later. It's just gone 1:10. A quick pause, and then we'll be right back.
Every day, Rand Water's underground pipelines run through servitudes across the country, carrying millions of liters of water to our communities. But when people build too close, it's called encroachment, and it's very dangerous. If a pipeline bursts, it can flood homes, destroy property, and in many cases, people lose their lives. That's why Rand Water marks its servitudes with blue and white beacons, a clear warning to stay clear and safe. When we protect Rand Water's servitudes, we protect our communities too. Rand Water, finding new ways.
The Bavarians are loving life at the summit and are highly spirited to keep their grip on the top spot. Standing in their way are the Foles, eager to climb the table and spoil the party. This is the Bundesliga, football as it's meant to be. Do not miss Bayern München versus Borussia Mönchengladbach on Friday, 6 March at 9:30 p.m. Live on SABC Plus and SABC Sport on DTT Channel 4. Proudly brought to you by SABC Sport.
For the love of the game.
This Human Rights Month, we commemorate a significant milestone, the Bill of Rights at 30, making human dignity real. For 3 decades, South Africa's constitution has been a beacon of equality, freedom and justice for all. Yet dignity is not just written in our constitution. It must be lived, protected and upheld every single day. Join SAFM as we unpack the issues that matter, elevate voices driving change and reflect on the progress we've made while confronting the work that still lies ahead. SAFM, leading the conversations that move us. You are listening to The Full Circle.
Alrighty, let's get on with the business at hand. Spahle Mota is standing by, SABC reporter. Good afternoon to you, Spahle. How are you?
Good afternoon to you, Bridget, and thank you so much for having me.
It's only but a pleasure. I mean, I don't even know where to begin, because technically today the commission should have been sitting with Shibiri, if I'm not mistaken, continuing that cross-examination. However, we're still preoccupied with this application that has been put forward by Suleiman Karim's legal team.
I mean, I think a lot of us were not anticipating what is currently happening before the Madlanga Commission, because we had expected that General Shibiri would be subjected to cross-examination, but when we arrived at the commission this morning, we saw that an application was being brought by Suleiman Karim asking that his evidence must be heard in camera. So essentially what that means is that he does not want any cameras, nor people listening on, his testimony, because he's citing the fact that his life, as well as his family's life, is under threat, and that he has been, his businesses are being targeted, and he has been threatened that some of these people who claim to be targeting him will actually burn down his business, and that is where we are. So what we had found is that the Justice Madlanga ruled that he would hear arguments from his legal counsel, Karim's counsel, as well as the evidence leader, to sort of hear why this matter should be heard in camera. And after lunch, we are expecting evidence leader, Advocate Adila Hassan, to argue against that. So this is where we are, and we've just adjourned for lunch. But we're hoping it's going to be a very, very short sort of session. But as you can see, it's tending to drag even after lunchtime.
Yeah, I mean, definitely not a short application as it was posed in the morning when the commission first sat. And it's been interesting to watch. I mean, as we were getting ready for the day that was, just watching Advocate Primhid put forward the arguments on behalf of his client. And I think anyone who's, and I'm, rendering my own observations here, but anyone who's sort of watched him before present in front of court on a matter, you kind of almost get a sense that, yes, he's arguing and putting forward a good fight because that's the instruction that he got from his client. But simultaneously, he recognizes that some of the reasonings for this application might not make sense, might not be justified. And the commissioners are pushing back on that, because here's the other things, Bahle, that my team and I were talking about. Suleiman Karim already had a postponement to come and appear after Ramadan. He was given that leeway for him to go and observe the religious period and other matters. So he was set to appear after Ramadan. At that point, when they made that first application, before he even sat at the commission and was seen on our TV cameras, shouldn't he have instructed his lawyers then that he wants to put an application for his testimony to be off camera? Because what is the point of it now when we already know what you look like, who your wife is, what business she's in, what business you in? At this point, is it not too far gone, as the commissioners have asked?
And that's precisely what the commission and the commissioners are putting to him, that the fact that he testifies in camera or, in an open session, he's still going to testify and put his testimony out there. Because remember, when he implicates other people in his testimony, those people have the constitutional right to defend themselves. So how are they to know that they've been implicated and not been implicated? Because precisely that, they have to have access to this information. I mean, his application even went as far as that certain, certain members of the commission or the team, even investigators, should not really have access to his statement, and even him accusing the commission, saying that he's afraid that his statements may get leaked. But there's no evidence that has happened before, any statement being leaked. So it goes back to the fact that, he has been trying to evade the process of him presenting himself before the Madlanga Commission. We saw him trying to subpoena, or rather interdict the subpoena that was issued against him by the Commission, and we saw the High Court, striking that application off and compelling him to come and present himself before the Madlanga Commission. So this is yet another effort from his side not to come and present testimony before the Madlanga Commission. But as you can see, I don't think he has presented anything tangible to the commission to say that his life has been threatened as he has been questioned by the commissioners.
Yeah, he's definitely, I don't know, maybe we speak, just off the cuff, but it definitely seems like a man who's doing a lot to try and evade that testimony. I mean, the mere suggestion that the commissioner should be the only people who lay sight to his testimony, and that even investigators should be restricted. At one point, Commissioner Madlanga saying, well, it seems as though your client is trying to dictate and prescribe to the commission how he wants us to conduct ourselves in as far as he's concerned. Just seemingly making it very difficult for the commission to get him in that seat.
No, definitely. He seems like he's somebody who wants his testimony to be dictated or done on his own terms and his own conditions. And also, I mean, there's been so many other witnesses who have testified by impartial camera where their faces were hidden, where at one stage, I remember one witness could not finish their testimony because his witness testimony was being heard through an intermediary. And I think there was some sort of compromise that occurred there. But those witnesses who had applied to be impartial camera gave a very concrete and tangible evidence to the commission to say they believe that their lives were at risk. And the commissioner did put to Karim saying that the threats that he seemingly has received, even the text messages, that it doesn't seem like it has anything to do with the commission because, number one, he is a businessman that has been associated with the ANC, and nothing according to the text messages or the evidence that is presented is about the Madlanga Commission. So there is that dilemma against him. But I mean, I'd be surprised if, the commission actually grants him this application.
Yeah, I mean, they've already denied one and said they would give reasoning for it on Monday, which I'm sure they're going to get further into it today. Why wait for Monday when we can just wrap up this situation right now? Sibahle Mote, thank you so much for your time. That was the SABC News reporter, Sibahle Mote, reporting. Oh, so Sibahle, sorry, before I let you go. So what happens? Oh, I wanted to find out what happens of Shibiri, who's been standing there and waiting patiently the whole day, because it is after lunchtime, but it's all right. We'll see what happens after lunch when the commissioners come back, because Shibiri has been patiently on standby in the room, in the vicinity the entire morning. And what a waste of another witness's time who is willing and able and has presented himself, who now has to sit there and entertain this situation that's going on. But let's pause and then we'll come back and catch up with Tianis Ferreira.
You are listening to The Full Circle.
All right, let's switch gears for a second and talk about something else that seems to have made all the buzz on social media. A lot of people chatting about, well, what does this mean? What does it mean for this platform that after 11 years in business, $1 billion plus invested, 500 million plus since 2024, that is now being shut down? How are you doing, Tianis?
Good, and you?
I'm great, thank you. It's all the buzz. This news coming out of Carnel Plus, the new owners of MultiChoice announcing yesterday that following a comprehensive review of its streaming activities, Showmax would be phased out.
I am here at the Sandton Convention Center where the 8th Joburg Film Festival is taking place this week until Sunday, and I cannot describe the shock, the awe, the despair, the anxiety, the angst from the local filmmaking community, and that's directors, producers, all kinds of creative people who are just sort of sad and despondent and fearful and unsure about what the future holds for them making the shows like the Shaka Lembes and all of the other things that Showmax has commissioned as a local platform, because now once again we're having one less platform or opportunity for local content to be shown and be consumed by viewers.
Absolutely. I mean, the words, the descriptives you use, shock, awe, anxiety and angst, I think is what you could feel reverberating even on social media around this conversation? Because everybody says, to end what was supposed to be Africa's most ambitious attempt at building a localized subscription video on demand platform is catastrophic for creatives out there, and also just for that competitive edge of the world of content business.
So a lot of consumers maybe don't make the distinction. You go like, oh, I watch Netflix, I watch Disney Plus, I watch Apple TV, I watch ESPN. But keep in mind that Showmax, as you say, was a local African originated, conceived idea and a platform for us, for our content. And I don't really see... with Canal Plus now being in cost-cutting mode and also saying that will include content cut, they're not going to start up a new Showmax or really, I think, funnel as much money as what MultiChoice did with Showmax in original content creation. And the thing with Showmax was also it gave local filmmakers an opportunity to kind of be a little bit like HBO, so you could get a little bit more edgy stuff, more experimental, more out there things that a little bit beyond the departure point of sort of the normal content. Not that there's anything wrong with that, with your more that's being made for linear television, for your more conservative TV audience on a Mzansi Magic or CakeNet or Mnet. So you could give younger people, younger filmmakers a little bit more leeway to experiment. Maybe it sticks, maybe it's a good tryout to see what works, more edgier fare. And I'm sure we're going to lose some of that now in the whole shutdown process.
I mean, there are sort of, I guess, streaming platforms that the major local broadcasters have embarked on. I know quietly there is the platform that's owned by E! That also has local content that goes straight there. We have SABC Plus, which is doing absolutely incredible, just crossed a milestone of 2 million plus viewers. Just a couple of weeks ago, we were having that conversation. So is there room? Because a lot of people started tagging us at SABC saying, SABC, it's Katsako so Parama Manje. It's your turn for you to take advantage of this and exploit it. Is there room for sort of other similar, albeit not the same platforms to maybe plug into the gap that will be left?
I think what happens is, or that the big thing that is scaring me, or that would scare the industry, is when you see somebody like Canal Plus shutting down Showmax, it sort of makes other executives or company executives go, oh, if they are doing less, maybe we should also relook our budgets. We should also maybe do less. So it's very difficult to then make a business case and go like, oh, Showmax is shutting down, but for whatever reason, but we should be spending more money. So I would hope that SABC Plus would do more originals, or EVOT would do more originals, or Disney Plus would actually come and do more originals. But Amazon, literally just 2 years ago, sent the seismic shock through the industry and said, oh, we're abruptly stopping and shutting down any African originals. Now Showmax is ending, so the trend is almost in the other direction, and that is what's scary, because people go, oh, what are we left with? Always less and less instead of more, instead of sort of supporting the industry. There's just constantly cutbacks. Where do we go? Then we sit with the industry struggling with film rebates and getting that. International production companies that say South Africa is a no-go area, even though they do want to come here, they take their productions and go and film them in Malta and Portugal and Australia and other places. So next weekend is the SAFTAs. People see the golden gowns and the beautiful hair, and they don't really realize the dire state that our local film and TV industry is really in. Because we are so great at telling stories that we are actually keeping up appearances, and I think maybe don't smile as brightly or as widely, so that your ordinary person watching and consuming the content can start to get the message that everything isn't really as hunky-dory and rosy behind the scenes. People are keeping up appearances, but it's really very a dark and a getting darker time for our local biz.
I mean, it's a precarious time, Tianis, and I just want to steal another minute of your time on the other side of the headline news. Let's take the headlines and we'll be right back.
Thank you, Bridget. On the news headlines, some members of the Joint Standing Committee on Defence have accused Defence and Military Veterans Minister Angie Motshekga of defiance after she failed to pitch for a meeting on the readiness of the SANDF to be deployed to assist the police in some provinces to fight crime and gang violence this morning. The late COP leader and former ANC member Musiwa Likoda continues to be remembered by close friends, and police in Britain say they've arrested 4 men on suspicion of spying for Iran's intelligence service. A full update follows at the top of the hour.
It is the Full Circle with myself, Bridget Masinga, on SAFM, and we are in conversation with Tianis Ferreira, independent TV critic and writer, and we're looking at the implications of the shutting down of the streaming service Showmax and what kind of reverberation that will have in the creative sector. And part of the conversation, Tianis, around this is a conversation of accessibility and sustainability for this model in the South African or African context, because a lot of the chatter by those who know better, like yourselves and other folks who are involved in the economies of the creative industry, we're sort of contrasting streaming services in North America and Europe, for instance, talking about broadband connectivity there, disposable incomes there, and all underpinning the success of subscription models. Whereas in African markets, the economies are a little bit different. Our reliance on mobile data is a bit costly. And we have low consumer spending power. So what do we do with services like this? And is it possible to provide a service that is either absolutely free, like SABC Plus, or a service that comes in at a cost-effective financial model?
I remember when I was in primary school and my parents were like, well, not really too poor, but we lived not far enough away, but also not too close. So we had to walk. And then I'd be like, oh, but today it's raining. I don't want to go to school. And my mom was like, you will. And then I go, the next day it's windy. And I was like, can't I just stay home today? And my mom was like, no, you will. So, and as you mentioned, SABC Plus has passed 2 million. I think a lot of times for us as Africans or African companies or African people, you almost want to go like, oh, I'm going to wait for the better day. But there's, I think that Kevin Costner film, Field of Dreams, where the quote is, if you build it, they will come. We shouldn't rest on our laurels and wait for the perfect time. The perfect situation is not going to arise. We're always going to sit with some or other issue or some or other excuse that it's raining or the bus is late. Go to school anyway. Even though you think today I want to just book out and not play. Yes, although there's the data cost, there's accessibility, there's other financial issues, there's like numerous reasons to go, we shouldn't do the streaming service, or we shouldn't try making Shaka Lembe, or we shouldn't start SABC Plus, but just do it anyway. We'll grow into that time where it will be successful and it will work, and then we will have new challenges again on the horizon. So I would say don't give up, don't despair, even though times might be less favorable. Push through and keep going.
Yeah. Tianis, we'll leave it there and let you get on with the business of the day out at the film festival. Thank you so much for your time. That was Tianis Ferreira, just unpacking the implications of the shutting down of, Africa's ambition for that streaming platform. We're going to take a quick pause and then we come back and we catch up with living legend Shadow Twala, who's the chairperson of the Craft and Design Institute, Making It. And we're looking at Making It, which is happening 24th and 25th of March.
Bridget Masinga, weekdays on The Full Circle.
I'm Zanze, I'm Vaughan Lucas. Feel every moment, only on SABC2. And remember, Paradise kicks off 23 February 2026 at 7 p.m. Live in every beat, the pulse of SA.
The Bavarians are loving life at the summit and are highly spirited to keep their grip on the top spot. Standing in their way are the foes, eager to climb the table and spoil the party. This is the Bundesliga, football as it's meant to be. Do not miss Bayern München versus Borussia Mönchengladbach on Friday, 6 March at 9:30 p.m. Live on SABC Plus and SABC Sport on DTT Channel 4. Proudly brought to you by SABC Sport.
Wherever you are in the world, SAFM 104 to 107 is accessible. We're also streaming live on Facebook, X, and YouTube at SAfmRadio. We acknowledge and appreciate everyone tuning in and watching our streams. Stay with SAFM 104 to 107 as we bring you Commission Live, breaking stories, and thought-provoking SAFM, leading the conversations that move us. You are listening to The Full Circle.
All right, let's have a creative conversation now. Making it 2026 marks 25 years of the Craft and Design Institute shaping South Africa's creative economy and convening designers, founders, strategists, investors, and cultural leaders in the Cromwell Design District from the 24th to the 25th of March. We're talking now to a lady who is a living legend in every right of the word. And today she talks to us in her capacity as the chairperson of the Craft and Design Institute. How are you doing, Mom Shadow Twala? Mom Shadow?
Can you hear me, Bridget?
I can now. It was not your fault. It was the slow fingers of my technician. Are you good?
Thank you for hosting us, Bridget. I'm good, thank you very much, and very excited to be talking to you about one of my passions, which is this creative sector, which we've been in as the Craft and Design Institute over 25 years, as you mentioned. And what better way to celebrate the 25 years than put together a 2-day conference, which I think is the first for Johannesburg. And it's very exciting for all of us. You've mentioned that it's going to bring in cultural leaders, designers, strategists, investors at the Cromwell Design District.
Yeah, I mean, firstly, wonderful location. Spend many Saturdays meandering and daydreaming of all things creative in Cromwell. And a little bit of context for some of our listeners in as far as the Craft and Design Institute and what you are ordinarily preoccupied with, sort of in the day-to-day of the organization's vision and mandate.
Well, as I said, the Craft and Design Institute has been supporting and scaling South Africa's creative economy over 25 years, which has made it a really milestone for us. But more than that, it's really just being the shining light of the creative sector, and wants to grow it nationally and internationally.
I mean, you went from 2001, if I'm not mistaken, supporting just 63 makers to now having a national network and national input with well over 8,000 creative enterprises across every province.
Exactly, across every province. And in fact, we only established ourselves in Johannesburg about 4 years ago. And this is why this conference is so important, especially with the kind of people that are going to be in the room, whether you're a startup or an established artist. I mean, we've got amazing milestones as far as our lineup is concerned, which is extraordinary and very deliberately curated to reflect both our roots and our reach. One of our alumni is Andile Galvane, and he's a ceramist who's exhibited at the Metropolitan Museum of Art in New York, and his journey is exactly the kind of story making it exists to tell,
Absolutely.
And we've got other exciting speakers, and, Waysi Zacharias is from Mozambique. She works at the intersection of material innovation and ancestral knowledge, and is doing remarkable things with banana fiber and recycled plastic. I mean, there's so many people that whose stories we need to bring to the fore, but also to encourage collaboration and asking us to think beyond just what our products are and how to really the biggest thing is also understanding how the creative sector can be used for social cohesion as well. Just us getting to know our heritage, us getting to know our culture, but also where it comes together with different people on the continent as well.
Absolutely. As you talk about some of the folks that are going to be part and parcel of the conference, love Andile Jalvani and the work that he and his wife do through Imiso Ceramics in Cape Town, and having watched them build their ceramics brand and company to an international footprint, where it's one of the most coveted collectibles in the world by any art appreciator. It's just always a phenomenal story to hear from him and how he taps into his roots. But Mam Shadow, you also mentioned something very important, and that is the power of collaboration. And during the course of this week, we were in conversation yesterday, for instance, with the folks from Design Africa. And we were also in collaboration with Minister Stella Ndabeni with the creative biz that she was hosting in Durban. And it was really just at the essence of the conversation, or the substance of the conversation, is opening up the corridors of collaboration across different creative mediums and leveraging on that power to build an industry that is not only sustainable but also scalable globally.
You know, Bridget, something that I'm very passionate to explore is that, you know, we have bilateral agreements with so many countries across the continent, but also across the world. But every time you get missions going out to these countries to explore on that people-to-people democracy, they always just take business people and establish businesses which are big businesses as well. And I'm sad that we've never actually exploited the possibilities of a creative and cultural bilateral gathering, which will bring, you know, the continent together, which we need to do very urgently these days, but bring the continent together. And if we can learn about each other, we'll find the commonality in all of us through what we do creatively. Because, as I said, it's also about storytelling. It's about culture. And when you dig deeper, you'll find that we actually are, you know, if we don't write our own stories, and some of us don't write, we can explore our cooking as part of that creative process. We can explore fashion, which we've seen has worked. But design, furniture making, you know, design in the way we live. There's so much to be explored in this space that I think this conference is going to come up with some suggestions and solutions as well.
In spaces like this, Mom Shadow, like the Making It conference, which is a space that's geared for discussion and exchange of idea and an exchange of energy, how vital is it to also bring in the various stakeholders? Because, for instance, I'm just reflecting on the conversation with Minister Stella Ndabeni yesterday, where she recognized that from a governmental perspective, the various departments and ministries that deal with arts and creativity have often worked in silos. You know, for instance, that the Department of Small Business Development has never been roped into a conversation with the Departments of Arts and Culture around how do we support, how do we build business systems that speak to creatives and their needs.
Well, you have no idea what has been happening behind the scenes to try and get people to open those doors. I mean, even as we were planning this conference, there isn't a government door we haven't knocked at. Some have responded, and some, because also the space we work in, the creative sector, is being treated as a soft landing. Nice to have. But I don't think people understand the collaboration within those departments. The Department of Trade and Industry, Small Business Development, Department of Tourism. I could name them as we sit here if we had enough time. But if they would put their their efforts in understanding the sector, first of all. We need to look at policies that we can influence because of the work we've done. And I think some of us have started doing that. So there's a lot of behind the scenes work and education that I think government needs to be aware of, that could grow this sector and make it good for the economy and an important contributor to the GDP of the country and the continent.
Absolutely. You've convened quite the stellar grouping of thought leaders, of captains of industry, of creative entrepreneurs, of creatives themselves, founders, investors. And it reads like really a very robust, holistic, well-rounded conversation that's going to be happening over the 2 days. For folks that are interested, whether it's folks that have been in the creative and adjacent industries for a while, or folks looking to get into it, how do they go about being involved in accessing the space? And most importantly as well, given your imprint over the 9 provinces, is there a hybrid stream that folks can log on to track the conversations and the conference if they can't physically be at Cromerville?
Well, what we've done is we've set up a Cape Town watch party at the CDI Hub and Makers Landing at the V&A waterfront. So while the stage is buzzing in Johannesburg on the 24th and 25th, Cape Town makers, designers, crafters and entrepreneurs can gather there for a streamed plenary experience, exclusive local sessions and real networking. That's going to happen in Cape Town. But if you need to get your area interested, and I think people must just go to our website and they'll find more information there.
Wonderful. Well, it's been a pleasure. Thank you so much for the time. That was Mam Sheru Twala in her capacity as chairperson of the Craft and Design Institute.
Thank you, my love. Thank you.
It is the Making It conference happening on the 24th and 25th of March out at Cromerville Design District here in Johannesburg. So if you have an interest within the creative economy, if you are a designer, founder, an investor, a thought leader in the space, it must be well worth it, or might be well worth it for you to track these conversations. And like I said, it really is a laundry list of well-experienced, well-rounded individuals who function in different capacities and have ignited different journeys and different brands within the space of the CCIs. Sounds like a good one to definitely be a part of. Looking at the time, it's fast approaching 10 to 2 o'clock. We're going to hit a quick pause here for an ad break, and then we will come back on the other side. But before I do that, let me just remind you that SAFM is in partnership with Symphony by the Water, which is taking place on the 7th of March at Mid-Madam, and we're giving away 15 double tickets to see an incredible lineup of South African artists that's supported by the KZN Philharmonic Orchestra. And to win tickets, all you have to do is send us a WhatsApp voice note to 061-410-4107 telling us which artist will be performing on the day and sing a line from one of their songs. Winners must be based in KZN or be able to travel to the venue. Terms and conditions do apply.
In 2025, Liberty paid out 48 million rand in education cover claims to 755 families, meaning...
So many kids still went to school?
Correct.
Even when the dog ate their homework?
Yep.
What if it rained so hard that even fish needed raincoats?
School's still on.
But why?
Because there's no negotiation when it comes to protecting your child's tomorrow, even if you become disabled or pass away. Get education cover today. Liberty, in it with you. Liberty Group Limited, a licensed life insurer and authorized FSP and part of the Standard Bank Group. T's and C's, risks and limitations apply.
The Bavarians are loving life at the summit and are highly spirited to keep their grip on the top spot. Standing in their way are the foes, eager to climb the table and spoil the party. This is the Bundesliga. Football as it's meant to be. Do not miss Bayern München versus Borussia Mönchengladbach on Friday, 6 March at 9:30 p.m. Live on SABC Plus and SABC Sport on DTT Channel 4. Proudly brought to you by SABC Sport.
For the love of the game.
Hi,
I'm Khomotso KG Mweketi, and I believe in music's ability to connect, to heal, to remind, and to bring joy. And each week on my Saturday and Sunday show Seasons, right here on SAfm 104 to 107 nationwide, I endeavor to do just that. So join the movement of Seasons every Saturday and Sunday, 10 a.m. to 1 p.m. It's addictive. You might invite a friend. Seasons, only on SAfm 104 to 107 nationwide, with me, KG Mwekezi.
SAfm supports a litter-free South Africa. Play your part in keeping our surroundings and environment clean. SAfm, leading the conversation. This program is brought to you by SABC Education, enriching minds, enriching lives.
And welcome to Nali Bali. Have you ever had more than enough of something? Maybe extra food, extra toys, or even extra time to help someone? When we have more than we need, sharing with others can make a big difference. There are people around us who may not have as much as we do, and a small act of kindness can bring them joy. Helping others doesn't mean we lose, it means we make the world a better place. Today's story is called Zephyr, written by Tato Khaje. But before we listen to today's story, let's all get up and dance! In a small village in the hot desert of eastern Sudan lived a family of camel headers. They were very proud of their camels, especially their racing camel Zephyr. Zephyr was the fastest camel in the village.
Baba, is Zephyr really fast?
Zainab asked the father.
Just wait for the day of the race, my young daughter. Then you'll see,
said Baba. Early one morning, the grandmother, whom everyone fondly called Jadati, gathered the 4 women in the family.
Our water supply is running low, and we must fetch fresh water from the oasis. The men are getting the camels ready to fetch water. We must collect all our clay pots and water skins. You know how far the oasis is, so please be quick,
said Jadati.
Not you, Arsalan. You are 9 years old and no longer a child. Your job is to look after Zephyr. Please make sure you give him some exercise. Remember, there are many people who are coming to watch the camel race, and Zephyr must do well. Please take care of him,
said Baba. Arsalan nodded and waved as the family left the village on their pack camels.
Baba, do you think Zephyr will win?
Asked Zainab. Baba laughed.
I hope so, my child. All the fastest camels in the country will be racing here. But this year, I think we will win.
At the oasis, the women busied themselves filling up the clay pots and water sinks and carefully sealing them for the journey back. The men picked up the heavy cargo and loaded it onto the camels, and slosh, slosh, the camel caravan started back towards the village. The moment they arrived, Baba noticed that Zephyr was not near their tent.
Perhaps Asalan has taken him to the desert for a run.
He said to Jadati. He went into the tent. There was Asalan fast asleep.
What are you doing here, Asalan? Wake up! Where's Zephyr?
Baba shouted loudly.
You were left here to look after our most valuable possession, and now it's been stolen. And here you are, fast asleep.
Oh, no. This cannot be. There are no thieves in our village,
said Jadati. But Baba was very angry.
If there are no thieves in our village, then where's our camel? All of you, go through the village and look for Zephyr.
The entire household was very upset.
Asalan, you are not a fearless lion as your name implies. You are just a sleepy cat.
Zainab teased Asalan. The family hurried out of their tent and went this way and that, searching everywhere. Then they heard one of the camel herders shouting.
Shuhaida, what is this?
Everyone rushed to the big tent in the furthest corner of the village. There they saw men with large knives.
What are you doing? Stop! That's our camel!
Called Baba.
But this camel was walking around on its own. We didn't know that he belongs to you. Please, we are so sorry. Please forgive us. We are just so hungry. We do not have any food left and no money to buy anything to eat.
One of the men replied. Jadati could see that the men were truly sorry. She called the women of the house.
Go to our tent and bring back food. We will help these people.
That night, there was a family meeting. There was a lot of discussions, but at last, Baba said,
It has been decided. If Zephyr wins the race, the prize money should go towards helping anyone in the village who doesn't have enough food.
Zephyr did win, and everyone was happy. But the happiest of them all was Zephyr himself. Not because he was the winner of the race, he didn't even know what a race was. But as the winner of the race, he was given delicious juicy fruit as a special treat. And so we come to the end of another Nali Bali story time. Today's story was called Zephyr, written by Tato Khaje. Did you know that reading and telling stories to children at home can help them do better at school? If you want free stories to read to your children or for your children to enjoy on their own, visit the Nali Bali website www.nalibali.org or Mobi site www.nalibali.mobi. You will find stories in 11 South African languages, as well as tips for reading and sharing stories with your children to grow their potential. Also look out for the bilingual Nali Bali Reading for Enjoyment supplement with great children's stories and activities, available in newspapers. Nali Bali, it starts with a story.
With my learned friend from the panel has rendered most of my task here redundant, I think. But I'll do my best to cover what I wanted to cover and not dwell on some aspects that have been already fully canvassed with my learned friend. So, Chair, what I propose to do is to address the following in my submissions to the Commission. And the first is the legal framework. The second is the reason why granting the application in the particular circumstances of this case is not justified. And in short, what I submit to the Commission is that an in-camera hearing will not offer the protection or remove the threat that Mr. Karim seeks from having these application granted. And the third is to propose an alternative course that may have better protection, perhaps, for Mr. Karim than an in-camera application. So, Chair, let me first say that although my learned friend was a bit dismissive about the attitude of the evidence leaders to this application, we in fact take quite seriously requests for in-camera evidence. We've moved applications before you in the past in circumstances where the facts were more cogent than in this case. And even there, the Commission has not granted our application in the terms that we sought. So even though there were in-camera witnesses, they were partially in-camera, which wasn't the initial request that was sought for those witnesses, and I'll come back to that. But we moved those applications because we take seriously threats to witnesses. So the starting point is the legal framework and Section 4 of the Commissions Act, which governs this proceedings. And what Section 4 makes very clear is that all the evidence and addresses heard by the Commission shall be heard in public. That is the first thing to say about the Commissions Act. That statutory requirement is given effect in the rules of the Commission, which states that hearings of the Commission will be held in public. Rule 4 also expressly recognizes that there may be circumstances in which it is appropriate for hearings to be conducted in camera. The question is whether these are the appropriate circumstances. And according to Rule 9.2 of the rules of this Commission, that determination lies in the discretion of the chair. My learned friend refers to a series of judgments, including what we call the Masetla judgment, SABC versus NDPP, and others. And the propositions there for when restrictions on openness is appropriate are well established. But they don't do the work for Mr. Karim in this application. The proceedings, and for several reasons, and it is important to say that the proceedings here don't concern the same kind of litigation, inter partes litigation, in which there is a list. It is a public commission of inquiry, and that's relevant when taking into account the weighing up and the balancing exercise that comes once a threat is established. Because the purpose of a commission of inquiry is not only to investigate and to fact find. It serves an important additional purpose, and that is of public accountability in a matter of high public interest. And for that proposition, Commissioners, I'll cite two authorities. The first is the Minister of Police versus the Premier of the Western Cape, and that's to be found at 2014, Volume 1, South African Law Reports, page 1, Judgment of the Constitutional Court, and the specific paragraph that establishes this is paragraph 45. It developed the SAFU judgment, and it emphasized that a commission's role is not exhausted by merely advising the executive or the president in this case, but that in addition to doing that, a commission may serve, and in the language of that judgment, a deeper public purpose, especially in times of widespread public disquiet. The second authority is the case of Secretary of the Judicial Commission of Inquiry into allegations of state capture versus Zuma. And that's to be found in the South African Law Reports 2021, Volume 5, page 1, Constitutional Court Judgment, at paragraph 5 in particular, where there, what the court said, again, is that in addition to the advisory and recommendation and policy advising function of a commission, it also serves a purpose of having a public inquiry in respect of matters of high public concern. And the court said the purpose of a public hearing there is to restore public confidence in the institution in which the matter that caused concern arose, which is very similar to what this commission is dealing with. The objective, said the court, is to reveal the truth to the public pertaining to the matter that gives rise to the public concern. So that context in which this commission sits is important in assessing whether appropriate circumstances prevail that justify the granting of the application that's brought today. Against that backdrop, of that legal framework, let me say then that the facts here don't warrant an in-camera application. The applicant brings the application on the basis that he fears for his safety. In fact, he goes further than that. He talks about the safety of more than 1,500 employees. He says, if he testifies in public, that's the risk. He's also referred, apart from the threats that he's received, he refers to the backdrop of 2 witnesses, but we've now covered that extensively this morning, and it was 1 witness that was killed. The second, Mr. Pretorius, was not a witness before this commission. And of course, the investigation is still ongoing as to the circumstances of the assassination of witness D. And so that's been covered again extensively. I'm not going to get into detail about that, but it is important again in weighing up what this application rests, the grounds upon which this application rests. Mr. Karim attaches text messages that he has received from unknown numbers, which appear to be threatening. We don't know the context, further context of those text messages. We don't know what the potential sources are of those text messages. We don't know whether there's anything that is, whether there's any hostility or dispute or that's happening within Mr. Karim's workplace that may give rise to this. We don't know what the source of the threats are. But that there are threats, on the face of it, appear to be clear. They're attached to his application. So we're not dismissive of that, and my submissions to the Commission shouldn't be misunderstood as being a dismissive of the concerns raised by Mr. Karim. But the reality is that the relief that Mr. Karim seeks is not going to assist him. The reality is that Mr. Karim is known to the public. His application in the High Court to delay his appearance before this commission was widely broadcast. He then appeared before this commission in order to secure a postponement by agreement. Those proceedings were widely broadcast. In those open proceedings, the commission issued a ruling that Mr. Karim is to be present on the 9th and 10th of March for the purposes of leading his evidence, providing his version that he wishes to place before the commission, and to be questioned in relation to his evidence, particularly on allegations that have been made by other witnesses that have come to the commission. Now, and let me say this, in the answering affidavit at paragraph 5.1, it sets out a sample of national media coverage in which Mr. Karim's name and pictures are displayed. And that's in relation to the High Court application. In paragraph 5.2 of the answering affidavit, there are examples of widespread coverage that Mr. Karim will be testifying on 9 and 10 March, and those examples include visual images of Mr. Karim's face. So there is no secrecy at all that it will be Mr. Karim who will be testifying in the commission on 9 and 10 March. What Mr. Karim says in his supplementary affidavit, though, is the following. He says, if my in-camera relief is granted, at best, the makers of these threats will simply not know when, if, or how I give evidence, as the very fact of my doing so will be sealed. And Chair, that is to be found at page 55 of the paginated pleadings bundle, paragraph 9.2 of the supplementary affidavit. Roughly halfway down that paragraph. And I want to emphasize this. What he says is that the makers of the threats will not know when, if, or how I gave evidence, as a very fact of my doing so will be sealed. But that's not correct. First of all, it is known. It is known when he will be testifying, and it's known widely as we've set out in the answering affidavit. Second, Mr. Karim accepts in his notice of motion that he will testify, and as my learned friend has said earlier this morning, it's accepted that he will testify 9 and 10 March. And so in the notice of motion, the paragraph 3, what paragraph 3 requires is just that the hearing is held in camera on those days. Third, it's not at all a given that that in-camera hearing or that closed session will protect the witness. In fact, it may make him more vulnerable, since those who are threatening him may assume that he has implicated them or given evidence problematic to them when he has not. So secrecy can actually amplify a witness's vulnerability by signaling that the witness is exceptional or hidden, and it may just fuel speculation and targeting rather than quell speculation or threats. My learned friend said just testifying at all is a risk, something to that effect. And I'm not sure that I understood it fully. But again, that doesn't assist, because what we do know is that Mr. Karim is not saying that he will not come to testify. He will come to testify. All he asks is that it should be made in camera, but not disclosing his face or his voice is a practically futile measure, because his voice and his face is so well disclosed. And I must say that Mr. Karim has not raised confidentiality or tried to assert confidentiality over his intended evidence as a ground upon which an in-camera hearing is warranted. So we're only dealing with the question of the threats. And I say that he's not raised that because it's not raised on the papers, but also because when one has regard to the statement, and although Mr. Karim repeatedly refused to comply with this commission's ruling on 6 Feb that a written statement be provided by 27 February, he has now filed it. And nothing in that statement appears to place the witness at risk through exposure of third parties in any wrongdoing. The contents of the statement do not disclose any information that was not already disclosed in a public setting before the High Court. So there really will be no practical purpose served by an in-camera hearing. And the threat won't be removed by an in-camera hearing. The threat that, such as it is that has been put up in the text messages. And I'm assuming for the purposes of my argument that those are credible threats. Now, with regard to the other in-camera applications, there have been 8 witnesses who have applied to give evidence in camera before this commission. All but one of these witnesses were required to testify only partially in camera. That is, in public session, with only their faces concealed. The grounds advanced by those witnesses in their applications were either that testifying in open session would risk compromising ongoing criminal investigations, or serious risks to their physical safety. The reason for concealing the faces of those witnesses was because they were also in witness protection, and their facial identification would have rendered the witness protection measures ineffective and would have materially jeopardized their safety. Their faces were not known to the public, those witnesses, unlike Mr. Karim. Here, his identity and appearance are already in the public domain, as is apparent from the extensive media coverage annexed to the answering affidavit. Masking the witness's face would therefore serve no practical protective purpose. So in those circumstances, even a partial in-camera hearing would be devoid of a rational foundation and cannot be justified on the facts before the commission. So in these circumstances, Chair, in the circumstances of the already public litigation that took place before coming to the commission, and then the public appearance before this commission on the 6th of February, one is hard-pressed to understand how another 2 days of public process will increase the risk to the witness. It is true that there is public attention on the proceedings of this commission. By their nature, all commissions established under the Act are required to be public as a default position. All the witnesses who have testified in open session in this commission have had to deal with this at great personal discomfort. Having regard to what I've said about the public knowledge of the witness's identity and the dates for his evidence, there's no reason to privilege this witness by shielding him from public view. and there's been no argument that can be sustained on the founding affidavit or the supplementary affidavit before the Commission that the in-camera hearing would provide protection. As I said, I think it might be counterproductive as far as safety goes. I noted my learned friend, because this point was raised by Commissioner Khumalo about whether it wouldn't be counterproductive. And my learned friend said that might be a glib answer. And first of all, it's not. It's just a practical reality. And it's a practical reality that Mr. Karim has difficulty overcoming. But to assure the Commission and Mr. Karim and his team that from our perspective as evidence leaders, it's not a glib response. What I submit to the Commission is that there are measures of protection that may be provided to the witness. And I must say that in the supplementary affidavit, the witness says the following, and that's at 9.3.4, paragraph 9.3.4 of the supplementary affidavit. What the witness says is, I quote, "Unlike the Commission and some of its staff that have the benefit of security details paid for by the state from taxpayer funding, I have had to undertake at huge expense and prejudice funding security for my family and me." So the witness has complained that while there's protection provided to the Commission and its staff, he's had to foot the bill for his own protection. I want to clarify and place on record that I've been advised by the Commission's head of security that the Commission has previously offered the witness protection services. I understand that he declined the offer as they already had arrangements in place. The offer, however, remains. And I would go so far as to propose, Chair, that in light of the threats received, the Commission could better protect the witness in other ways, not through an in-camera application, but by renewing its offer of protection services that was made earlier, and to consider the contours of the offer of the protection services, whether it's transit protection or static or both, and to do so on the basis of a threat and risk assessment, which I think, in fact, first of all, a threat and risk assessment with the assistance of the state security or crime intelligence or both would actually be important, because a properly resourced TRA is likely to identify the source and nature of the threat more expeditiously than a report made at the local police station. So it goes to the point, Chair, that you raised at the outset about the credibility of the threat, the source of the threat, what actually lies behind it. And having a well-resourced threat and risk assessment made available to the witness will provide a more meaningful measure of protection for the witness. And I would propose that those measures be considered, and if the threat and risk assessment shows that there's a basis and for providing, whatever range of services are necessary, then that can be considered by the Commission, and if necessary, it may even be in place for the duration of the work of the Commission. And again, I say so on the advice of the head of security for the Commission. But that is a meaningful way to address what the witness has brought to this Commission, the risk that he says that he faces and the threats that he's received. It's not the first time that the Commission would be offering services. It's done so for other witnesses who have come, and those witnesses have testified in open. So, in open session. So those are my submissions on the application itself. There are a few other issues I just would like to touch on very quickly. The first is the issue of the bundle that is to be provided to the witness. And I'd like to again clarify that that bundle is not there was a bundle that was provided to the witness some time ago. And what is to be provided today are additional documents that will be used for the purposes of examination of the witness on the 9th and 10th of March. So it's the original bundle plus some additional documents. So the delay is not for the provision of an entire set of documents. It is for the additional documents. The reason it couldn't be provided earlier was because the evidence leaders were awaiting the statement, which only arrived on the 4th of March, the statement that was due on the 27th of February. And the reason for that has got nothing to do with ambushing. The witness seems to be paranoid about the posture of the commission. And there's really no basis to be concerned about that. The purpose of the statement is something that is common practice by all commissions, in fact, not just this commission. A witness comes, a witness provides a statement. It's for the benefit of the witness. The witness gets to provide his or her version unfiltered by the evidence leaders. That was why it was important to get the statement. And of course, if the witness were to say he didn't wish not to provide a statement in the end, well, there's nothing much that the commission could do about that, but the cross-examination would continue in the absence then of a version in writing by the witness. So the second thing is what it does is it allows the issues to crystallize, to understand what is actually in dispute and not in dispute, what are the things we need to cover with the witness.
You are left with, you are left with 5 minutes.
Thank you, Chair. I'll be done in 4. And so it was necessary to receive that so that we could crystallize the issues and know what documents needed to be added to this bundle. It will be provided today. The second is the answering affidavit. The purpose of the answering affidavit was to put up those media reports so that the commission, so that it was properly placed before the commission, so you could have regard to it in determining this and considering the argument of the evidence leaders and where we are coming from when we say practically there is no, it would be futile to have an in-camera hearing. We needed to set that out. That was the purpose of the answering affidavit, not to respond ad seriatim to the applicant's affidavit. So to the extent that there were issues like the 2 witness issues that were not addressed, that was the only reason why it wasn't addressed. Again, we're not in adversarial mode here with the witness. We just wanted to make the evidence of the extensive media coverage available to the commission properly. So I'm going to resist the provocation by Mr. Karim, I won't say by my learned friend, in his affidavits and his remarks about the commission and the commission staff and the evidence leaders. I could say more, but maybe I'll just leave it at what Justice Fisher said in her judgment when she was determining the urgent application that was before her and about what she thought was the unreasonable conduct of the witness in paragraph 19 of her judgment. I won't say anything further on that score. I'll leave it at that, Chair. So that really is our response. I am here addressing the Commission on behalf of the evidence leaders to this in-camera application, Chair.
Thank you, Ms. Hassim. I have just one issue. You emphasize, of course, you've raised a whole lot of other issues, but you've emphasized the question of the High Court application and therefore the fact that Mr. Karim was brought into the public domain, pictures and all, on that occasion. And also that this happened as well when he appeared here. If I understood Mr. Prem, his argument correctly, he's saying none of that changes the situation, which is that After the High Court application, after that appearance, it's only then, thereafter, that there were threats, and that the application relates to the threats, and not so much what had happened historically, even if that was recent history, of course. Why the emphasis on the High Court application and also the appearance here?
The emphasis is important, and it's not historical, Chair. And it's not about the High Court application and what it was about or anything like that. What is important is that as a result of the application and the public appearances that the witness has already been involved in, whether High Court or here, his identity is known. So it is, and that can't be changed. It's because of the High Court application and his appearance here that his identity is known. And that's the only point that's the relevance of the High Court proceedings and the 6 February appearance. It's in that context that there were images of his face, that there was video coverage of his appearance before this commission, and therefore he is known. So the relevance of it is, what does in-camera hearing, how does it serve the witness in protecting him? By my learned friend's argument, the only way in which the threat would be removed is if he did not testify at all before the commission. That's the only way the threat would be removed. But as it stands now, he is publicly known. His face is known. It's known that he's going to be here on Monday and Tuesday. To just pull a curtain over it and have the hearing
not necessarily here, because at this stage you do not know what my order or direction will be.
Fair enough. I'm saying if it were to be in open session, it would be, the dates are known. And so the identity and the revelation of the identity of the witness around that time, the High Court application and appearing here, has made the in-camera application redundant. That's really the only point of referring to those.
Thank you, Ms. Hassim.
Isn't a further factor that it's known that he's going to testify already from the date that he filed his application in the High Court, and when he appeared here and a date was given, so the world, whoever's making those threats, knows that he's been ordered to come and testify on Monday and Tuesday, the 9th and the 10th, and the application as it stands now it doesn't ask that he does not testify on the 9th and the 10th. It doesn't. So the assumption has to be, or the prevailing position as matters stand, is that he will testify on the 9th and the 10th. So whoever he's afraid of knows that he is testifying. He's not being excused. You want to say something about that?
Commissioner Bloy, that really is it. It's a practical point, really. And it's why I referred to that paragraph 9.2 of the supplementary affidavit, because what the witness says is that the makers of the threats will not know when, if, or how I give evidence. That's just not true. The makers of the threats will know when, if, and how Mr. Karim will be giving evidence.
Thank you. We'll hear what Mr. Premit says about that.
Just one, maybe 1.5 points from me. For the purposes of this application, we should accept that the threats are credible, because there's no suggestion that they are not. You agree?
All my submissions are on the basis of accepting that the threats are credible.
So we must start from the premise that there are threats. Now, accepting that as a fact, do you think an in-camera hearing of the evidence would eliminate those threats? I mean, based on what we have heard I'm not asking for your opinion, but based on the evidence that is before us.
Well, okay, so let me explain what I say when I say the threats are credible. What I mean is, I think it would indeed be glib to not take threats seriously. However, there is an issue of insufficiency of the evidence. Some of it was already, and I didn't go there because it was covered already by Commissioner Baloy, about whether the messages that are attached to the affidavits actually show that it's a threat that is emanating from this commission, or whether it has to do with something else. And I've heard my learned friends say, well, you've got to see it in the context of when the threats were made. I accept that, but it's not a full answer. The evidence is insufficient. So I just want to be understood properly when I say it's credible. I just mean that I think it would, from my perspective, I take it seriously, but it's not the application, the sufficiency of the evidence for the purpose of the application doesn't satisfy, I think, what this commission needs to determine. So,
I understood Mr. Premier to be saying, because we don't know where it's coming from, we must err on the side of caution. Just because we're not certain that it's related to the commission does not mean it is not.
Sorry, Commissioner Kamala. So the first is the issue of the sufficiency of the evidence, but it's also not knowing, it's precisely not knowing that, which is why at the tail end of my submissions, I propose that, well, let's get to the bottom of it. Where is the threat coming from? And how can the commission assist the witness in that regard? And that would be, as I said, more meaningful protection than an in-camera application, because everybody will know that the person behind the curtain is the Wizard of Oz.
Thank you, Ms. Hassim. Mr. Premier?
Yes, thank you, Chair.
Just a minute.
Oh, apologies.
Only 10 minutes, Mr. Premier.
Is that protected time? Or in toto?
All told.
I have 14 points to make very briefly in reply.
Sorry, sure. Was that 14?
14, sure. Yes.
Sure.
I'll do it in 10 minutes, but I will...
All right.
I have 14 points to...
10 protected.
Okay, I take that. Thank you, Chair. Let's start at the end. My learned friend says that Mr. Karim will come here on the 9th and 10th if the in-camera application is granted, and all that will be done is his voice is going to be blurred, or they're going to distort his voice so that he's not known. My learned friend is interrupting, I apologize. I don't know if this is going to cut into my protected time. That's how I understood the submission, but Ms. Hassim, yes?
Chair, can I just correct it, because you may go down a path then, Mr. Premier, that is not warranted. Not a distorted voice or that kind of thing. It would be in camera. That is what's requested. It would be a closed, sealed session.
Yes, but the specifics of that request are set out at pages 11 and 12 of the founding affidavit, where at paragraph 23, the witness says, it appears that the individuals are tracking my movements and will be monitoring whether I attend at the Commission's current premises. In this regard, I request that my evidence be led in camera and virtually, alternatively, at an undisclosed location. And then at paragraph 25, it goes on to talk about the purpose of moving the application in the context of being monitored. So actually, the presentation that the in-camera relief is simply to come here in secret on the 9th and the 10th, properly construed is not that at all. It's about getting appropriate directions from the Commission for alternative accommodations that will give the protection of an in-camera session in the way that my learned friend has said, if we come here on the 9th and the 10th, it won't be. So I agree with my learned friend's submission in that regard. May I just also say regarding this sudden offer that is being made about security and whatever else might be the case. I heard my learned friend to say that the head of security made a direct offer to this witness, i.e. my client, and I am instructed by my instructing attorney that no such offer has ever been made. And therefore, the further submission that that offer was rejected also falls to the wayside, because you can't reject something that you haven't actually received. But let's just assume it was made. Why did we have to bring an application and have to come to fight a full in-camera hearing when that is a practical offer that the Commission could have made earlier? And so my learned friend says, rather conveniently, we're not here in adversarial proceedings, we're here in an inquisitorial context. But she then tenders at the last moment, literally in her answer in the in-camera application, something that could have remedied my client's prejudice, which has never been tendered before and has never meaningfully been engaged. Why is it that we are subject to this kind of treatment in this particular context? Regarding the other points that I need to make, that's 2 of the 14, by the way. Yes, the bundle is coming. The bundle was meant to be served 2 business days after the witness statement was filed. That was filed on the 4th of March at 9 o'clock. I'm instructed that it's almost 20 to 3, 2 business days later, and we still haven't received the bundle. So I must raise that in the context of the ongoing prejudice that my client faces at the hands of the Commission's, and I say this with, in a slightly guarded manner, heavy-handedness in how they have treated my client. So regarding also the throwaway remark that my client is seeking to be privileged as a witness is utterly unacceptable, with all due respect. He's not asking for any privilege. He's asking for a procedural determination by the Commission of the rights that the Commission's own rules give him. And to present it as being a privilege actually suggests that the Commission characterizes my client's application as seeking something to which he is not entitled. And that's not correct, because what he is asking from the Commission is something that the Commission's own rules entitle him to. Regarding some of the authorities that my learned friend cited, may I just make 3 brief points about that? The first one is that I sent my learned friend my list of authorities earlier. I asked her to do the same. She didn't, but it's fine. Point number 2 is that those authorities, with all due respect, are irrelevant to the issue at hand. Those speak about the important public function that a commission is supposed to play. That's trite. It's common cause between the parties. The question we have to ask ourselves is whether or not that, as the default principle and the baseline, can be derogated from, having regard to the 6 authorities that I cited, which said that openness is not by default, it's not absolute, and that it can be derogated from in circumstances where, for example, there's a serious threat to security. And whilst I'm just complaining about this, let me also say that this was not the case put up in the answering affidavit, so this is the first time that we're hearing about that. But be that as it may, we're not in a strict court proceeding where affidavits need to be dealt with in that way, I suppose. Let me just also say that we have things that are thrown at us that we learn about for the first time regarding, apparently it was 12 witnesses or 8 other witnesses and all these other kinds of things and what they did or didn't do or whatever the case might be. This is knowledge that is squarely within the Commission's, and when I say the Commission, I mean the evidence leaders, the staff and the attorneys within their knowledge. And instead of then drawing us into a proceeding of this kind, this information could have been tendered to us well in advance and we could have had a reasonable engagement with each other. The only reason that we are here at the moment from the Commission is precisely because we are treated in the manner in which we are treated. Chair, I see I have 4 more minutes, which I will try to use to the best of my ability. And also, with all due respect, the fact that we are here now, in the circumstances in which we are here now, demonstrates not only the abusiveness that my client has been subjected to with respect, it's also that this whole exercise, by the time we're here, has been rendered futile because of the manner in which the proceeding has unfolded in front of the Commission. So even if the Commission was still minded to give my client some form of meaningful relief, regrettably, most of the relief that he could otherwise, or most of the relief that he could otherwise have been entitled to is now lost because of the way in which this in-camera application has unfolded in front of the Commission. And the point that needs to be repeated is that it's not the public nature of my client's exposure to public knowledge that gives rise to the in-camera. It's the existence, the factual existence of the threats and the timing of those threats and the way that they have arisen. And so in those circumstances, we would say that the appropriate thing to do here is to grant my client in-camera relief. If it has to change Schedule A, who's included and who's not included, that is something that the Commission will determine and we will respect. And the Commission will also apply its mind to what is said at pages 11 and 12, paragraphs 23 onwards of the founding affidavit regarding the modality of that evidence. And may I just conclude then on this point in 2 minutes to spare, is that one of the letters that were placed in front of the Commission was an explicit request for confirmation that all of the correspondence in this matter, as well as all of the pleadings, had been promptly placed in front of the Commissioners because of the fact that we required a ruling before the 25th. And that was never responded to despite the request being made. And the reason I raise that is because that concretizes the prejudice that my client faces in circumstances where he engages the Commission evidence leaders and staff on one hand, and things don't necessarily go through to the Commissioners in the way that we don't know whether it does or it doesn't, and then he's caught with the consequences arising from the way in which the Commission's evidence leaders and staff choose to handle requests made of them, including requests where matters are asked to be raised with the Commissioners on an expedited and time-sensitive timeline. And so, quite frankly, having regard to all of that, and the fact that factually at the end of the day, everyone accepts that these are credible threats, and that they do exist as a matter of fact and as a matter of the record, we would pray for the relief sought in the notice of motion, subject to those amendments that I have suggested are possible amendments, like the one I discussed with Commissioner Khumalo. May I please take an instruction? Thank you, Chair.
Mr. Premier, I'm concerned that with the posture, and I'm concerned because I am not aware of the facts. I don't see the facts, maybe let me say it. I don't see the facts on which you base the kind of contentions or statements that you're making. You have this consistent complaint that your client is being treated exceptionally badly. He's being victimized, high-handedness. In fact, if one went through your client's affidavit, there's really quite a number of concerning statements. You know, in your supplementary affidavit 932, you speak about brinksmanship. In 934, you speak about a fishing expedition that the Commission wanted his statement as part of a fishing expedition. But over and above that, there's this hyped up criticism of how he's being dealt with. You haven't placed to us, before us, facts that support those kind of strong statements. And I think there is a responsibility, especially for, at least as far as I'm concerned, there is a responsibility for legal practitioners to advise their clients when a statement is required by the Commission, because our rules say so, because the chairperson directs statements must be filed. I think I think you'll agree with me that legal representatives have a responsibility to say to the client, you can't call it a fishing expedition. Statements must be filed, right? We do have that responsibility.
Absolutely.
And here there's this gratuitous statements about how badly he's been treated, including on something like this. It's not backed up by anything in the conduct of the Commission. You know, the chair earlier dealt with you, spoke to you about some of the language and gratuitous statements that are made, but in fact, there's quite a number of them here. I'm concerned that your client is on a path that seeks to publicly create the impression that this commission has got something against him. And there's no basis, absolutely no basis. And I want to deal with just one example. Your attorneys wrote a letter requiring a response and rulings by a certain date. They had unilaterally fixed dates. And there was no justification in that letter why the commission must make rulings by a certain date. We're just told, just give us rulings by this date. You're complaining about the response that you got. We didn't give you the ruling on the date that your attorney demanded it, because that's what it was. You're complaining about that as if it was there for your client to take. It was for the attorney to write, and the commission must give a ruling on the 25th, and if we don't give a ruling on the date that has been dictated by your attorney, we are treating your client unfairly. Something that I can answer directly to without having to file an affidavit is the demand to place it before the commission, that letter that said, please place this before the commission. Commissioners, in fact, it happened. And your attorney got a response saying, we acknowledge receipt. It will be placed before the commissioners and they will deal with it in due course. There is that kind of response that was sent. And I say that because I know it happened. But that's not even the nub or the essence of what I'm speaking to. I'm speaking to this tone, this consistent tone since morning, that your client is being treated unfairly. You haven't suggested, or he hasn't suggested, why we would do that to him. He hasn't. He's just been happy to say, I'm being treated unfairly. There's this high-handedness. There isn't. He appeared here. He was told to file a statement by a certain date. He did not file by that date. Instead, he wrote a letter to say, well, give me directives. He doesn't file on that day. He's told you have to file. So I don't see any facts here. And it's important what you're saying because it carries. And it carries. This is a very public process. And it carries, and I think it should be called out. If your client has got facts, he must list them and let the reasonable person judge on that. But as matters stand, there's nothing of sorts. It's just gratuitous statements. What fishing expedition, what interest would the commission have, and why him, when all other witnesses, we've had many witnesses appearing. This is the first time that we have a witness who says, well, you want my statement as part of your fishing expedition. We've had in camera people applying. They have happily filed statements that set out why they should be heard in camera. This is the first time that we get a complaint that this is a fishing expedition. I'm really, and you can comment as you wish, but I'm really expressing a displeasure with the conduct of Mr. Karim, but also because it's not substantiated by anything that he has put before us. You may comment if you want to.
Thank you, Chair. Commissioner Baloyi, I'm now going to read from the correspondence because I don't know if the correspondence bundle has been placed in front of you in the way that we asked. But on the day that the application was launched on the 18th of February, this is what the attorneys say on the record with prejudice.
The postponement. What application?
No. This is on the 18th of February when this application for in-camera is launched, Commissioner Baloyi. The attorneys say, as you would appreciate, due to the sensitivity and urgency of the matter, bearing in mind the date for the submission of our client's statement, in respect of his evidence, we request the aforementioned application to be urgently considered by the chairperson and such ruling is issued by or before the 25th. In that same letter, it says, in our respectful view, it can be decided without oral submissions on the basis of the application. Should the chairperson require submissions, we are amenable to do so at a time that is mutually suitable, taking into consideration the need for a ruling by or before the 25th. And you'll remember that is coupled with an application that seeks condonation for non-compliance, both in terms of the rules as it applies to the timing of the in-camera, but also explicitly says, I need a direction in respect of the filing of the statement so I know what my position is come the filing deadline. On that day, Commissioner Baloyi, the response from Mr. Popkas says, it's not that it's being placed in front of the commissioners. It says instead, we confirm that same will be relayed to the secretary and evidence leader shortly, and we will revert with formal instructions in due course. And then 5 days lapse. And on the 23rd of February, a letter is written, and it's a 2-page letter, and I'm not going to read all of it, but what the attorneys say is, kindly advise whether the application has been served, and further when we can expect a response. In the event the application has not been served, what are the reasons? We remind you of the urgency in response to our client's application premised on the order of the Commission. And we refer you to what we set out in paragraph 7, which is what I read out about that 25th deadline. We reiterate that request. And then on that same day, we get a response that says, we acknowledge receipt of your correspondence and confirm that same will be directed to the relevant functionaries for consideration.
My point, Mr. Pramit, is why does that all, how does it all justify this is victimization? That's my point. My point is, you remember where I started. I said there's this consistent theme that Mr. Karim is being treated exceptionally badly, victimized. You've said, I think we've been adversarial. The commission has been adversarial towards him. All the strongest words that he could think of are in his affidavit about how badly he's being treated. But not just badly, but like he's being targeted, he's being victimized. And that's my issue, that sequence of correspondence happened as it did, right? How does it translate? When do we get to the point where you say, this is my client being particularly victimized? That's why I referred, and for me, that's an easy example about the statement that, all witnesses have to submit statements. To have a witness say, oh, this is a fishing expedition. I've asked to be heard in camera, now you want my statement. And you want my statement because you want a peek, to have a peek into what I'm going to see. What I'm saying is, surely, what interest do we have, right? Why would we want to fish when we're going to have a witness here? He will come and testify. We'll ask him all the questions we want to ask. Absolutely. Yes, so there's not, basically the point I'm making is there is no basis for this strenuous complaint that is being put out there that this particular witness, and just him, because we've never had this complaint, just him, why would we treat him badly? Why? The one witness who came here applied for a postponement on the basis I don't have documents, I have people who are, my lawyers are not going to be available, actually got a very generous postponement, right? To go get ready, have your lawyers available. That you don't, as you say, context. That context you don't speak to, but you nitpicking on matters of engagement with the evidence leaders, with the attorneys, and you elevate it, or I accept you're a creature of instructions, and so it's not your personal positions that you're putting forward. But why he would be targeted by the commission? What's there to gain for the commission? And I think those are critical questions that should be asked before he puts stuff like this on, in the public domain.
Thank you, Chair. Through you, Chair. When I was engaging with the Chair in the morning about the other instances of prejudice claimed by my client, that was a cumulative assessment of not only this chain of correspondence, but other instances where the Commission has conducted itself in a way that reasonably leads my client to believe that he is being treated in the way that he is. I understand what Commissioner Baloy is saying to me, that in Commissioner Baloy's view, there is no basis upon which to make such a statement, and that the stridency of the statements is a concern for Commissioner Baloy, but more broadly than that, that it's a concern insofar as the integrity of this commission as it may be viewed in the public. And Commissioner Baloy, I would entirely agree with you. The consistent complaint from my client has been that the Commission has a set of rules. There are instances where not the Commissioners sitting on bank in front of me, but through the evidence leaders or the attorneys or the staff or whatever the case might be, there are instances where non-compliance with those rules are identified. That may or may not turn out on legal interpretation and whether that view is right or wrong. But what it implicates is that my client is the subject of coercive force by this commission. And unless my client is represented by a legal...
Coercive force having manifested where? Just tell us
it's the threat of the coercive force. I'm not saying that there has been coercive force. I'm saying at each one of these instances that you've put to me, where the stridency emerges from Mr. Karim and his legal team, I'm saying that in each one of those instances, the threat of coercive force hangs over my client, that if he is found to be in breach of the commission's rules, or even where to be found in breach of those commission's rules is subject to a legal debate where his legal representatives say, actually, the commission is not following its rules in the first place. So why
can we just clarify this? You say he's the subject of the threat. I understand you to be saying the threat of coercive force, but that's true for everyone who appears before us. If they haven't complied with a directive in the way that your client did not, right? There was an order by the chair. You must file your statement by a certain date.
Yes.
Now, there's nothing exceptional about your client on that kind of order. And when he doesn't comply with it, to say that you will be subjected to the powers that we have, that you will be held in contempt of the commission because you haven't complied with a ruling, a lawful ruling of the chairperson. There's absolutely nothing wrong with that, and there's nothing to complain about.
No,
he may justify himself and say, I didn't comply because I was waiting. I was hoping you will give me a directive just like I asked for, right? He could give that as an excuse for non-compliance, but as a matter of law before us here, right? If you don't comply with the directive of the chairperson, you are in contempt. Whether we act or we postpone acting is a different matter. So it's an inaccurate reflection of the position to say that, well, he's being unfairly subjected to coercive force because he has been told he's in contempt and therefore he will be, measures will be taken against him. Sorry, I don't understand that complaint.
No, that's not the complaint, because we're not complaining about the trite proposition that the commission has the power to use coercive force in instances of non-compliance. What we're overlooking, with all due respect, Commissioner Baloy, in the way in which you've put that limited factual scenario to me, is that there was an application as an intervening fact to say, please define...
That application did not displace, there was never a suggestion from the commission, Mr. Premet, that because there's a pending application, you don't have to file. And the commission doesn't get dictated upon by a witness who decides, I do have a ruling. I have a clear ruling to file by a certain date, but you know what? I'm not going to file. I'm writing a letter to say, give me directives. I have a pending application, therefore I'm not filing. That's not binding on the commission. He was given a clear directive and he was in contempt of the directive. Simple. But with
all due respect, Commissioner Baloy, the ruling was asked for before the statement was due. And that's why we can't simply ignore the factual intervention of the application. If the application was dismissed by the 25th, then he would have had to file on the 27th. We can't deal with the hypothetical of non-compliance without factoring in the fact that the witness himself came to the commission and said, I know what my obligation is, but here's a related issue I need you to decide upon before my statement is due to help me clarify what my obligations are.
The problem isn't that before, that he determined, he determined for us, before I file my statement, give me a directive. And then when he doesn't get that directive, he chooses not to file his statement. That is where the problem is. And I'm not sure why we're having this argument, when in fact the reality, the factual reality is there was a directive. It had a fixed date for compliance. He did not comply. he has an explanation. And that's my complaint, if it's a complaint at all, for lack of a better word, is that he superimposed before the statement was due, between the date of the directive and before the statement was due, he then superimposes something. He says, give me a directive, and then he goes and make a decision, I'm not filing, because they didn't give me the directive on that day. And the simple point I'm making to you, and that I didn't expect would be such an issue of contention, is that he wasn't entitled to do that. He did it anyway, but he wasn't entitled to sit back because he doesn't have the directive that he's asked for and that he has put us on terms, by the way. He puts us on terms to give him a directive by a certain date. When we don't give him that directive by that date, the simple point I'm making is he wasn't entitled not to file his statement in accordance with the directive. And when he is told that you did wrong by not filing by that date, it's not open to him to say, I'm being victimized. That's the simple point I'm making. It's not open to him to say that.
Unless perhaps I'm wrong on some legal basis, it seems to me like somebody that were to act as if there is an interdict in place when in fact there is none.
Chair, may I say something on this?
Not in the middle of Mr. Premier's argument.
Oh, sorry. I thought you...
No, the
yes,
commissioners
Mr.
are
Premier,
very active on a Friday afternoon. I'm not done.
Please respond to Commissioner Baloy's question.
I hear exactly what Commissioner Baloy says. I think where Commissioner Baloy and I depart company is let's use a high court type of scenario. A high court gives an order that is going to, compliance with which is going to have to occur by the 27th of February. Let's use our exact dates. And before the 27th of February, an application is placed before the High Court that says, I need you to determine an issue, whether rightfully or wrongfully, whether imposed unilaterally, whether placed on terms. The fact of the matter is an application is launched before the compliance date to say in the High Court, determine the terms of my compliance, because I'm concerned if I comply in the way I'm currently expected to comply, that's going to cause me some or other prejudice or harm or whatever the case might be. I think where Commissioner Baloy and I part ways is that, on my understanding, given that it wasn't just a letter, it was also an application for formal relief under the Commission's rules with a prayer for condonation with the associated timeline, that demonstrates an absence of willfulness for the purposes of the so-called non-compliance, because there's a legal issue that is sought to be determined before that compliance and or non-compliance can arise. But I've heard what Commissioner Baloy has said, and Commissioner Baloy's view is that is not correct, and that notwithstanding your application, and please correct me if I'm wrong, you actually should have complied, and that your failure to comply is what has caused the concern for the Commission. I hear that, and I accept the remarks made by Commissioner Baloy. Obviously I do, but I would say that the fullness of the answer that I can give is that he didn't sit back and simply not comply. He came to the very body that will determine the consequences of his compliance or non-compliance on the 27th and said, please give me a directive on this particular issue that is materially connected to that compliance which I know I have to comply with. If that was the wrong approach, that is the wrong approach, and we have to take the proverbial beating that we receive for that. But as long as it is on record that my client didn't just simply write a letter or sit back or sat on his hands, but that he engaged a formal procedural process to help him clarify the terms of his compliance in respect of that particular date, then that's as far as I can take it. But I take that, Commissioner Baloy, and may I also say on the record that this is now the third instance that the Commission has raised languaging and stridency in the conduct of the legal team, in the conduct of Mr. Karim's legal team. As Mr. Karim's leading counsel, I will take responsibility for that, and I again apologize to the Commission for those terms, but I hope the Commission will understand that the obligation on us, as Mr. Karim's legal representatives, in circumstances where he could be the subject of coercive force, is to represent him to the best of our ability with no regard to personal consequence, fear, or favor. And so I take the admonition in the way that it is delivered, and just to assure the Commission that that was never meant as a sign of disrespect or willful non-compliance, but it was in what we see as the legitimate pursuit of our responsibilities to our client as his legal representatives. Thank you, Chair. Thank you, Commissioner Baloyi.
I accept that, Mr. Premit.
Mr. Premit, this is directed to your client and other witnesses that are still to come, and this is very important because officers of this commission don't get to speak for themselves, and allegations are made in the papers that affect the officers of this commission. I just want to place it on record that the rules of this commission require that they take the oath of secrecy to preserve confidentiality of any document that comes to this commission. And Regulation 12 says if they breach some of those regulations, it is an offense. So all of them take that obligation very seriously. And we as commissioners, we administer that oath. And we make it clear to them that, these are your obligations. Everything that comes here is to be treated as confidential. I just needed you to know that, and any other witness that comes after your client, they know that, so that allegations should not be made that if officers of this commission come across statements or documents, they won't treat them with confidentiality. I think it's very important that that is made clear, because that was the fear as I understood it, and it is put on affidavit. They don't get to speak for themselves. But we know the regulations. As I said, some of these documents are on the website. So can we just understand that, so that going forward, you know that that is the position? It is not directed just to your client, but anybody that comes after your client.
Of which I assume there's going to be many. But
I hope they don't repeat what was said this morning.
Commissioner Khumalo, may I say I accept that. And indeed, had the confirmatory statement of what you just put to me, which we received in the directive on the 3rd of March, in paragraph 7, be said on the 18th of February, then that might have changed our position being in front of you. But I've heard what you've said, and I'm sure all the television cameras have flighted that as well. Thank you, Commissioner.
If they repeat it, I'm going to blame you.
Wouldn't be the first time, Commissioner Khumalo.
You wanted to say, or should I quickly raise my issues and then you come thereafter? You want to come in now?
Chair, it is related to the issue of...
I just hope it won't result in an unending ping pong.
No, Chair, I'm sure you will ensure that it doesn't.
Yes.
It really is to say two things. The first is that the effect of bringing the application on the 18th of February was not to suspend the ruling of the 27th of Feb. And so I hear my learned friend saying...
I think that was the first, or after my preliminary point, I think that was one of the very first issues I raised. I think Commissioner Baloyi as well has touched on it. I think the point has been made in that regard.
I won't say anything further on it, except it was important from our perspective as the evidence leaders, because there are allegations that are being made about the evidence leaders in this. And so it doesn't suspend the ruling. It was important from the point of view of the evidence leaders in the way in which they handled that application going forward. But the second thing was that my learned friend said that the statement was materially connected to the application. And that was not at all apparent, and until this moment, it's still not apparent to me how it is materially connected to the application. If Mr. Karim had said, my statement will contain information that cannot be disclosed, and that it's part of my application for the in-camera hearing. Part of why I need this is because I'm going to say something that has to be kept confidential. That I understand, but that's not the ground that was advanced in the application. And what is in the statement is not anything that has not already been said in public in the High Court by the witness.
Thank you, Ms. Hassim. A quick response to the second point only, please, Mr. Premhead, if you have it.
All I'll say is that I don't know what more my client can be expected to do in the circumstances where he comes to the commission, places the application and the correspondence where the exact justification sought by my learned friend is placed. And that's not to do what my learned friend has, I think, suggested, which is that it's about the content of the statement. It's about the status of disclosure it's the status of the hearing prior to the disclosure of the statement, not the content of the statement itself. So that's consistent, the consistent line we've taken in these proceedings.
Thank you, Mr. Premhead. I have two very brief points to raise. There's the issue of the offer of protection. There's a dispute as to whether the offer was made previously. I will leave that and proceed to what the attitude is now, because Ms. Hassim has said the offer is being extended even as we speak. Is there a response? If not, will a response be given to the evidence leaders as soon as possible in this regard?
Chair, may I say that we have to take an instruction and we'll give a response, but I must just say this.
Yes.
My client is scheduled to come before this commission within 48 hours. My learned friend was talking about things like threats assessments and all these other kinds of investigations that need to happen. So I mean, practically speaking, even if he wants to accept that, I don't know to what extent all of the necessary processes are completed within the 48 hours that he has available. But we'll take an instruction and we'll come back to you on that. Thank you, Chair.
Thank you, thank you. Then there's also the issue of the supplementary bundle. This morning I understood you to accept that that's due today and that you will accept it when it's finished today. But when you were arguing this afternoon, I understood you to be saying it was due at a specific time this morning and that by now it's late already. I just want to understand what exactly you are saying in this regard. What's the point of substance being made in this regard? Are you saying it's late and therefore your client will be prejudiced if your client gets it later than whatever the morning time was?
Yes. And the reason for that is that we were under a time pressure to file by a particular time. That was specified in the directive handed down as 9 o'clock. 2 days later, business days later, 9 o'clock, the statement, the supplementary bundle has not been given. We are now here on the Friday afternoon at 3:15. I'm instructed it's still not been given.
What were the exact terms of for the filing of that?
You'll remember that comes from the original order you
yes,
gave
but
in the context
what were the exact terms?
Within 48 hours of the receipt of the statement. And so now I'm saying 48 hours has actually lapsed. And I'm not just complaining that 48 hours has lapsed. What that has an impact on is from Friday 9 o'clock until my client has to appear in front of you on Monday at 9 o'clock or whatever the actual time is, the absence of the bundle since this morning is now eating into our...
What time was it this morning?
9.
9.
That we had to deliver the statement yet. We had
No, the bundle, the supplementary
bundle. We would
bundle.
have anticipated it 2 days later, meaning 9 o'clock today in the morning.
9 today.
Yeah.
And at 9:30 you were here.
Yeah, and it hasn't come.
And would you have used it meaningfully, or is this a technical point?
No, we would have. As you might notice, one of my team is not here today because he's off sick. But he would have been the one to take up. He was off sick and not present because he has a contagious illness, which means he should be isolating. But he would have been in the position to already start looking at that bundle, engaging our client, and so on. and so that's just the reality of where we are placed.
But Mr. Premhead, this point about the exact hour was not made this morning. This morning you seem to accept that this bundle is to be given to us today, and it was already past 9 o'clock, and you did not suggest that you are late because you did not give this to me at 9 o'clock. It seems to me that this is an about 10, and I'm not taking kindly to that at all.
No, I accept what you say to me, Chair, and I'll say that it's not an about turn, because when we were given
It is. If after 9:30, when argument commenced, if after 9:30 you said the supplementary bundle is due today, and you said it in a context that was receptive to the idea of that being given to you later than the start time of the argument, all of a sudden now you are insisting on 9, and you are already past 9 when you made this point. That is why I'm saying this is an about 10. If you want to, we can actually listen exactly to what you said. And I think I'm correct on this.
No, I don't think that's necessary. And I hear what you say to me, Chair, but all I'll say is that even if 9 o'clock wasn't the fixed time, or alternatively, my failure to mention the 9 o'clock issue when I addressed you earlier now causes the effect that it didn't have to be given at 9 o'clock. The point that I would make simply is that it's now Friday afternoon, almost 4 o'clock.
Do you remember as you were arguing, I think I even asked Ms. Hassim, will this supplementary bundle be served today? And you said yes. And Mr. Premier, you never said, but that will be late already. You never said so.
Chair, may I?
Yes. Yes.
Because what is happening here is important. It's again the applicant creating rules and demands.
No, please respond when Mr. Premhead is done. Let's just continue with the debate with Mr. Premhead.
It's on the same point, Chair, but okay.
No, so that you don't, it doesn't become a dialogue between you.
I never know when Mr. Premhead's done or not.
No, you're still arguing. I hope you follow what I'm saying, Mr. Premhead. After 9:30, during your argument, you, in a manner that is receptive to the idea, accept that the bundle is going to be served. You do not appear to be opposing that on the basis that it was supposed to have been served at 9 o'clock, and therefore it's late already. You did none of that. If anything, as I've said, I think 2 times already, you were receptive to the idea that the supplementary bundle was going to be served after 9 a.m. in the morning. It's on that basis that I say I see this as nothing but an about 10. It's on that basis that I say so. And I added that I do not take kindly to it.
Chairperson, I'm instructed that the bundle has now been emailed to us whilst we've been having this engagement. So my prejudice is cured.
Thank you very much. Thank you very much. Those are the only 2 issues I wish to raise. I wished to raise with you, Mr. Premier. I don't want it to get to the ping pong that I said I do not want it to become.
No.
This issue has been resolved now, Ms. Hassim.
Chair, can I just put one point of clarity? There was never any agreement that would be filed by 9 o'clock this morning.
No, I understand that perfectly, but I understand the point to arise from a mathematical calculation of 48 hours, not that there was any agreement. But I am saying what I said despite the mathematical calculation because I just find it very strange. Yeah.
I appreciate that, Chair. My point is not about yours. It was about...
No.
Even the 48 hours was never...
I guess I'm addressing Mr. Karim through you. Yes.
It's merely to say that the 48 hours was never an agreement.
No.
The 48 hours comes from your ruling on the 6th of February relating to a different set of documents.
All right. No, thank you.
Thank you, Chair.
Thank you, Council. Thank you all to all of you. I will make my ruling on this at 9:30 on Monday, and I hope that it will be a written ruling which will cover both the reasons for this morning's ruling and also then the ruling on the aspect that's been argued now, plus the reasons for it. We earlier touched on the possibility of the filing of a supplementary affidavit on the issues that I engaged Mr. Premhid on. I do not even trust my memory to be able to articulate those. I trust your memory more than mine, Mr. Premhid, on that.
To interrupt you whilst you are talking, but my learned friend indicated she also doesn't remember. I remember that this possible supplementary statement is to deal with issues such as who could potentially be the source of those threats.
That was the thrust of it.
Yes,
that was the main.
The circumstances and the reasonable version of the
That was the thrust of it.
Yes.
Thank you. I direct that a supplementary affidavit, if any, underline if any, must be filed by midday tomorrow, and a response to it, if any, by 7 p.m. tomorrow. That's the direction, but I may just add that by making the direction, we're not necessarily saying that anything will turn on that, but when you write your reasons, you never know where the pen might lead you. So I want to avoid a situation where we just might say, oh gosh, if we had directed that there be such a supplementary affidavit. So it's on that basis that I'm giving that direction. Let us adjourn and resume at 9:30 on Monday, and we will resume here. Perhaps let's see counsel outside regarding the practicalities and so on. Let's adjourn.
These chances come and the voice notes come in, we'll bank them and play them when it comes up. So as you know now, the Madlanga Commission adjourned until Monday, 9:30. Right, so you can WhatsApp ASAP, both on the Madlanga and the Adoc, and anything else that you wish to get off your chest. There's also big issues in the Middle East. The price of petrol's gone up, well, not gone up. The projected increase could be 90 cents, by the way, in one move. Let's get to your thoughts, right? Here we are. Let me pick out those voice notes.
Good afternoon, Ashraf. This reminds me of the Stalingrad tactics used by one Jacob Zuma, who always wanted his day in court. And when that day arrived, he used all sorts of tactics for the case not to proceed. And this is exactly what they are doing now. They are playing games for this Karim individual not to testify. Can only mean one thing. He's got very, very explosive information, or he is heavily involved in wrongdoings. Daniel Middleburg.
What about is it fear for your life because of threats? Is that not a reasonable argument?
Hi, Ashraf. I think the counsel for Mr. Karim earlier on was playing mind games. When he was doing a presentation, he then looked at his phone and said, oh, the finance minister is calling me. I think he wanted to brag and show the commission that he's connected to the high echelons of the government. That's Reddy Pobe from Midrand.
Okay, there we are, connected to the higher echelons of government.
Good afternoon, Mr. Ashraf Mbongo Sundisa Mbuyisa. I think the witness that wants to give evidence on camera is being ridiculous, because last time he did appear on camera here on Madlanga Commission. Even if I were to meet him now at the garage or Shoprite, I can say it was this guy. Like simple description, he's just being difficult, he's serious. Thanks, Mr. Ashraf.
Okay, and there's more. Let's just pick out, and there's a lot about Karim, of course.
Good afternoon, Ashraf. I just want to share my thoughts with regards to the appearance of Comrade Suleiman Karim, the Madlanga Commission. But Ashraf, the reality is one thing. That is not the Madlanga Commission. That is the Baloyi Commission. Because when that lady says, what she says goes. It is clear at this point in time. When she cannot make it there, there's no proceeding seating. She is the one that's running the show there, in my honest opinion. And Comrade Suleiman Karim shouldn't even be called to be sitting there. This whole proceeding is unfair towards Comrade Suleiman Karim, my honest opinion. Daniel here in Bryanston.
Okay, why would it be unfair to him? I mean, even now, when it hasn't, it hasn't started for him. At the moment, they're just pleading for a in-camera testimony. Right, more to come. I'll take more calls from you, so call in live. You can also tweet, hashtag the National Pulse, tag SAfmRadio, tag me, Ashraf Gandhi. I'd love to chat with you. And then to WhatsApp, well, you should have the WhatsApp number. Everybody's got it. But let me remind you, 0614 104 107, text or voice note. This is the National Pulse. News headlines. Here's on Dela Mbana.
Thank you, Ashraf. From the news headlines, the Northern Cape National Prosecuting Authority has secured a forfeiture order in the Kimberley High Court against properties of a businessman in Kimberley valued at approximately 12 million rand. The South African Weather Service says residents in Gauteng should prepare for cloudy conditions with widespread showers and thunder showers today with an 80% chance of rain across the province. And Ukraine's President Volodymyr Zelensky says the United States has asked for his country's support in protecting against Iranian-manufactured Shahed explosive drones in the Middle East. A full update follows at the top of the hour.
SAFM, guiding you through the rush hour traffic.
Good afternoon. Starting off in Gauteng, the N12 R24 westbound in Bedfordview, slow moving on both routes towards Giluli's interchange. The N12 eastbound in Boksburg has a crash before Atlas Road, and the N1 northbound in Pretoria, slow moving towards the N4 Mbakwena Highway. In KZN, a crash on the N2 southbound at Umhlanga Road, the right lane's closed. The N2 northbound is queuing towards Umgeni Road, and Umgeni Road westbound, slow moving through Springfield Park. In Cape Town, the N2 outbound is slow moving towards Bunga Avenue, the M5 southbound slow moving towards Krombum Road, and the N1 inbound slow moving through Brackenfell. With your traffic update, I'm Irma G.
This is SAFM Sports with Tuming Khapele.
Right, so we were hoping that South Africa plays in the Cricket World Cup final on Sunday. That's not the case. Attention focus on local. The Nedbank Cup to me.
Absolutely. A very good afternoon to you, Ashraf, and our listeners. Well, Nedbank Cup quarterfinal action takes place this weekend with 4 matches deciding the semi-finalists. Tomorrow, AmaZulu take on Keswick Stars at 3 p.m. before Skukuni United take on Milford FC at 6 p.m. Sunday's fixtures see 2019 champions TS Galaxy face Jaxa Spears, and that's at 3, while the Manville Golden Arrows meet Durban City at 6 p.m. 3 clubs, Keswick Stars, Milford FC and Jaxa Spears, are appearing in the quarterfinals for the first time in the Nedbank Cup. Meanwhile, TS Galaxy assistant coach Bernard Parker says that the Rockets have been handed a rare opportunity in the Nedbank Cup following the early elimination of several traditional heavyweights.
We have done our homework as well as what they have done their homework, and we all know what can happen. And what has happened in the past within this Nedbank Cup. Also within the Cup, we're also well aware that we've got a strong possibility to go all the way to the final. Reason why is that we all know is the big teams has been surprised, and we also don't want to be surprised as well from the opponents that you're going to face. But right now the focus is on Jaxa Spears this weekend, and the main focus is for us to make sure that we get the team back to our performance stage what we want.
Moving on to rugby, Springbok coach Rassie Erasmus says that he is satisfied with what he achieved during the team's first alignment camp of the year, which ended yesterday. Erasmus says that he was especially pleased with the energy and enthusiasm shown by the 11 uncapped players who attended their first Springbok alignment camp. And he says that even though not all of them will get a chance to play this season, the experience remains important for their development. The Springbok coaches will now hold a virtual alignment camp with 21 overseas-based players. A second alignment camp will take place in Cape Town in May, and that will be followed by the first official training camp in Johannesburg in June. In terms of tennis, 7-time Grand Slam champion Venus Williams was knocked out of the Indian Wells, losing in 3 sets to French qualifier Diane Parry. The 45-year-old, playing on a wild card, fought back to level the match, but Parry surged through the decider for a 6-3, 6-7, 6-1 win. While she remains winless in 2026, she has declined to comment on speculation about a doubles reunion with her sister Serena. Ending things off with motorsport, home favorite Oscar Piastri thrilled fans after setting the fastest time in the second practice for the Australian Grand Prix today. The McLaren driver clocked a best lap of 1 minute 19.729 seconds around Albert Park circuit, finishing just 0.2 of a second ahead of Kimi Antonelli and George Russell of Mercedes. The Ferrari pair of Lewis Hamilton and Charles Leclerc were 4th and 5th fastest during the session. On that note, it's a wrap from my side for now. I'll have more in the next hour.
Thanks for that, Tumi. Hey, listen, Tumi, I have to ask you this quickly. A year ago this time, your enthusiasm for Lewis Hamilton was immense for the season. Does that still hold?
Not on the same level.
Well, says it all. Thank you. Goodbye. Yeah, more sport in an hour.
Hi, I'm Khomotso KG Mweketi, and I believe in music's ability to connect, to heal, to remind, and to bring joy. And each week on my Saturday and Sunday show Seasons, right here on SAfm 104 to 107 nationwide, I endeavor to do just that. So join the movement of Seasons every Saturday and Sunday, 10 a.m. to 1 p.m. It's addictive. You might invite a friend. Seasons, only on SAfm 104 to 107 nationwide, with me, KG Mwekezi.
Ashraf Garda on the National Pulse.
Right, we will have an update on a prayer session that links to the miners that are still trapped at the Kapa Minerals joint shaft just now. We'll do that in a few minutes, but in the meantime, let's pick out some WhatsApps from you, because there are many comments from you via WhatsApp voice notes. So here's one about the lawyers.
Afternoon, Ashraf. OJ from Severske. Ashraf, I'm now becoming worried. It looks like now the cans of worms have been opened. Lawyers are now coming to Madlanga to come up with ways to turn over the rules of the commission to suit their clients. That cannot be accepted at all. I mean, the time that their clients connived with the top brass of the SAPs, were they not thinking that it would ultimately come up to this far? No. Let them testify. Let them testify. How can I be?
In fact, to be clear, they're saying the client's going to testify. The question is in public, in camera. That's really what's being debated right now. Okay, right. There's more. There's naturally a lot about Karim and what that position is.
Good afternoon, Ashraf. To me, it seems like Mr. Karim doesn't want to give his testimony. He's been ducking and diving the whole morning. He must just give his testimony and see where things go. Thank you. It's Osborne from GQ. It's my first time.
Okay, first time. Welcome to the show. Make it a habit, right?
Ashraf, good day, brother. Great show as always. Ashraf, it's Fangalonka here. I want to find out what's the difference between in camera and actually going to the commission, because at the end of the day, he's going to have to answer questions, whether he does it over the phone or on camera or at the commission itself. Why would he not want to go to the commission live and do things on camera? Could you just clarify that for me, please?
Okay, my understanding, it's an important one. In camera, on camera. In camera, in person. In camera means effectively off public camera. So they'll be recorded in camera away from the public glare, which means the media and all of us will have no access to that. That means what we now see, listen on radio and see on TV, for example. Maybe radio may be different. We'll not be able to see him. And the reason is they're saying there's a threat in terms of threats he's received. That's the difference. So you'd not be able to get the wall-to-wall coverage that you'd get, but the actual testimony would be the same. The question is, does that make a difference in terms of how you come across as well? It may well be, as you've seen from examples of yesterday's Adoc committee, right?
Good afternoon, Ashraf.
Wait, yeah.
This reminds me of the Stalingrad tactics used.
In fact, wait, we played that already. My apology for that. We need to sort that out. Here's another.
Good afternoon, Ashraf. This is Salim from Durban. You see, the war is creating financial havoc for the global south. What it means now, the dollar is getting stronger, the rand is getting weaker, we're going to pay more for petrol, our cost of living is going to go up. At the same time, the American people's life going to get better, their prices going down. America doesn't have to buy oil. They will get it from or steal it from Venezuela.
Okay, I hear you. Yeah, we've had many like that, and I understand that. Let's do this now. Away from the war, we're going to pick up another issue, something back home that's really important around the miners that are trapped. Right after this.
Ashraf Garda on the National Pulse.
Right, so a prayer session took place earlier today in Kimberley by the Northern Cape government. That's for the 5 men that are still trapped at the Kapa Minerals joint shaft. It's always terrible when you hear stories like that, right? Because that's the human story. 5 members, family members, I understand, of the 5 miners were also present. Now, this is what we know. The men are presumed dead, right? After the mud rush of more than 2 weeks ago. That's what the assumption is. It's not we need to find out more. Therefore, the prayer sessions as well. So let's find out more about it. With me is Ulrich Hendricks, the SABC reporter covering the story in the Northern Cape. Ulrich, appreciate you joining us on the National Pulse.
Hi, good afternoon, Ashraf.
Thank you. Let's go back to how it all started. How did we get to a situation where these miners have been trapped down under?
Okay, so 18 days ago, so that is about 3 Tuesdays ago, at about 1 o'clock in the morning, there was a shift change, and then, the mud rush occurred. We not sure yet how or what caused the mud rush. That is still under investigation by the DMR and as well as the Geoscience Department. So the 5 men were trapped. We spoke to one of the former workers last week who were called in, just a couple of hours after that. And they went in, they started to pump water out. And he told us, as they started working, a second mud rush occurred. And they had to hightail out of that. So they had to run for their lives, basically, just a couple of hours after the first mud rush.
And just so we're clear, when we say mud rush, what does that mean?
So, Ashraf, that is just an insane amount of water coming through down that shaft. And I'm talking, when I'm talking about a lot of water, I'm talking about massive amounts, volumes of water. The water can basically move those big machines that are used in mines, and we're talking about 890 meters down. So that water, the pressure of that water, the volumes can basically move things as big as a TBL. And that is the water that went into that shaft and closed it. So since then, they've been trying to pump the water and the mud out of there. They had specialized proto teams, they call them. There were some that came to help from other mines as well. So they've been pumping basically 24/7. They are telling us, or the DMR, the update we got today from them is that, they've reached where eyewitnesses at that stage said the men and the machines were. Unfortunately, there is no sign of them at this stage still. And so, but they reckon that is because of the push of that water. So it basically just pushed everything away from where it originally was.
Mm-hmm.
So no signs of life, no signs of the men, and no signs of the machines where they are supposed to be.
So well, thanks for clearing that up. Let's then talk about the prayer session today. I mean, tell me the nature of it, and as you talk about it, is it done on the basis that these miners have passed on, or is it done on the basis of praying, hoping that they would have survived?
I think the objective from the Northern Cape government was to give reassurance and to give comfort to the families of the 5 men that are trapped. They are presumed dead in terms of from the government side, but also from Ekapa mineral side. So, just the force of that mud rush and the days that have passed, it's 18 days, the men, by all accounts, didn't have food, didn't have water. So just the passing of the days already says that, there's very little chance that these men are still alive. The family representative who spoke at the press session, Anki Kriya, during her speech, she basically, very emotional, obviously, but basically saying that they still believe that the 5 men are still alive, that they are hoping that they, sort of found a nice, safe cabin or a place where they could hide out for the past 18 days. And so there's still hope, from the families that until they see bodies, until the men are extracted from there in black bags, that they will continue to hope that they are still alive.
Yeah, I think that is completely understandable, right? What then was the nature of the prayer session? Can you tell us more about that? Who led it and what came through?
So the Northern Cape government basically led it. They had services of choir, they had services of a preacher who tried to give comfort, obviously. But also, Ekapa applied for liquidation of the mine. So the 1,200 workers who work there didn't get a February salary, and the 5 men, of the families of the 5 men who worked there, who were still trapped, did not get any money for February. And so the provincial government gave or donated 10,000 rand to the families of the men trapped still there, as well as 3,000 rand in food vouchers to the 1,200 former miners or workers at Ekapa. So just to give immediate relief, because these people who did not get a February salary, and they're not sure with the liquidation process still underway when they will get another paycheck.
Okay, what happens next?
So the retrieval or rescue operation still underway. It is still officially it's a retrieval operation that's underway. DMR told us that they are hoping that in the next day or 2 they will reach the men, and whether or not they are still alive or dead, we will see once that operation comes to fruition.
I see. Let's leave it at that. Ulrich Hendricks, a really sad, tragic story indeed. Ulrich Hendricks, the SABC reporter, covering the story in the Northern Cape of these 5 miners that have been trapped at the Kapa Minerals joint shaft. Well, as you've heard, over 18 days now. So over 2 weeks, well over that, and unlikely to have survived. Hoping, praying for a miracle.
The Bavarians are loving life at the summit and are highly spirited to keep their grip on the top spot. Standing in their way are the foes, eager to climb the table and spoil the party. This is the Bundesliga. Football as it's meant to be. Do not miss Bayern München versus Borussia Mönchengladbach on Friday, 6 March at 9:30 p.m. Live on SABC Plus and SABC Sport on DTT Channel 4. Proudly brought to you by SABC Sport.
For the love of the game.
This February, fall in love with the shows that bring us together on Saturday nights. First, sparks, surprises, and second chances at romance. Farmer Wants a Wife US, where real love grows in the most unexpected places. Saturday at 8:30 p.m. And before the love story begins, the stage lights up with pure talent and big league dreams. America's Got Talent Fantasy League. The world's best acts battling for the ultimate bragging rights. Saturday at 7:30 p.m. 2 shows, one unforgettable Saturday. Only on S3. Open up.
As we celebrate 90 years of existence, SAFM takes you back to the voices that shaped a nation.
Now leave the SABC and see the tower block lit up, 27 stories of light. Move from Auckland Park into the shadow of the Hillbrow Post Office Tower.
This is the English service of the SABC. Here is the news read by Patricia Carr. A member of the Planning Committee of the President's Council, Mr. Nick Turnich, has been appointed chairman of the Council's Community Relations Community.
90 years of trusted voices. This is SAFM. You're listening to the National Pulse on SAFM. SAFM.
Right, so we'll take more calls just now. And a reminder that being a Friday, we have the Fireside Chat coming up just now. My guest today is Pandelani Mefolo-Vordwe. He's the co-founder, one of the co-founders of the Black Consciousness Movement, former deputy president of AZAPO. Looking forward to that conversation. In the meantime, so Madlanga adjourned until Monday. What actually happened today? Let's really understand it. Key to that was the application by the Northwest businessman, Suleiman Karim, who really appealed to have his appearance at the commission to be heard in camera. So what does that mean? Andy Mashaile, security strategist, ex-co member of the International Cyber Security and Investigations Committee. With us, Andy, good to connect with you as always. Hi.
Good afternoon to you, my brother, and to the production team there with you.
Thank you. Right, so I was asked by a caller just now to say explain camera or no camera. Let me leave it to you so that I'm right or wrong. What does that mean when a person says request for on camera compared to what we've experienced now? What's the difference?
In camera means he is not in front of the camera. He's somewhere at an offside and you can only hear his voice. On camera means he is seated right there where you and I always watch these guys, the brown Mokhotis of the world and all others that they have come up and we have seen them. That is the difference between the two.
All right. And my understanding is that in being in camera, so we'll hear the voice, the actual proceedings will continue as normal. But that means that, are we saying therefore the councillors will not be with him in person? They would be somewhere else. They would be at the Commission HQ, right?
No, when he is off-site, when we are only hearing the voice, the lawyers will be seated with him wherever he is. That would be the instructing attorney. The advocate would be sitting there at the commission's chamber at Project Mabandla.
Yeah,
like we have seen with witness F when he was off-site and we could only hear the voice, and he kept on getting advice from the attorney, and the advocate, the counsel was sitting in the commission's chamber at Project Mabandla.
And I understand. I mean, Karim's reason through his legal team was that he's received death threats. I mean, how compelling a reason is that?
You know, Ashraf, my brother, we sometimes have to make our own brothers feel uncomfortable. There is this notion that he will be number 3 of the witnesses that are killed. The kill rate is very high. Without substantiating and proving that the 2 witnesses, or Flam van der Merwe and Viandre Pretorius, were killed as a result of, directly as a result of him, Flam van der Merwe, testifying and Viandre having had to testify. I am not convinced, once again, Ashraf, that there is a link between the death of the 2 people and the Madlanga Commission. There are other things that they were doing that I don't want you and I to be involved in, of the Zamazamas and many other things that happened offside the commission, where the commission never influenced those processes. And for Ntate Karim to say he feels and he knows that he will be number 3 because of the kill rate of the commission is just a smoke screen. He doesn't want to appear before the nation to explain his involvement in the influencing, political influence and corruption and criminality associated with people like Ntate Matala in capturing law enforcement agencies. I fully understand the ire of Justice Madlanga by when he said he is ruling to the effect that that gentleman, Mr. Suleiman Karim, will appear before the commission. And like everyone else, there are those whose lives are more at risk. People like the Sinonas of the world and the Sibias of the world, those people that they might have offended, like Imran Bad saying General Sibia is lying and many of those things. Those people could be in a rough world.
Okay.
They could be the ones who could be targeting the Sibias of
All
the
right.
world.
So just
But
to
the
confirm,
Sibias of the
so
world
so
can-
Andy, to confirm now, I mean, of course, we had his legal team, Suleiman Karim's legal team today, trying to convince the commission chairperson that in fact they must go in camera. So we understand, and you've alluded to that. The ruling now has been made by the chair of the commission, chairperson Madlanga, that Karim's application must be heard publicly. So that's a ruling. But he'll provide the reasons on Monday. So whether he appears on Monday or not, we don't know, but he will appear publicly, right? And that's what you're saying, that in fact, I mean, do I take it that the commission chair had no choice but to do just that?
He had no choice, given the behavior of my brother Suleiman Karim, ducking and diving, going to court, applying, trying to stand down the subpoena and many of those things. The behavior, the pattern creates suspicions that the gentleman really doesn't want to appear. Hence, the decision that you will appear publicly and we will get to see you and know what you know when you share it with us. Us meaning the commission on behalf of the people of South Africa.
Okay. Just your last thought in terms of how has this week gone at the Madlanga Commission, as well as Adoc, if you have any thoughts on both of them?
Yeah, the ad hoc was very brutal and bruising. As of yesterday, this morning I went to bed at 2:30 a.m. catching up with Mama Sarah Jane Trent. And when you look at Paul O'Sullivan and being demolished to an extent of being forced to tender apologies and being cornered with regards to his involvement as a complainant and investigator in General Pasani's house issues and corruption issues as alleged. And both you and I are not saying when people like General Pasani have done wrong, they must be covered. Like we have seen the portfolio committee taking, the Adoc committee taking Mr. O'Sullivan's testimony apart. We are saying those who have committed wrong must find their day in court. Things must happen the correct way, and the processes must be clean and straight to the point. There must not be any satanic or demonic influence, as we have seen that there was demonic intelligence gathering to an extent of using Mama Sarah Jane Tran, not knowing at that tender age, not knowing what to do, given what she has said that that gentleman was a bully. Fast forward to Madlanga Commission, having seen Richard Shibiri coming through and testifying, it was shocking and disappointing for the concession or for conceding that he received 80,000 rand loan and deposited that into his son's account after requesting Tate Matlala to reverse the money that he had deposited into his personal account. Suspicious, but understandable that even if it might have been a proper loan, you would not want to have received that loan from a person who's suspected of criminality. The second point.
Okay, very quickly, just in 30 seconds, we're on to news. Go ahead.
Knowing that Tate Matlala is suspected of criminality, there is no reason for a general to have requested assistance from that man.
Okay, that's where we can leave it. Appreciate your time as always, Andy Mashahila. Thank you for that insight. But there you have it then, with regard to Suleiman Karim and whether he appears in camera, on camera. Let's get the news. Here's on Dela Mbana. It's 4 o'clock.
Thank you, Ashraf. On the top stories, Ramaphosa shows no objection to removal of Khampempe and US asks for Ukraine for assistance. For SAfm News, I am Ondela Mbana and a very good afternoon. President Cyril Ramaphosa, in papers before the High Court in Johannesburg, says he does not object to the court ordering the removal of retired Justice Sisi Khampempe as TRC inquiry chairperson. Ramaphosa says had he been aware of the allegations against Khampempe, he would not have appointed her. Former President Thabo Mbeki and former President Jacob Zuma have turned to the High Court to review Khampempe's ruling, which refused the pair's application for her recusal, citing an apprehension of bias due to her previous role in the initial TRC. Papers reveal that President Ramaphosa asked the Minister of Justice to approach Justice Khampempe to consider standing down in light of the controversy around her appointment and the damage to the public image of the commission. However, Khampempe declined. The Northern Cape National Prosecuting Authority has secured a forfeiture order in the Kimberley High Court against properties of a businessman in Kimberley valued at approximately 12 million rand. The assets are linked to funds unlawfully received during irregular procurement processes for personal protective equipment at the height of COVID-19 pandemic. The Provincial Department of Health appointed a company and its directors as a service provider under irregular circumstances from March 2020 to August 2020. Parliament has 2 years to amend the Value Added Tax Act following a Western Cape High Court ruling. This means that the Finance Minister will not be able to determine tax changes unilaterally. The development follows last year's budget process when Finance Minister Enoch Godongwana proposed raising VAT from 15% to 17% before later revising it to 16% in the second budget attempt. This triggered legal action from the DA and EFF, who argued that the can be no taxation without proper parliamentary oversight. The VAT hike was scrapped in the third and successful attempt to pass the budget. Partner at Deloitte for Tax and Legal, Severus Smuts.
And what the section determines is that if such an announcement is made, it's effective, but it has to be ratified by Parliament within 12 months. Now, I think in previous years, it wasn't really an issue because, I think that ratification was easily obtained. But I think we're in an era now where it's not that easy. We have the Government of National Unity. So in other words, it's not a done deal.
The South African Weather Service says residents in Gauteng should prepare for cloudy conditions with widespread showers and thunder showers today, with an 80% chance of rain across the province. South African Weather Service senior forecaster Tukelo Chilwane says the wet weather is expected to continue into the weekend, although the probability of rainfall will decrease to about 60% on Saturday and Sunday across Gauteng.
This weather is expected to continue to Saturday as well as Sunday. However, will only be under 60% chance of showers and thunder showers for the weekend. When we're looking at temperatures for today, we are looking at a maximum of 20 Johannesburg, maximum of 21 Vereeniging, and a maximum of 21 in Pretoria.
Ukraine's President Volodymyr Zelensky says the United States has asked for his country's support in protecting against Iranian-manufactured Shahed explosive drones in the Middle East. The BBC's Denny Aberhart.
President Trump once accused his Ukrainian counterpart of not having the cards. That, it would appear, was somewhat wide of the mark. Ukraine had to innovate to defend itself cost-effectively from regular massive Russian bombardments. Ukraine's designed relatively cheap but effective interceptor drones, fast-flying machines that ram into Shaheeds and Russia's home-produced spin-offs. Such technology and experience in using it would be of great value to nations defending themselves from current Iranian attacks.
Recapping the top story, President Cyril Ramaphosa, in papers before the High Court in Johannesburg, says he does not object to the court ordering the removal of retired Justice Sisi Khampembe as TRC inquiry chairperson. I'm Lambana for SAfm News 4.
In sports this hour, Blitzboks eye Vancouver success with renewed energy, and Mackenzie urges collective action to solving ticketing, traffic and crowd issues at SA Stadia. More details at 4:30.
SAfm, guiding you through the rush hour traffic.
Good afternoon. Starting off in Gauteng, the N1 northbound in Pretoria, slow moving towards the N4 Bakwena Highway. The N3 southbound in Spruitview has delays towards Leondale Road, and Winnie Mandela Drive southbound in Fourways has a crash before Leslie Avenue. In KZN, the N3 westbound slow moving between Key Ridge and Cliffdale. The M13 westbound in Cliff has a crash before Maytime Stores, and there's a stationary vehicle in the travel lane on the N2 southbound after Umgeni Road. In Cape Town, Main Road is slow moving through Cork Bay, Voortrekker Road eastbound slow moving through Maitland, and High Level Road westbound in Greenpoint slow moving towards Ocean View Drive. With your traffic update, I'm Irma G.
Stay safe on the roads. SAfm is with you.
This February, love the shows that keep you guessing. Every case tells a story. Every clue brings you closer to the truth. From shocking twists to unforgettable investigations, Homicide returns with seasons 3 and 4, where justice is hard-won and nothing is ever simple. Because loving what you watch sometimes means leaning into the darkness. Homicide seasons 3 and 4, weekdays at 12 p.m. only on S3. Open up. S3.
Bafana are preparing for the 2026 FIFA World Cup, which will be hosted by the United States of America, Canada, and Mexico from 11 June to 19 July 2026. Bafana will host 2 international friendlies against Panama on Friday 27 March in Durban at the Moses Mabhida Stadium at 7 p.m. and Tuesday 31 March in Cape Town at the DHL Stadium at 7:30 p.m. Tickets are available at Ticket Pro at 80 Rand for adults and 50 Rand for children under 12. For more details, visit safa.net and Bafana on X.
The National Pulse with Ashraf Garda on SAfm. You're listening to the National Pulse, weekdays 3 to 6 p.m.
So you know that in the past you have the finance minister deciding on raising VAT, which then needs to be ratified, we understand, by Parliament. But because up to now the leader, the finance minister, would be the leader of the political party that has the majority vote anyway. So any vote put to Parliament, they'll win it hands down. It didn't happen now because of the changes with the GNU and with other parties, and the fact that no one party has got a 50% plus majority in our country. So as a result of that, as you know, VAT did not increase Well, that whole issue was taken to court, and the court ruling now is declared, and this is important, that the unilateral powers of the finance minister to determine the value-added tax rate is now unconstitutional. Basically, bottom line, simply, finance minister, can you increase VAT? Sorry, it's not in my power. Go and check with Parliament. That's really what it is. Let's get reaction on this from the EFF, their national spokesperson. He's Sinao Tambo. Appreciate your time as always. Thanks for joining us.
Afternoon to your viewers, listeners, also.
Thank you. Right. I mean, I know that the EFF as well as the DA, in fact, both pushed for this Concord ruling. So this must absolutely thrill and vindicate your position.
No, we're absolutely thrilled. It's an affirmation of what we've been saying in the Standing Committee on Finance, the National Assembly, and as well as in the courts, that the principle must always be that there must never be taxation without representation. And this means that any legislation related to altering tax mechanisms in the country must be determined by public representatives who are elected by the people. And the executive should not have a unilateral power to declare whether to increase or decrease a tax or not. So it affirms that principle. And we're happy that the Western Court has agreed with us. And we think that first and foremost is going to bolster our court challenge around the increase of the fuel levy, which happened in 2025, because the fuel levy was increased under the same principles, where the Minister of Finance thinks that, had that power to make a declaration. And thankfully, the court found that Section 7, subsection 4 of the VAT Act is defective and is inconsistent with the constitution of the country and therefore invalid.
Okay, so therefore going forward now we know that VAT did not increase as was the original intention of the finance minister, just over a year ago. What, in practical terms now going forward, how do you see this playing out?
Look, we've been given 24 months to ensure that we correct the defect that is contained in the VAT Act, which is Section 7, subsection 4. And relates to that. So we are going to ensure that as the EFF, we lead that process and make the necessary amendments to ensure that all of our legislation is in line with the spirit and letter of our Constitution, which grants legislative powers to Parliament to make necessary legislative pronouncements and changes, not only limited to tax, but around various other things. I mean, for example, there's a bill the EFF is proposing around the Public Finance Management Amendment Bill, which speaks to regulating the ability of the Minister of Finance to take foreign loans from the IMF or the World Bank. Because as things stand, the Minister of Finance does that unilaterally. We've spoken a lot about how the President has unilateral powers to appoint heads of Chapter 9 institutions, to appoint the Chief Justice of the Constitutional Court. So there's many things that are defective in our laws that give the executive too much power and crosses the line between the legislature and the executive. So we're going to continue to pursue those mechanisms.
Well, I mean, that's precisely the point. So having sorted out the VAT issue, I would take it you are sufficiently empowered now to pick up on all the other issues that you've just mentioned, right? And actually go for each one by one.
Absolutely. It sets a good precedent. So later in this year, our challenge of the fuel levy increases, which were implemented last year, will be had. But not only those challenges, but also we want a declaration by the Constitutional Court on the invalidity as well of the act that empowers the Minister of Finance to declare increases of costs of fuel as he sees fit. So hopefully we'll succeed there, because if we thought VAT is a challenge when it comes to the purchasing of food, fuel affects all goods and services. Goods must be transported and those sorts of things. So it can't be that it stands in that way. So we're happy that this declaration sets that precedent.
Okay. I mean, I would think that people listening in here, part of the National Pulse and SAFM community, would be thrilled by hearing what they've just heard. Others would have been paying at least 2% more VAT already, as you know, right? But is there any downside to this? I mean, meaning when a minister gets appointed by the president gets appointed by being the majority of party or the majority supported party. Is there a downside where their wings are clipped?
I think there shouldn't be a downside in a democracy when you're being forced to be consultative and adhere to democratic processes. So no one should desire for unchecked power. The EFF as a political party, for example, desires to be in the executive at one point in time. We desire to have certain powers. But this shows you that even though we have that desire and we're confident that we will one day occupy these positions of power, we don't want to have unchecked power, because unchecked power is dangerous and can compromise the lives and livelihoods of many South Africans. So anyone who is a democratic person and abides by our Constitution should not feel threatened by having mechanisms to hold them accountable and mechanisms to be consultative whenever they make laws.
Okay, no unchecked power is what the EFF says. It's what Sinawa Tambo you say. But now we also know, in fact, it's what the Concord tells us in terms of their ruling as well. So much appreciate your time. Thanks for joining us here on the National Pulse.
Thank you very much.
Thank you. So there we are. A significant position there with the court ruling against the finance minister deciding on VAT. It has to be effectively debated and approved by Parliament, which means a whole lot more consultative than it ever has been up to now. What do you say? Yay or nay? Sure, it's got to be a yay, right?
Ashraf Garda on the National Pulse.
Interesting, we often get asked about the position regarding the Madlanga Commission and the Adoc committee, and I asked you about it as well to say which one do you get the thumbs up? Like which one for you really works? Now, I thought I'll pick out a tweet from the journalist Max Duprio, and he said the contrast between the Madlanga Commission and the Parliamentary Committee is stark. Too many MPs are using the live broadcast to grandstand and promote their own party's interests. They try to score cheap points and humiliate some witnesses instead of focusing on finding the truth. And I thought the comment from Shireen Singh in relation to that is also telling, saying that is how they behave in Parliament generally. Okay? And then Charles de Villiers saying, I'll say it again, Madlanga Commission looking for facts, Parliamentary Commission looking for vibes. So I'll just put it out there. What do you make of all of that, right? Now, let's just pick up on another important point, because, of course, we know the Madlanga Commission postponed adjourned until Monday. So let me remind you what was discussed in today's Madlanga Commission session. And here's the evidence leader, advocate Adila Hassam, explaining.
Then that the facts here don't warrant an in-camera application. The applicant brings the application on the basis that he fears for his safety. In fact, he goes further than that. He talks about the safety of more than 1,500 employees. He says, if he testifies in public, that's the risk. He's also referred, apart from the threats that he's received, he refers to the backdrop of 2 witnesses, but we've now covered that extensively this morning, and it was 1 witness that was killed. The second, Mr. Pretorius, was not a witness before this commission. And of course, the investigation is still ongoing as to the circumstances of the assassination of witness D. And so that's been covered again extensively. I'm not going to get into detail about that, but it is important again in weighing up what this application rests, the grounds upon which this application rests.
Okay, that's it from Adila Hassam. By the way, having the chat with Andy Mashaile earlier, I mean, how convincing is he in terms of what he told you? But I hope you get that, the in-camera and on-camera. So in-camera, sound only, he would be somewhere else, not even in the same auditorium as we would get used to with others. And then on camera is what we see at the moment. He's with a full house, full crowd, everybody is there. And of course, it's also broadcast via media across the country, effectively across the globe. And that's what he was trying to avoid. Okay, let's get to further comments from you.
Afternoon, Ashraf. I really picked it up from the onset that these ones, their intention are clear, is to discredit the commission. And what is happening is that this man, Karim, has a lot of money, and he's using the power of that money to distract the whole mission of the Constitution. Thank you.
Okay, there we are. Money, distractions.
Yeah, Ashraf, now we are sitting here listening to Karim's lawyer trying to protect or to talk on behalf of him that he be protected. Oh, yes, be questioned in camera. So it's actually his right, Karim, to give testimony under in camera. That's his constitutional right. Thanks, Willie and Kuma.
Okay, is right, but I mean, he can apply. It's also the commission's head to decide whether to allow it or not.
Afternoon, Ashraf. I just want to ask if anyone knows the feedback or the report back from the People's Dialogue. The last time I saw it on TV, it was the opening. And there was a lot of money invested in that. What happened?
I promise you we need to find out. You're right. I mean, look, there was the opening, August, wasn't it? Then you had, in fact, there were people appointed, right? There was this prominent, eminent persons group, but there were others who were also appointed to now do the tasks. And that was around maybe November-ish, I think it is. But I can tell you since the turn of the year, I haven't heard anything. Have you?
Afternoon, Ashraf. Ashraf, it's clear now, Madlanga is getting closer to big fishes. That's why you see how the counsel for Mr. Karim is behaving. It's getting closer to where we want more info. We'll get more details of what has been happening. Hence this fight. I think Madlanga is doing a better work than our investigators. This commission is going to assist a lot. Zee from Bloemfontein.
Okay, getting closer to the big fish, yeah?
Hello, Ashraf. For me, whether this guy testify in camera or not, it will make no difference, because those who are threatening him will know that he went to the commission. If he testify in camera, it will make no difference, because they will take it as a fact that he did mention them. Maybe he will not, or he will mention them, but it will make no difference. They will go after him, whether he went on or to the commission or not. That's it, Ashraf. It's Kesha here in Durban.
Okay, thanks
My
for that.
first time calling your show.
Welcome to the show. Thank you. Thanks for joining in. Well, I hear your point, and I think it's an important point that you make as well. So thanks for bringing that up, right? We'll get more comments from you right after this.
Get Spar Super Savings at every store, in every aisle, every day. Like 2-ply Spar toilet rolls, 18s for $94.99. Save 25 Rand. Or Huggies Dry Comfort Nappies or Nappy Pants, Jumbo Pack, including Gold Value Pack. Buy any two for 320 Rand. Save 64 Rand. Now that's super savings. Price is valid from the 23rd of February till 8 March, while stocks last. Only at Spar. T's and C's apply.
This February, fall in love with food that tells a story. From bold new culinary stars to untamed destinations and unforgettable flavors. Gordon Ramsay brings passion, pressure, and purpose to your screen. Gordon Ramsay Uncharted, Sundays 5 p.m. Only on S3. Open up.
Ashraf Garda on the National Pulse.
Yeah, I think that point that we've heard, which is whether he's in camera or not. I mean, people who know him, right? They know exactly. In fact, I mean, we saw him the other day. They know what he looks like exactly. So it's not about that, is it? And that's really what evidence leader advocate Adila Hassan has suggested in why it should not be in camera only. Calls from you. Let's talk about the miners, the tragic story. Babitseng in the Northern Cape. That's your region. Hello.
Hello, Ashraf.
Yeah, how are you?
I'm good, man. How are you?
Good indeed. What's your point?
My point is, I want to talk about the mud rush, these guys that are trapped. But I want to tell you up front, I've worked in those mines. In fact, I did develop one of those areas. I remember with the BS, there was a level which they called 410, which had water, a lot of water. Whenever we take out the ground, whether LHDs, these machineries, it was always wet. So at the start of the shift, they would pump out the water. So it was not safe. So the bears decided to seal off that cage. There was a lift that will ferry us to that level. They sealed it off, and then we went to an area which was 870, just to catch that amount of ground that we left behind.
Yeah, sure.
But now, the mistake that we did was they didn't left an opening so that an operator can access that area and go and start the pumps to get rid of the water. So what happened, the diamonds of that area that we left behind, they were beautiful diamonds. Their color was about, blue and white. The redder the color, the more expensive the diamond.
Mm-hmm.
So what happened is, then we developed something like, we call them drifts, 15 drifts. 2 years into those drifts, we finished the drifts, and then the mud came out. And then when mud rush came out, it came out to drift number 1, 2, and 3, which means the area that was above, we did not leave somebody, the base did not, it sealed everything. So there was no access to that area 410. So from 870, so that water came out, which now created into mud. And then when that ground falls there in that 410, it came down, and then we just saw it coming out at 870. And so now, when it came out, we would wait for something like 2 months so that the water should be drained out. We should drain water, and then we can start, because it's going to get dry, and then we start mining that wet ground
Well,
out.
look, thanks for sharing that with us.
I want to tell you exactly what happened. The day when they reported that there was mud rush, people were trapped, I knew they were dead. I knew from day one when they reported they were dead, those people. Those people, there is no hope that those guys can be found on day one. Now they're telling stories that, no, there is hope that those people can be alive. Those people could only be alive when there is loose ground that came down, where you can communicate and make an opening, and you put compressed air there so that you can communicate with them whilst you try to
All right, so just a final point. I do need to move on, Babi, saying just a final point in one line, one final comment.
Come on.
I said make one final comment in just one sentence. I need to move on, yeah?
The thing is, those areas were sealed, Ashra. There is no when they are battling now to go to an area where those people, where the mud rush came out and closed up where those guys were working.
All right.
Because as a miner, before you can go a step or 2 meters to it, you need to make the area where you are standing safe. That is what they are battling with.
I understand.
Because their area was sealed and they went and opened it. I don't know. There should be an investigation anyway about this.
I'm sure there will be. Babi saying thanks for that. And of course, I think your personal testimony is so telling, because you're not speaking from the outside. You're very much on the inside. You understand it. So thank you for sharing that with us. But a tragic story all the same, right? Sibongile in Soweto, hello.
Hi, Ashraf. How are you?
I'm good indeed, right? What's your point?
My point is the national dialogue. I hear one guy speaking about what happened to the national dialogue.
Yeah.
Yes, as we speak, there is a session that is happening around in Pretoria where the steering committees are meeting for strategies, to strategize. It's on. The first one was in January, because there seem to be a lot of problems regarding the election of steering committees. So I think they have ironed that one out.
Okay.
So there's a lot of preparatory happening in the national dialogue as I speak, because I'm also part of.
I see, but I mean, do you agree? I mean, so I'm right from the eminent persons to the steering committees. Now the real work happens at community level. But do you agree there's been an absence of public communication around that? Like, that is why people are asking what's happened to it. Lots more needs to be done. We need to know, even if they're doing things behind the scenes.
Yes, I think for now that is the strategy, because now it has to go to the ground also. So that's why people are asking. So that is the part where I am part of, as saying that the strategy is about now how do we go about and let people know what's happening. So this is the first phase of happening. This is the second strategizing meeting. Then I think after this, it will go to the ground. People will know about it.
Okay. Well, thank you for clearing that up, Sibongile, and best wishes with your work as part of that those committees, right? Charles in Mokopane. Hi, Charles. Charles, how's it, man? Charles?
I'm good, man.
Yeah, go for it.
Let me just quickly go for it, my brother. Man, I will celebrate half-heartedly the sentencing of Vincent Smith.
Yeah.
In the light that Vincent Smith's transgression was identical to that one of Mantashe. They both received a security upgrade, but Mantashe's case was discussed at some integrity committee that lacks integrity and some other forums, and then it was brushed under the carpet. It shows that some animals will truly be more equal than others.
But if you're saying it's identical, and I hear you, then what stops anybody laying a charge against him?
I beg your pardon?
If you're saying it's identical, what stops anybody laying a charge if it's all about corruption and bribery?
The very same charges that were laid against Vincent Smith, why should Mantashe have special charges laid against him? Because he's a wonder kid of certain people who are benefiting out of his generosity, perhaps maybe in the mining industry.
Okay, that's your perception, right?
That's my viewpoint.
Okay,
yeah.
Got that, Charles. Yeah. Charles in Mokopane, thank you for that. The special kid of the ANC, Grady Mantashe, according to Charles in Mokopane. Right, we're going to have more calls. Let me tell you, someone said, who is the guest today? The Fireside Chat guest today is one of the co-founders of the Black Consciousness Movement, a former deputy president of AZAPO, and I'm talking about Pandelani Nefolovodwe. Looking forward to that conversation with him. He also talks about what is called the Codessa betrayal. Goodness, man. I need to ask him about that. 4:30. Here's the news headlines.
Thank you, Ashraf. On the news headlines, former COPE leader Musiwa Ligota will be honored with a special official funeral Category 2 next Saturday. President Cyril Ramaphosa has also ordered that flags be flown at half-mast at all flag stations from tomorrow until the day of his burial. Recent good rains in the area of the Guardian Route town of Knysna, together with the repairs of water infrastructure, have slightly boosted water capacity in the town. And Jamaica has ended a 50-year agreement with Cuba, which saw healthcare workers from the communist country fill gaps in its healthcare system. A full update follows at the top of the hour with Greg Hose.
SAFM, guiding you through the rush hour traffic.
Good afternoon. Starting off in Gauteng, rain recorded across parts of the province, so reduce your speeds and drive with absolute care. The N14 southbound in Centurion is queuing towards Brakfontein interchange, and the M1 northbound in Braamfontein slow moving towards Carr Street. In KZN, the R102 southbound queuing towards the M25 Commercial Highway. The N3 westbound is slow moving between Key Ridge and Cliffdale, and a stationary vehicle on the N2 northbound after Commercial interchange. In Cape Town, the M5 northbound queuing through Koeberg interchange. Robert Sobukwe Road in Moderdam is where a crash is reported at 35th Avenue, and Robert Sobukwe Road southbound in Belleville South is where a crash is reported before Symphony Way. With your traffic update, I'm Irma G.
This is SAFM Sports with Duming Khapele.
So, Jimmy, they do say that Cape Town and Vancouver sort of resemble each other. And I'm just saying that because you want to talk about the Sevens, and it's happening in Vancouver.
Yeah, definitely. The Blitzboks say that they want to create special memories at the Vancouver Sevens tournament this weekend as they continue their strong 2026 HSBC Sevens campaign. Head coach Philip Snyman says that the team is confident after good preparations. However, he has warned that their pool opponents, Great Britain, Spain and New Zealand, will be tough competition. In football, Minister of Sports, Arts and Culture, Gayton McKenzie, says that there's an urgent need to get to the bottom of the ticketing, traffic and crowd control challenges at the FNB Stadium. McKenzie, who was among more than 101,000 spectators inside the 94,000 capacity venue during last weekend's Soweto derby, says that the situation cannot continue as normal. Concerns around overcrowding at the stadium have been raised since last year, when more than 110,000 fans attended another derby between Orlando Pirates and Kaizer Chiefs.
Then we look at the ticketing system. It's a mess. You get to your seat, somebody's sitting at your seat. You can be stabbed by telling a person. He'll tell you like, "Hi, he's drunk that time. You are not a violent person." So we must be honest about these things. No, we mustn't just, we need more security. You know, I went to watch many years ago, I think 2003, I went to watch an Arsenal game. And when I came, somebody was sitting on my seat. It was with Charles. And somebody was sitting on my seat in 2003. I said, "Hey, brah, get up." Charles like, no, gee. At that time, I was fresh from jail. And then Charles said, "Security?" The security came and said, "Sorry, can you leave?" You must look for security sometimes. We need to change it. We have had the Orkney massacre. We have had the Ellis Park massacre. It was Chiefs and Pirates game. Are we not a learning people? Have we not seen enough? People have lost their lives. This year we're commemorating those lives. So I'm saying to you that our intervention is going to be painful. It's going to be very strict. It's going to be intentional, and it's going to be results driven.
Still staying with football, Kaizer Stars head coach and co-owner Bucks Mtombeni has reflected on the club's strong run in the current Nedbank Cup campaign and believes that the results are good for the brand on and off the field. The Believers, as the side is popularly known, are one of the 4 lower division teams competition and play top flight side Amazulu FC in the quarterfinals this weekend. When the two teams lock horns at Moses Mabhida Stadium in Durban tomorrow, Mtombeni says that they'll be looking to write a new chapter in their book. Elsewhere, Manchester City have been boosted by the return of Nico O'Reilly for the side's clash against Newcastle in the FA Cup. O'Reilly missed Wednesday night's draw with a knock that forced him off against Leeds last weekend, with Erling Haaland returning to action against Forest after missing the win over Leeds. It means that Manchester City are almost at full strength ahead of the cup tie. In golf, South African golfer and member of the Southern Gods GC, Dean Burmester, has welcomed the weight that comes with leading the team at Live Hong Kong. Round 1 yesterday at the Hong Kong Golf Club saw some exciting action as Spaniard Carlo Otters of Talk GC topped the leaderboard at 10 under par 62, with Burmester just 2 shots off the pace in second. The two-time Live event winner is carrying the SGGC teammates Louis Oosthuizen, Charles Schwartzel and Brendan Grace into day 2, but is very confident that his promising run can inspire his brothers to improve their scores today. In cricket, India face New Zealand on Sunday, looking to become the first side to lift the T20 World Cup for a 3rd time, but under huge pressure with the weight of a nation on their shoulders. Standing in the way of the Indian side are a team who have already upset the odds with a thumping 9-wicket win over previously unbeaten South Africa to reach the final. New Zealand believed after Finn Allen's record 33-ball century in the semi-final in Kolkata that they are very capable of taking down the hosts to win their maiden T20 World Cup title. Ending things off with motorsport, Aston Martin chief Adrian Newey admits a vibration issue with the team's car is sucking all energy out of the operation, leaving Fernando Alonso in a hard mental place. The newly designed machine has been plagued by reliability problems with its Honda power unit, causing mirrors and tail lights to fall off and raising fears of nerve damage for drivers. After just 3 laps completed in first practice of the Australian Grand Prix, Newey said that there was no quick fix and revealed further battery failures could sideline a car. I'll have more on other sports in the next hour.
And just by the way, talking about sport, Patrice Motsepe is the boss of CAF, and he's made it clear in the light of what's been pronounced in the last few days, including, I think, a website in his support for the presidency of the ANC. He said he's made it clear that he has no desire to stand for the presidency of the ANC. I mean, the other one, picking up from what Gaten McKenzie said about the Ellis Park massacre, surely it's the Ellis Park disaster and not the Ellis Park massacre, isn't it? Big difference.
Hi, I'm Cindy Yankees. Watch me light up your screen only on SABC2, starting on the 23rd of February 2026. Catch Paradise Monday to Friday at 7 p.m. Live in every beat, the pulse of SA.
Usuthu are on a mission for a place in the semi-finals, while the believers are confident they'll secure their ticket to the last 4. In another sizzling encounter, Babina Noko are ready to sing their song of victory. But the Stallions are courageous to cause a major upset. This is the doubleheader of the Nedbank Cup quarterfinals, where pride meets ambition. Catch Amazulu FC versus Casrick Stars this Saturday, 7 March at 2:30 p.m. live on SABC1. Then, Sekhukhune United face Milford FC at 5:30 p.m. Both matches are available on SABC Plus. Also, tune in to SABC radio stations at 3 p.m. and 6 p.m. Proudly brought to you by SABC Sport.
For the love of the game.
When music meets nature, something unforgettable happens. Symphony by the Water, a world-class live music experience set against the breathtaking beauty of Midmar Dam, featuring the KZN Philharmonic Orchestra, Spogazi, the Black Lapels, Saturday, the 7th of March, 2026. Day tickets from 150, evening tickets from 350. Tickets available at WebTicket and Pick and Pay. Symphony by the Waters, where sound flows.
Economic news on SAFM. Facts and figures you can count on.
Tell you what, all I know is suddenly families are interested because of the prediction of a 90 cents price increase in petrol. Not today, but sometime soon because of that Middle Eastern crisis. Think about that. With me is Paswane Mpatlele, Senior Accounts Manager at Makwe Fund Managers. Paswane, what have you got locally and globally?
Good afternoon, Ashraf, and good afternoon to all your listeners. Not much good developments happening. We're a week into the US and Iran conflict continues. The Strait of Hormuz is technically closed. The shipping companies are suspending activities in the area, despite the US government offering guarantees to insurance companies. Oil prices are climbing higher, passing the key level of $83, up over 7% to $90 a barrel, and $100 a barrel is more likely to hit even this month, as market hasn't fully priced in the longer duration of this conflict, especially with the late Supreme Leader's son being a hardliner to have a higher possibility of taking over and increasing the conflict regionally across other countries, and possible ceasefire not taking place even by May. Yes, the big winners are the likes of Russia on set. We see they are benefiting from the fact that the US is granting countries like India to restart buying oil from them. Russia is also the biggest supplier of wheat and fertilizers, and they will be expected to explode in pricing. China is also well stocked up and we should survive over the next 3 months. South Africa, not so much when we talk about oil stocking up, and they're exposed to face the inflation risks for the most half of this year, and it will hit consumers at the second half of the year. On the data front, Ashraf, we saw the US labor indicated that they lost 92,000 jobs. Unemployment increased to 4.4%. 4%. The markets have therefore found a way to add more and one interest rate cut back onto the table, and this caps the dollar strength at 99.4 and eases the losses on tech and financials. Gold has edged up 0.5% at $5,100 an ounce. Global equities are under the pressure of the fact that with oil prices going to rise, inflation rising, consumer spending patterns will come under pressure. We see the UK's equities are under pressure. The likes of Nasdaq down 1.5, S&P now 1.4, Dow down 1.6. In Europe, everything is down. FTSE CAC DAX over 1.3%. Locally, we also got the pressure down 3% as the weaker rand is filtering through. Inflation risk pressuring that the sub might just not even cut rates for most of 2026. Financials down 4.7%. The resource sector down 3%. Industrials down 2.3%. The only gainers you're seeing even on the market are the energy stocks, Sasol, Tungela, and Renet up 5%. When we look at the rand, it is weaker. We're sitting at 16.76 against the dollar, 19.37 against the euro, and 22.35 against the pound.
Okay, perfect. Thanks for that. And you have a good weekend. And I think all of us collectively hoping there can be some reprieve regarding Iran versus USA and Israel, if for nothing else, because of how it impacts on you. Thanks for that, Paswane. Right.
Ashraf Garda on the National Pulse.
By the way, talking about that, so Donald Trump, yeah, you know Donald Trump. Some people say I'm too critical of him, unfairly so. Do you know yesterday he announced and he said, Cuba, you're next. Seriously. Donald Trump said, Cuba, you're next. Imboyiza in Pretoria, let's get your thoughts. Hi.
Ashraf, how are you?
I'm good indeed. What's your point?
I'm fine. My point is on the ad hoc committee. No?
Yeah.
You know, having had everything that has been said here,
yeah,
I came to a conclusion that in the entire country, no government employee was dealt with the way General Patlane was dealt with. Really. If maybe you have an answer for me, what is the problem that actually he is losing his cases in court? Are judges not listening? I mean, his rights were, or his lawyers, I don't know whether his lawyers are not bringing to the fore that this man's right has been trampled upon like no other employees in the history of South Africa.
So that's how you see it. But what is it that tells you that compared to anybody else? Because, I mean, there's been so much that's grey area, shady issues about so many relationships, employer-employees, not just in policing, everywhere else too.
The issue here, sorry for interjecting there,
Yeah.
the issue here, even if people now are raising the issue of the blue lights that actually he inflated the price, I mean, those blue lights, we haven't been told that those blue lights were returned back. The blue lights that he bought are still working today. How can they say that they are of the substandard when they are still using them even today? I believe, surely it is said, I don't know, maybe I would have been dead if I was Patlane, because, I mean, the man is having a big heart, but I feel very bad. You know, this man, in the literal sense, is a persecution in the literal sense. I don't know the man. I'm not related to the man, but I so wish that one day maybe the Constitutional Court will rule in his favor. No. You know what? It is unjustified that the person can be treated this way.
Okay, got that. Let's see if others agree with you, Imboyisa. Thanks for that call about being unfairly treated. What do you make of it? There's so much that's come through, and that's the great thing about watching both the Adoc Committee and the Madlanga Commission. Notwithstanding the point from Max Dupree to say there's a lot of party political posturing at the ad hoc because they understand the prominence they get. But leaving all that aside versus the Madlanga, which is very straightforward legalese, right? There's a lot that we can learn, and we are learning from how these people all come across, isn't it? Edward in Durban, hi.
Hello, Ashraf.
Yeah.
I'm a senior citizen. I'm in my 80s now, and I had occasion to learn and meet up with a lot of people who work in this shadowy world that we see in these two commissions. And this, as we see from all these like 8 or 10 people who have appeared, They live in this world of informants, bit of corruption, moles, sleepers, agents, double agents, and you can see through a lot of them. And the interest in body language, because it's a pity that experts in body language, their evidence does not result in a conviction in a court of law. But as for people sweating, drinking water, waving their hands around like mistress, it's very evident. But what comes across is these people who have graduated to top positions in government and in the police, there's not one of them who comes across with any sense of authority, like any kind of charisma, that sort of thing. They appear to be squirming. They take time to answer because they've got to defend themselves. And it's lots of things I could say. When we get on to, I'll quickly get on to Paul.
Okay, but very quickly, 30 seconds, please, right? Yeah.
Okay, Paul O'Sullivan quite possibly has connections with CIA and R6. He mixes with people in high places. 2 weeks ago, he sat for an hour with our Minister of Finance on a plane, picking his brains. And there we go. So there we go. That's all I'll say for now then, Usher.
Thank you for that, Edward, with that synopsis, really speaking, in many ways. There's more, right? So here's an important one.
Afternoon, Ashraf. Mama Baloy brings emotions into her arguments. She doesn't want to lose an argument. She always wants to be right. I think the guy has valid reasons for him to be in camera. He's not refusing to come. He's just saying he wants to be in camera because he fears for his life. You know, that is something that they should take into consideration and just allow him to be in camera. What is the issue here? I don't understand why they want him to be there so much.
But remember, I mean, I know we mustn't get our commissions mixed up. This is for the Madlanga Commission. For the Adoc, at one stage, you had O'Sullivan effectively saying the same thing, right? So, but the downside of that is, you know, are we suggesting that people who don't know Suleiman will now know him only because he's on camera? Meaning, those that know him, you think they would not know what he looks like?
Hey, Ashrat, you know, let me tell you, the finance minister, I think he was a bit off guard when he wanted to introduce VAT. I mean, as a former trade union, he wanted to plug the poor to be so poor again. These guys of the ANC, they are opportunistic. And I don't see him as proper and fit to be a minister of finance as such. Because if he was smart, he was supposed not to do that. Because a lot of the black masses will be more disadvantaged with that 1% diet.
Okay.
It's 500 in the East.
Well, first was going to be 2%, remember that. But do you think he can also make decisions on his own? I don't know. I mean, listen, there's him, there's the ministry, there's treasury, there's the president. There's no way he could go into a presentation and a budget speech literally, and the president has no idea what he's talking about, meaning that can't be a single person's call. Right, there's more. Let me just sort that out. There we are.
Ashraf, this is Ngonde. About the recusal of Sisinga Pepe, I would have thought, naive as I am, that because she once served in the TRC, therefore she's got institutional memory and she would be better placed to be the judge in this current form, right? Provided, of course, she's not biased, right? So for Thabo Mbeki and Jacob Zuma to insist upon a recusal, it would seem to me they are worried about the skeletons coming out. Thanks, Arhaf.
No, thank you. So is that how you see it? I wonder if others see the same way about why would they not want Contempt. There we are. Right, what about Madlanga versus Adoc?
Asraf, good day. You're speaking to Anonymous here from Cape Town. I just want to say the difference between the Madlanga Commission and the Adoc Committee, there's a big difference. You can see when professionals are doing their thing and when politicians are doing their thing. You can see the difference. The politicians is all about making their party look good to us as voters. And the Madlanga, you can see it's a professional setup. There's no chaos, there's no shouting, there's no pointing fingers, there's nothing of that regard. So you can see the big difference. It's more professional setup than sort of a Mickey Mouse setup that we get in the committee.
Okay, got that. But I mean, I hear what you're saying about the difference, and I also believe there's a lot of it where they understand that their party's stature is enhanced and their stature is enhanced by the questions they ask, which may not be the case with the Madlanga Commission, because they just get on doing their job. But are they not asking the questions that matter? Like, say, yesterday, are they not asking relevant questions at the Adoc? Surely they are, aren't they? Maybe you just don't like how they do it.
Good afternoon, Ashraf. First-time voice note sender. I love your show very much. Thank you for touching base regarding Trump and Cuba. He mentioned it last week, and the media is so quiet about it. And he mentioned it yesterday. So now it's like the world is just his oyster. He chooses which toy to throw around. It's so scary. It's scary in the world that we're living in. And I so hope our president do keep quiet, because we don't have the capacity to be dealing with Trump's tantrums. Thank you.
Well, thanks, and thanks for being the first-time caller. Make it a habit, and appreciate the kind words for the show. Thank you for that. Really much appreciated. As far as Trump is concerned, I mean, you're right. Can you just imagine another person saying that? In fact, Trump has been saying that, on the one hand, literally saying what he wants to say. And then, I have to say, Netanyahu has been saying that from Israel. And then some of his colleagues within Israeli the government. Very few other leaders from different political persuasions around the world can say what they say and get away with it. They can't. They just absolutely can't. And you wonder why. And then Trump made the point about Spain. Like, something, you want to side with us? Okay, you'll see. We won't do business with you any longer. I'm paraphrasing, but that's it. And then also knocking the British as well. Sure, man. Who's going to stand up to him? Should we?
Afternoon, Ashraf. This whole thing about the in-camera appearance. You see what will happen if they grant him to be not seen on live TV by everybody. Then all the witnesses are going to say the same thing. And also, whether he appears on live TV or not, if someone is threatening his life, why will they stop, whether he's on live TV or what? They know he went there. They know he's going there. So I don't see the difference. Whether he's on live TV or whether he's not broadcast live, there's no difference.
Well, in fact, that was the evidence lead, Adila Hassam's position. And then finally, that was the ruling from Judge Madlanga. So you guys are, what's the right word? You are aligned, right?
Afternoon, Ashraf. This Karim guy is such a fool and stupid. Doesn't matter whether he's going to appear on camera or not. The fact of the matter is that they know he's going to appear there and they know his voice. So to run behind being shown on the face is just a foolish idea. Must think before he speak. Aubrey.
Think before he speaks. And there's more. Let's see if I can pick out this. Maybe time for a few. Forget, Friday we have a fireside chat. So if you want to, well, in fact, we've got a flood of other comments. Let's see if we can pick it up here.
Hi, good afternoon, Ashraf, Nora in Heidelberg. My word, this guy has been trying everything, every trick in the book not to appear at the commission. Now we are really intrigued as to what is this all about. I mean, he went to the High Court to block his appearance there, which he lost. And then it was Ramadan. He asked for postponement for Ramadan, and he was given that. And then he had this contagious disease, which he had to isolate. And now this. I mean, when he went to the High Court, we all saw he was all over the TV. So why should they hide him now? I'm very interested what is going to come up of this next week, Monday. I might take 2 days off just to see. Have a good day. Bye.
Oh, are people doing that? Are you taking 2 days off? I mean, I jumped in an Uber the other day, and this guy was listening in to the Madlanga Commission of streaming live. That means he had it on his phone until I told him, hey, catch SAFM. It's like, oh, I didn't know that SAFM covers it. Of course we cover it. But like, would you get to that level of actually taking 2 days off just to catch all the drama? Sure.
Ashraf, good day, brother. Great show as always. Ashraf, it's Fagalonka here. I want to find out what's the difference between in camera and actually going to the commission, because at the end of the day, he's going to have to answer questions, whether he does it over the phone or in camera or at the commission itself. Why would he not want to go to the commission live and do things on camera? Could you just clarify that for me, please?
Okay,
Thank you.
Sorry, that one did not delete. My apology for that. But I think we've answered that as per the chat with Andy Mashaile. I mean, obviously, in camera would be, you just hear his sound. On camera, you see everything. He's going to be with everybody face to face. He's arguing that it's a threat. I think it's also a psychological issue when you're in person. I mean, really, just look at what happened yesterday.
Hello, Ashraf. This is Seppi. So happy Friday. I've been watching both parallel commissions, and I'm just going back to something that I mentioned, I think last year, that my fear is we are going to find that there'll be people who'll be coming in to distract us. And that's what exactly happened this week, especially with Adams saying all these things that some of them he could not even back them up with evidence. And I'm just hoping that at the end of the day, Ashraf, is that the truth is going to come out, and those who are responsible with murders and capturing the justice cluster would be arrested. That's what I'm praying for. And I really feel sorry for Sarah Trent. I really feel sorry for her, but kudos to Honorable James. That woman, she's my hero, especially in this month.
Okay, your hero. Point made. Let me stop there because we're going to get to the news. A reminder, we've got the Fireside Chat guest with Pandelani Mefolo-Vod. We're coming up after 5. Looking forward to that. It should be fascinating indeed. Right, here's the news at 5 with Greg.
Thank you, Ashraf. Lakota to be honoured with a special official funeral, and Jamaica ends healthcare agreement with Cuba. Good day to you. Former COPE leader Mosiwa Lakota will be honoured with a special official funeral Category 2 next Saturday. President Cyril Ramaphosa has also ordered that flags be flown at half-mast at all flag stations from tomorrow until the day of his burial. Lakota passed away earlier this week after a long illness at the age of 77. He was a struggle activist, the inaugural chairperson of the National Council of Provinces, the Premier of the Free State and the Minister of Defence between 1997 and 2007. The President has sent his condolences to his family and his political party COPE. His family's requested privacy. Lakota will be buried in Bloemfontein on Saturday next week. President Ramaphosa, in papers before the High Court in Johannesburg, says he doesn't object to the court ordering the removal of retired Justice Isikampepe as the TRC inquiry chairperson. He says had he been aware of the allegations against her, he would not have appointed her. Former Presidents Thabo Mbeki and Jacob Zuma turned to the High Court to review Kampepe's ruling, which refused the pair's application for her recusal, citing an apprehension of bias due to her previous role in the initial TRC. Papers reveal that President Ramaphosa asked the Justice Minister to approach Justice Kampepe to consider standing down in light of the controversy around her appointments and the damage to the public image of the Commission. However, she declined. RCL Foods has issued a recall of more than 35 of its pet food products due to a salmonella contamination risk. Among the affected brands are Canine Cuisine, Bonzo, Bobtail, Catmore, Optimizer and Ultra Pet Dog Food. According to RCL Foods, the contaminated pet food was stolen after being sent to a waste management facility east of Johannesburg. The stolen product may be contaminated, posing a risk to both pets and humans. Sachin Naidu reports.
In a statement, the company says it became aware that some products from a limited number of specific batches of condemned pet food which were dispatched for destruction at a specialist facility in late January and February were stolen and are being sold through unofficial sales channels in parts of Gauteng, in particular Germiston, Boksburg, Benoni and Alberton. Shoppers are strongly advised to only purchase pet food from retailers, pet shops and vets, as these products adhere to quality standards and are safe for animal consumption. Sasha Naidu, SABC News, Johannesburg.
Recent good rains in Neisden in the Western Cape, together with repairs to water infrastructure, have slightly boosted water capacity for the town. That's according to the Provincial Minister of Local Government, Anton Burdell.
Neisden's infrastructure is at a critical stage, so the province will lead the 154 recovery plan. We currently talking to national government to put a joint team together to support the municipality with their water, sanitation and refuge challenges. The consumption is currently at 11.1 megalitres per day, and we ask residents to use water sparingly.
Finally, Jamaica's ended a 50-year agreement with Cuba, which saw healthcare workers from the communist country fill gaps in its healthcare system. The move comes as the U.S. increases pressure on Cuba's neighbors to cut off cooperation. U.S. forces seized former Venezuelan leader Nicolas Maduro in a raid in January on his compound in the capital Caracas. Dozens of Cuban troops were reportedly killed in the U.S. raid. The top story, former COPE leader Mosiuoa Lakota will be honoured with a special official funeral Category 2 next Saturday. That's SAFM News. I'm Greg Cos.
And in your sports, the SAWA Nedbank Cup quarterfinals take centre stage this weekend. Erasmus pleased with progress made at first Springbok alignment camp and India T20 World Cup final. More details at 5:30.
SAFM, guiding you through the rush hour traffic.
Good afternoon. In Gauteng, the N1 northbound in Midrand, slow moving towards Samrand Road, the N3 southbound in Germiston, slow moving towards Geldenhuys interchange, and the M1 southbound queuing towards Omonde. In KZN, rain across parts of Durban, so please reduce your speeds and drive with absolute care in these affected areas. On the N2 southbound in Isipingo, there's slow-moving traffic towards Joyner Road exit and the M4 southbound queuing towards Virginia Airport. In Cape Town, the R300 southbound slow-moving towards the N2 highway. Valhalla Drive is where a crash is reported at Angela Street, and Viking Way westbound in Epping, queuing at the N7 Jakes Gerwel Drive. With your traffic update, I'm Irma G.
Stay safe on the roads. SAFM is with you. This Human Rights Month, we commemorate a significant milestone, the Bill of Rights at 30, making human dignity real. For 3 decades, South Africa's constitution has been a beacon of equality, freedom and justice for all. Yet dignity is not just written in our constitution, it must be lived, protected and upheld every single day. Join SAFM as we unpack the issues that matter, elevate voices driving change, and reflect on the progress we've made while confronting the work that still lies ahead. SAFM, leading the conversations that move us. The National Pulse with Ashraf Garda on SAFM. You're listening to the National Pulse, Weekdays, 3 to 6 p.m.
So I can tell you now, my guest today, and I'm looking at him, he looks much younger than he says he is. That's the good news. But more importantly, someone who understands fashion, having been in the fashion space before, I always appreciate good shirts and good suits. And I'm looking at your shirt, and he's got a black shirt with braiding, the tabs from top to bottom and the collar. The type of shirt, I honestly, think of a Madiba's type of shirt, okay? But the type of shirt, if I had to buy a shirt for myself when I give talks, that's the type of shirt I'm looking for. So that's the one thing. Great to have you with us, Pandelani Nefolo Vodwe. We're going to have chat with us, I said, fireside or coffee in a way for the next 40 minutes or so. So thank you for joining us here in the studio.
Thank you very much for just inviting me to be in your studio again. It's a long time.
I know.
I've been in the studio. So when I received the invitation, I said that's better for me to go and look at how the studio look like now.
Well, there you are. Thank you. Well, I'm glad Temba reached out to you, my producer. But let me ask you this. I mean, we speak at a time where I suppose one of South Africa's members that form part of the political elite in the struggle, Mosiwa Lakota, the terror, has passed on. And I would take it your paths crossed, right?
No, in fact, he was my best friend, and from student time, right across to the SASO, the South African Student Organization, and I was his president. He was the national organizer, and we played a part in organizing what is called the Viva Frelimo Rally when Mozambique became independent. So we were arrested together, went through interrogation, and up until we were charged for wanting to overthrow the then regime, and also for organizing the Viva Frelimo Rally.
Oh, I see.
We were convicted together in the same trucks, transported to Robben Island. We stayed there, and we were released the same year from Robben Island.
Oh,
so he's
he's
a very close person to me. Even now, when he was belonging to other movements other than the one I belonged to, we remained friends right through.
Okay, and then how then did you, I mean, just the last thing on that, the fact that you were similar, but then at some stages ideologically apart, right? How did you marry the two, considering you were friends, but you were different?
I'm not sure when people say we were ideologically apart, whether they understand exactly what happened. The differences were not really on ideologies per se, except that we differ in terms of the Freedom Charter and the Azanian People's Manifesto. Those are not the documents that are similar. But generally speaking, when a person is in the struggle, in all respect, you'll find that 99% of what the person stands for is similar to what you also stands for.
That's a good
point.
So
there isn't something you can say there was a fundamental differences, except that the difference comes because people belong to formations.
And what you had in common,
you
all want to change, right?
Yeah,
you want to change.
Yes, they belong to formations.
Okay.
And when you belong to formations come with their ethos and their traditions, and that's when you start differing on practice and other things.
Okay. So, I mean, people in the struggle would have one, I mean, of all the things they have in common is dismantle apartheid, kill off apartheid, and establish in its place a system that is just, that is socially just for South Africans, right? So you were in the struggle. All these years later now, compare the dream then versus the reality.
But just before we go into comparing the dreams and reality, there is a fundamental point of departure. Okay. When you are in the struggle with other people. Now, the fundamental point of departure, particularly of Azapo, where I come from, the Black Consciousness Movement, was that we were not in the struggle merely to dismantle apartheid, because apartheid was the manifestation of a system, right? So many people tended to fight the manifestation, whilst we then said no. The manifestation is just a point of departure. The real issue to be dismantled is capitalism and its foundation and what we call the system, which means holistically everything that is a basis of what brought about apartheid and what brought about inequality, what brought about racism, all those things are fundamentally there at the basis of it.
What's so bad? What was so bad about capitalism then? What's so bad about capitalism?
It is the same.
Yeah. What's the evil about it?
The only part where it ameliorates itself from time to time, because it has also to adapt to circumstances. When circumstances are good, then the circumstances were good for capitalism to oppress the blackies and to make them slaves, to make them work for it. And it survived nicely on top of separation. Whites on the one side, blackies on the one, but blackies were used as a labor for its sustenance. But later, the capitalist fellows realized that no, this is not sustainable. We are going to be in trouble because the majority of the people here are definitely going to overthrow us in terms of the management of the system.
All right, so now to go back to that point, what is your vision of the struggle at that time, and what are your thoughts now?
Now, our vision at that time, and mine too, was that we were going to completely dismantle what we refer to in our writings, the system. That's what the fundamental part was, to dismantle the system and put in its place a new egalitarian society. Now, that egalitarian society is not there at all at the moment, because the system itself just ameliorated itself. It brought in this or that, freedom for that, freedom for that. You can go to court if you've got a problem. So it does that so that it can continue systematically to do what it always want to do.
So the last thing on that, right, just in terms of where we are as a country right now, what's the one thing we must do now that we're not doing? There's 100 things, but what's like the one fundamental thing we need to be doing now?
The fundamental thing which many people do not realize, right, is that the constitutional architecture that we decided to put in place, right, after having got the apartheid system sort of by the wayside, we then put a constitutional, I call it a constitutional architecture. Now, that framework, it's a framework, which makes us to revolve around it. So we have put a constitutional architecture which does not bring the desired results. Absolutely. Okay. Because it was never meant to bring about those desired results. So, as you are asking me a question, what we should do is to dismantle the very constitutional architecture that everybody says is the best in the world. Because these architectures can be best to anybody outside your country. It has to be best to you. You mustn't worry about what people say. It is not bad. For as long as you have brought a constitutional architecture that makes you free and you feel, or this is where I belong, this is my country. We have not reached that stage.
How do we dismantle it then?
Dismantling now we have got an easier way of dismantling it. In the past, in the past, when I was still in the struggle for freedom, we wanted to dismantle it through armed revolution. In fact, we did form organizations and
now you have to convince them in the ballot box, right?
Yes,
and change the
because
constitution.
Now we have put in something which says you cannot be arrested for all the other things that you want to do. So what we then must agree, how do we then change the status quo that was put into place in 1994?
Okay,
so now we must use what we can call the masses. The vote of the masses must determine our destiny.
So it's interesting. Let me just remind you, if you just tuned in, never tune in late, firstly, right? But if you have, you're forgiven. But my guest is Pandelani Nefolo Vodwe, who's as you can hear, is one of the co-founders of the Black Consciousness Movement, and then later on then became the former, deputy president of AZAPO. And of course, all of that is what those threads come through in the conversation that we're having right now. Now, interesting, if we're saying that this constitution that we have now, you need to convince others to support your vote, you dismantle it. So you need to get to the 2/3 majority and all that type of thing.
Yep.
But I'm saying that intentionally because in the period of the 1990s, there was another bit of convincing. If the status quo is the constitution now, the status quo then was apartheid South Africa, right? And then there was a negotiation, and there was Codessa. And you have views on Codessa.
In fact, at the time when Codessa occurred, I was the president of AZAP. I later became the deputy president. But that period of negotiation, I was in charge of an organization called AZAP. And if you have heard of our views, those views came from my leadership. So that period from 1992 up until its culmination in Codessa, I was part of the leadership and I was in charge as an AZAPO president. So our view was very fundamental. And we went to campaign for it, was that, yes, let's agree to negotiate, because every dispute of a political nature or of an armed struggle, at the end of it, there must be some kind of negotiation. So we agreed also to go for negotiation. But we then said to ourselves, we can't negotiate from a position of weakness. And in order to maximize the negotiation so that we can come out of it having at least managed to push the frontiers so that we can be able to free black people, we need to go there as a united front of the PAC, Pan-Africanist Congress, the ANC, and ourselves. So I then led delegations to negotiate with the ANC about that vision, and negotiate with the PAC about that vision, and an agreement was reached. And
okay.
Yes, well,
and yet you call it the Codessa.
Yes,
the Codessa betrayal. I want to find out why. I'll give you a minute to think about it right after this.
The pain of losing a loved one is never easy. At Clientele, we understand that burying loved ones with dignity truly matters. Our funeral plans pay out cash within just 24 hours, and you receive 200 Rand airtime when you claim. Plus, we cover up to 13 people on one plan. SMS SAFM to 48031. That's 48031. Clientele Life is an authorized FSP and licensed life insurer. T's and C's online. Standard rates apply.
Yo, it's Sashili Kelly. Join us for stories that will make you live in every beat. The Pulse of SA. Starting 23 February 2026. Monday to Friday at 7 p.m. on SABC2.
This Human Rights Month, we commemorate a significant milestone, the Bill of Rights at 30, making human dignity real. For 3 decades, South Africa's constitution has been a beacon of equality, freedom and justice for all. Yet dignity is not just written in our constitution, it must be lived, protected, and upheld every single day. Join SAFM as we unpack the issues that matter, elevate voices driving change, and reflect on the progress we've made while confronting the work that still lies ahead. SAFM, leading the conversations that move us. Ashraf Garda on the National Pulse.
Right, so I heard your point about everything coming together. We're chatting to Pandelani Nefolo Vodwe, former, president as well as then deputy president of AZAPO, but also inspired by the Black Consciousness movement. So before the break, I said there's this thing called the Codessa betrayal.
Yep.
Betrayal of who to who?
It's because the betrayal came this way, as I was explaining to you. We wanted a united front, patriotic front, so that, because we knew very well that the white establishment and its power base had even recruited the Bantustan leaders, and it had formed a formidable force to come and negotiate. At that stage, they had even armed the Inkatha Freedom Party, those who know the history of our country, so that group would then work together with the oppressors in order to make a...
But let me push you. Did you feel personally? Do you feel personally betrayed, or do you feel the movement was betrayed?
No. It is a betrayal of black people. It has got nothing to do with just the movement.
Okay, who betrayed black people?
The people who then went and agreed on this constitutional architecture I told you.
So that would be obviously the obvious party would be the ANC, right?
It is the ANC and everybody who was at Codessa, who came from relatively the point of being in the liberation struggle. There is no way they can deny that. In fact, now, some of them are now saying so publicly that, hey, we really lost it. And if you can check the interview with Winnie Madikizela Mandela, where she says we lost it, right? And you can Google it, you'll find her telling you. But she remained a member of the ANC.
What could they have done differently, keeping in mind your point that at some stage, in any battle, you had to negotiate. And negotiating does mean giving off something that you've got and accepting something that they have, even if you don't always agree. And the story was South Africa, I'm talking of the freedom fighters, like the AZAPO and the ANC, they had power, but they didn't have absolute power, and they had to be up against an apartheid system that had entrenched power. So there had to be some compromises.
No problem with some compromise.
That's fine.
You can compromise. Don't compromise those issues that free people.
So, example.
Yeah,
so what did we compromise
when
on
you
that
do a compromise, don't compromise. Say that the freedom you wanted and the oppression still remains. So the compromise was here, right? All of us, you can go to the history of the ANC, history of the PAC, our history, and the history of black people generally, starting with the kings and chiefs, right? The basis of the struggle was the question of the land. And the land had to belong to everybody, not now where land belongs to those who actually had it backdoor, let me put it that way. So the land should be a property of everybody. That is why at the moment, Ashraf, you are having a problem of what is referred to as informal settlement. People want a place to stay, whether you like it or not, and it will not end until land is available to everyone else. And so I'm just giving you just a little bit of what I feel is. So the land was a question which was very fundamental. Secondly, and if you had listened now of late, you'll find that what I'm going to say ties up very well. The question of the economy. Mm-hmm. You can't leave the economy to be enjoyed by a minority in your country. Right? You can't. That is just a non-starter.
What should we have
so
done
it is a compromise which was made also, that the economy must remain with those that we were saying.
So, okay, economy, what should have been done then?
What should have been done was just to make sure that everybody can participate in the economy of the country. So your constitutional architecture, right, fundamentally should have addressed that. So that when we move into a new society, we no longer have to quarrel now with, you've got your BEEE, we don't like it. We are now still quarreling on a matter which should have been resolved at Codessa.
And when there's quarreling and there's inequality and there's injustice, then the roots of civil strife is enhanced.
Absolutely.
Right? So linked to that, you have thoughts on the security of our state just as a country. What's your thoughts?
At the moment, if you can check my writing on Facebook, here's my point of departure, is that if the national army of our country is depleted, right? The equipment, everything that is there, it has been reported several times. Even the chief of the army, right, General Mapan, has complained about it, to say at the state at which our army is, we cannot defend the territorial integrity. So when you live in a country, it doesn't matter, even when there are no wars, you must be sure that if someone likes what you have, and all of a sudden just decide, I'm coming to grab it, like Trump went to grab oil in Venezuela, you will be able to say, you can't grab it. So we are not in a way where we can do that. Secondly, if we had listened to the Admiral of the Navy, right, he has complained that we can't even guard our waters. People are stealing our fishes, which is our resources. So we can't even do that because we are in trouble. We don't have that. Then Mkwanazi comes, right? Lieutenant General Mkwanazi comes. He says, even your internal machinery of the police, your intelligence, even that you don't have. It has been infiltrated. So that is why I'm saying to you, right, we will not be able to defend our territorial integrity, which means
with that in mind,
our borders and everything. We won't be able to do that.
So with that in mind, I mean, whether it's the borders or whether it's even internal.
Yeah.
I mean, my example is like getting 11 footballers on the pitch without shin pads.
Yeah.
If they don't play with shin pads, they're going to be injured and they can't do their job.
Yeah.
So what do you then make? We've got the Madlanga Commission, we've got the Adoc, and the issues about the borders. Where do you see all that ending?
Now, the problem lies here. I see it ending somewhere, nowhere. Because the problem lies here is that the very people who are appearing at Madlanga, most of them have been members of the ruling party. That's I've never seen someone who appears there who says I have never been a member of the ruling party. Secondly, the constitutional architecture which I'm complaining about, it says that once you have done all that investigation, you must get all your reports to the president of the country, who is, if you know, who is also in the mud. So how do you expect such a person to take a decision to say, I'm coming for Ashraf Dada, who is a member of my party, when also he has a problem of his own? So we are going to end nowhere as far as I'm concerned.
We are going to end nowhere. I tell you what, this is not the end of the show, because we will continue this discussion in a few minutes' time. We've got sport, we've got the markets to come. But first things first, here's the news headlines with Greg House.
Quick look at the headlines. 4 people are missing after a bakkie was swept away by floodwaters when the driver tried to cross a low-lying bridge in Msinga in KZN. The DA's welcomed a High Court ruling that declared a section of the Value Added Tax Act unconstitutional And Amnesty International says women and girls in Ethiopia's western region have faced sexual assault, slavery and forced displacement during the region's ongoing armed conflict. There's a full update at 6 o'clock.
SAFM, guiding you through the rush hour traffic.
Good afternoon. Starting off in Gauteng on the R511 northbound in Hartbeespoort, there's heavy traffic towards Beethoven Road. The N12 R24 westbound in Bedfordview is where a crash is reported at Giluli's interchange, and on Witkoppen Road westbound in Johannesburg North, flooding towards Market Street, so please approach with caution. In KZN on Bel Air Road, there's a crash at Rick Turner Road. Umgeni Road westbound is slow moving through Springfield Park, and the N2 northbound queuing through the construction area north of Spaghetti Junction. In Cape Town, the N2 outbound in Somerset West has a crash after Victoria Street Junction. Robert Sobukwe Road in Moderdam queuing at 35th Avenue Stellenbosch Arterial Road Junction, and there's heavy traffic in the central Stellenbosch area. With your traffic update, I'm Irma G.
This is SAFM Sports with Tuming Khapele.
Right, so it's the weekend to me, and what do you have now?
We're looking forward to the Nedbank Cup quarter-final, which takes place this weekend with 4 matches deciding the semi-finalists. Tomorrow, AmaZulu hosts Keswick Stars at 3 p.m. before Skukuni United take on Milford FC at 6 p.m. Sunday's fixtures sees 2019 champions TS Galaxy facing Jackson Spears at 3, while Golden Arrows meet Durban City. 3 clubs in Keswick Stars, Milford FC and Jackson Spears are appearing in the quarterfinals for the first time in the Nedbank Cup. And Skukune United coach Eric Tinkler says that winning the Nedbank Cup has become an even bigger priority for the club as they chase qualification for next season's CAF Interclub competitions.
Definitely. Definitely. I know my chairman will be extremely happy, because that is the target that we've set ourselves for the season. We want to finish in the top 3. Why do we want to finish in the top 3? We want to be involved in CAF. Now, if we can get an opportunity to actually get there through the Nedbank, that would be highly beneficial.
Meanwhile, Orlando Pirates coach Abdeslam Wadu has praised the close title race between his team and Mamelodi Sundowns, saying that it's good for South African football. Pirates and Sundowns are currently level at the top of the league standings. However, Pirates are in first place because they have a better goal difference. The fight continues next week as the Brazilians are away to Orbit College on Tuesday and the Buccaneers host Richards Bay on Wednesday. And Wadu says a close competition between teams makes the league more exciting. He believes that when one team dominates for many seasons, it can make the Premier Soccer League less interesting. In rugby, Springbok coach Rassie Rasmus says that he is satisfied with what was achieved during the team's first alignment camp of the year, which ended yesterday. Erasmus says that he was especially pleased with the energy and enthusiasm shown by the 11 uncapped players who attended their first Springbok alignment camp. And he says even though not all of them will get a chance to play this season, the experience remains important for their development. In cricket, India will face New Zealand in the T20 World Cup final on Sunday. India are aiming to become the first team to successfully defend the T20 World Cup title, while New Zealand are chasing their first major global white ball trophy. More than 100,000 fans are expected at the stadium, with most supporting the home side. Sanju Samson has impressed with the bat at the top order for India, while Jasprit Bumrah has led the bowling attack well for New Zealand. Finn Allen and Tim Surford have been in excellent form and will be key for the Black Caps, with both teams playing well. An exciting and closely contested final is definitely expected. In terms of tennis, 7-time Grand Slam champion Venus Williams was knocked out of the Indian Wells, losing in 3 sets to French qualifier Diane Perry. The 45-year-old, playing on wild card, fought back to level the match, but Perry surged through and claimed a 6-3 6-7 and 6-1 win. Finally, in motorsport, home favorite Oscar Piastri thrilled fans after setting the fastest time in second practice for the Australian Grand Prix. The McLaren driver clocked a best lap of 1 minute 19.729 seconds around Albert Park circuit, finishing just over 2/10 of a second ahead of Kimi Antonelli and George Russell of Mercedes. Now, the Ferrari pair of Lewis Hamilton and Charles Leclerc were 4th and 5th fastest during the session. Ashraf, before I leave, I'm gonna predict India to win the T20 World Cup. They're at home, so everyone is just expecting India to beat New Zealand.
And so are you, right? Not just everybody.
Yeah.
Most obvious prediction ever, but who knows? Obvious doesn't always work in cricket, does it? Our South Africa, 7 in a row, we lose the 8th one. So there we are. Okay, thanks for Monday night. I'll message you. We'll see what happens.
Alrighty.
Thank you.
Ke nna tumeng kgapele, Modimo ke yo.
It's all about meat-free meals on Color Your Plate this Sunday evening at 7. 4 contestants compete to prove that a midweek family meal can be hearty, nutritious, and full of flavor, even without the meat. With a steering from a previous season watching closely as guest judge, the stakes are high. Who will earn their approval and cook alongside them in the next round? Find out on Color Your Plate Sundays at 7 p.m. Repeat Saturdays at 4:30, only on SABC2.
Get Spar super savings at every store, in every aisle, every day. Like 500-gram Roma Original Fat Spread Brick for $26.99, plus 50 megs free data on Spar Mobile, or 750-gram Cross and Blackwell Tangy Mayonnaise only for $37.99, plus 100 megs free data on Spar Mobile. Now that's super savings. Price is valid from the 23rd of February till 8 March, while stocks last, only at Spar. T's and C's apply.
Osuthu are on a mission for a place in the semi-finals, while the believers are confident they'll secure their ticket to the last 4. In another sizzling encounter, Babinanuku are ready to sing their song of victory, but the Stallions are courageous to cause a major upset. This is the doubleheader of the Nedbank Cup quarterfinals, where pride meets ambition. Catch Amazulu FC versus Casrick Stars this Saturday, 7 March at 2:30 p.m. live on SABC1. Then, Skuguna United face Milford FC at 5:30 p.m. Both matches are available on SABC Plus. Also, tune in to SABC radio stations at 3 p.m. and 6 p.m. Proudly brought to you by SABC Sport.
For the love of the game.
Economic news on SAFM. Facts and figures you can count on.
Right, we'll be back with the Fireside Chat with Pandilani Nefolo Vodwe shortly. But for now, Jimmy Moyaha with the market update, the last for the week.
Good afternoon, to the listeners. I'm glad it's the last update of the week because it is a sea of red on the markets. Nothing seems to be going right if we look at how stocks have been performing. US today, we've got those non-farms numbers. The US was expected to create 52,000 jobs over this cycle. They instead shed 92,000 jobs, and unemployment got 4%. That wasn't the worst of the data that we saw out today. Asian markets were largely in the red, with the exception of actually, Asian markets were in the green with the exception of the ASX and City. That was in the red. European markets were all in the red. US markets were in the red. South African markets also in the red. Financial stocks shedding 4.4% on the day's trade. Industrials down 2.1%. Resources down 2.6%. But all share down 2.9, almost 3%. The top 40 down 3%. If we look at the commodity markets, the oil price is above or tapped above $90 a barrel for the first time since April 2024. So for the first time Trump has returned to office, the oil price is back above $90 a barrel. I don't think that situation is going to get any better anytime soon. If we look at the rand, 16.63 against the British pound, 16.63 against the US dollar. 1 British pound is 22.23, 1 euro 19 rand and 27 cents. 1 Bitcoin, 68,850 odd dollars a coin, or 1.187 million rand with that weaker rand. The gold price still 5,160 odd dollars a fine ounce. Going into next week, we're going to hope that the ongoing tensions in the Middle East do start to come under control, or else markets are likely to continue this sell-off and erratic behavior that we've been seeing since those tensions escalated. Just for context, for those that are wondering, we do still have more than 1,000 days left of the Trump administration, and so that is potentially what has markets concerned, as we are still a long way away from potentially being or seeing the end of volatility. We're going to the weekend with disappointing market news, a weaker rand, a sell-off on the equities front, but we'll come back next week and see how the market unfolds for the middle of, and as we wrap up the first quarter of 2026. For now, Ashraf, back to you.
So you have a great weekend. We will connect Monday, of course, and let's see what the markets do. We've got a whole weekend of geopolitical issues in the world to take care of. Thanks for that, Jimmy.
Ashraf Garda on the National Pulse.
Well, I'll go back to talking now to Pandelani Nefolo Vodwer, our guest on the Fireside Chat. But I'll tell you what, we've got like 3 WhatsApp comments. Let me play them. If we can play them in one go, they all concern you. So let's play them now. Yeah.
Hi, Ashraf. Good afternoon. Yeah, Ashraf, your guest. Give him a hand of applause. Where was he all these years? Coming out, speaking out the truth. And you know what is so sad? That I believe that more than half of this executive of our country, including Mr. Ramaphosa, maybe not now because he is in the USA, but most of them are listening to this show and to this gentleman speaking. But nobody is coming forth. Seems me they rather protect what's wrong, because our country is shameful going down. But we need people like your guest this afternoon to bring some rights to this country. It's on Cape Town.
Good afternoon, Ashraf. I'm Bafana Kumalo in Memel. I would like to ask your guest today, what made the Azapo not to work together with the PAC? Is it still difficult for them to come together and form one party that can contest elections effectively?
Evening, Ashraf. What Mr. Nlovod is saying, it's nothing but the truth. But the unfortunate part is that no new government or new political party will change this, because they will be presiding over the same constitution that continues to give us problems in this country, especially majority of us, the brown-skinned people. So what we need is the restart button. It's a revolution, to be precise, whether peaceful one in terms of the shutting down of the country, or whether violent one, because revolution can come in different forms. You see, because the very same constitution is used by those who have become elite. They protect themselves from outside forces by selling the country and selling the resources of the country, yet indirectly suppressing us to remain poor, to remain helpless, so that they forever stay in power. Thank you.
Right, lots of things to reflect on. You may want to comment on that, yeah?
No, I suppose they have said the truth. The only thing that I wanted to add on what they have said is that once you have what I've been referring to right through, a system, even those who do not support that very system, for as long as that system has got facilities that makes everybody believe that it can be saved by voting, by doing that, it can sustain itself for a long, long time. And so we have to find other mechanism to make it, this one we live in, to make it not to sustain
and
itself.
what is the mechanism? You've got
the
some
mechanism
ideas?
is what one of them has actually hinted on, that those who still understand what we stood for and who still understand that freedom we wanted has not arrived, those who understand that we were cheated on the way, they must unite in order to bring about what I may call fundamental change in our country. It can't be otherwise. You saw it, I think it's last year, when there was a concerted effort to get what is called the national dialogue.
Yeah.
By the...
Good idea, isn't it?
Very, very important idea, because that's where you asked me a question earlier, to say how will we be able to off-ramp, right? So there were those foundations which were formed under the umbrella of very important freedom fighters.
Mm-hmm.
And they came together and realized that the off-ramp here is to call everybody, right? And so that people must participate in drawing a new constitutional architecture.
You think that's
that's my word.
This
is me now who are saying to draw a new constitutional architecture. You must remember, when Codessa took place, none of the organizations of the people were involved. It was those who usurped the stage and say, we are liberation movement, so you must listen to us, we are going to liberate you, you shut up. Whilst at that stage, there were so many organizations of the people. Now, this forum of national dialogue, it's saying, let's change the tactic.
So in effect, what you're saying is that if we had a negotiated settlement earlier with Codessa, which you felt was a betrayal, that this one has the potential to have a people's negotiated settlement.
Yes, because if you check what Azapo said during that stage, we wanted what is called the Constituent Assembly, which would not only have involved the liberation movement, it would have involved the churches, all the structures that were there at that time, the Black Lawyers Association, I can name as many, because Constituent Assembly, which we wanted, was to say, you can't free people by telling them I'm a liberator, therefore whatever I bring about will have liberated you. Now we are in danger here because we trusted that they would have crafted something that liberates us. And only after 30 years, we realized that no, there was nothing there. They were just protecting themselves. And that is why they went on to become partners. And Azapo decided that we cannot be partners to something we can see. It is
so what do you make of Ramaphosa's leadership right now?
Well, as far as I'm concerned, it's many people have said so. It's a person who can take decisions.
We can't. What about Trump? Trump can take decisions.
No, Trump also can't take decisions because Trump at the moment, he has been rented by Israel. They have rented. They have really rented. If you go and understand renting, it means that I come to you, Ashraf, and say, please, I want you to come and fight my wars here, and bring your arsenal and fight my wars. That's what is happening now. That fellow called.
What about Trump in Venezuela, Trump Mexico, Trump internal politics?
That is a different matter. Even in the Middle East, it's a similar matter. Trump is looking at what we used to call the balance of power. Now, at the moment, he's looking at the balance of power on energy and what is called precious minerals. Because these precious minerals at the moment are the ones that can make you manufacture ballistic missiles.
Okay, just pause on the precious metals. We'll find out what else is precious in the world today that all the big countries in the world want to have a grab of. More on that right after this.
Sorry I'm late, Sevi. Had to fetch my lucky putter.
No worries, let's go. We're teeing off in an hour.
Great. We're taking your car.
Can't. It's already taken.
What do you mean taken? It was right here when I left a few minutes ago.
I sold it to WeBuy Cars and made a whole lot of green.
Birdie told me that's the best way to sell your car.
Not only the best way, it's the fair way. Kom ons vat die pad.
Don't be doof, be savvy. We buy cars geared for a fast sale, geared for you.
The Bavarians are loving life at the summit and are highly spirited to keep their grip on the top spot. Standing in their way are the Foles, eager to climb the table and spoil the party.
This is the Bundesliga. Football as it's meant to be.
Do not miss Bayern München versus Borussia Mönchengladbach on Friday, 6 March at 9:30 p.m. Live on SABC Plus and SABC Sport on DTT Channel 4. Proudly brought to you by SABC Sport.
For the love of the game.
Wherever you are in the world, SAFM 104 to 107 is accessible. We're also streaming live on Facebook, X, and YouTube at SAfmRadio. We acknowledge and appreciate everyone tuning in and watching our streams. Stay with SAFM 104 to 107 as we bring you Commission Live, breaking stories, and thought-provoking lectures. SAFM, leading the conversations that move us. Ashraf Garda on the National Pulse.
Right, we've got about 8 minutes to wrap up this fireside chat. We probably needed 3 hours with Pandelani Nefolopodwe. I mean, just so much, and I just have a sense you want to talk, right? Co-founder of the Black Consciousness Movement, former president and deputy as well of AZAPO. Right, we were touching on minerals and energy. I mean, one thing is of oil and diamonds and that, right? Explain that in terms of the context of world politics.
Now, the world politics runs at what is called the balance of power. Right? Balance of power in the sense that you need to be able to have resources and have the wherewithal in case other people want to disturb your territorial integrity. Now, you must remember, America has always been, after the Second World War, America had always been on top. But then, all of a sudden, you find China coming in. It has got its own tactics of amassing power and resources that matter. The resources that matter now are those resources that can make the ballistic missiles to defend yourself. And also the oil industry, right? That is what is. That's why Trump went on in order to get the Middle East countries, right? All those Middle East peace deal, so that they become part of his deal, and he made them to sign some agreement to say them together with Israel and America, they will stand together in the Middle East.
Okay.
But he was looking at the oil that they possess.
All right.
That in case there is danger, he will be able to get the oil.
Okay, let's move on. We've got 5 minutes. The impact of colonialism on our education system.
Now, the impact of our colonialism comes from Verwoerd. Remember, during the time of Verwoerd, there was a saying which says, don't give a black child education, right? And we were even precluded from doing mathematics and science. Now, that whole business of, it was the suppression of the intellectual capacity. So once you don't have intellectual capacity anywhere else in the world, you are in trouble, because then you can't be innovative. You can't produce products that are independent of anyone else in the world.
So would you say the vast majority of South Africans then lack the intellectual capacity to lead? And that's a legacy of many years.
Absolutely. That dwarfing.
How can we sort that out?
That must be, our education system must change That is why we can't have an education system where when a child passes with 30%, we are happy. Because how do you become an innovative character when you are not given the wherewithal to be able to compete? So our education system on its own is a fundamental problem which must be changed. But you can only change it if you've got people in government who understand that apartheid has destroyed.
GNU is in government. What do you think of
well, GNU, if I were to tell you the honest fact, it's a platform for arguments and debates and contradictions.
But it is the result of the ANC not getting 50%.
But on its own, it can't take me to freedom. Because every day, if I wanted to bring about NHI, right? I must wait for another 5 years going to court so that people must get free medical care.
On
so that is how GNU is.
Right.
It's really a useless body to...
What's your thoughts on the state of our healthcare?
The state of our healthcare is also very bad. And we have very, very good scientists of late. If you were to check. I mean, we have just come with a magic for HIV. Right? It comes from us. But simply because we don't have the capacity, the infrastructure to get everybody must enjoy medical care free in this country.
How do we grow the economy then? I mean, if we don't have the money to do that?
The economy must grow by making sure that every citizen, right, is a person who can be able to create a job. You see, our education system, which many of us went through, is that it taught you to be a worker. Even now, if you see most of the toys are that give us work. It taught us to receive. Now that is completely that's completely out of order. Because you can't receive and not be able to create.
Okay, we got 40 seconds. Give me one person in South Africa now, not your era, a young South African that is just good enough to lead, that so inspires you.
I haven't found one.
Not one?
No, I haven't found one.
Sure.
Absolutely, I haven't found one. In fact, that is something that the younger generation must look at. I haven't found one. Because they are not, they are at the stage of that receive. They are at the stage where they don't see themselves.
So you don't see one
I haven't found one.
Give me one book you recommend we must read.
Many I can recommend.
Just one? Quick one?
Now, those who are, you must read The Pedagogy of the Oppressed.
The Pedagogy of the Oppressed.
Right?
Okay. Just the last thing to you, how would you like to be remembered?
No, just another. Now, if you want to remember, I'm just another soldier in the army for freedom.
That's the most understated response I've ever heard. I'm just another soldier in the army.
Yeah, I'm just another
for Mahala.
Yeah,
there we are.
I'm just another soldier.
Pandalani, the fall of Wardway. Your time's up, unfortunately, but we need to have another chat sometime soon on some of the biggest issues you've raised on its own. Thank you for joining us here on the Fireside Chat. Really good.
Thank you.
There we are. Podcast coming up ASAP. I'm sure of that. Okay. Thank you. Let's get the news. Here's Greg Host at 6 o'clock.
Thank you again, Ashraf. 4 people missing after a vehicle swept away in KZN.
Hard work